If I don't do nothing else, I'm gonna talk to the law. Let's talk about it. But before I start, for those who don't know me, I'm a Texas trial attorney going on my 5th year in the game. Y'all see the law license on the wall signed by the 9 justices of the Supreme Court. And I was minding my business. And I was drinking my water. And somebody said Glanville gonna release the tape today. I said, oh man, let's go. Let's go. Release the tape. Release the transcript. Where is the transcript? That's what I want to know. Anybody want to know that? We want to know. We want to know where's the transcript, Glanville? Somebody get him out the back. He back there hiding, y'all. He hiding back there. If you're doing so much right, why are you hiding? I guess he ain't doing right. So you can't be right when wrong got you. Hello, good morning, Miss Deborah C. Erica said he gonna waste time. He gonna do that now. She said he had these people waiting since 9:30. Oh, hey, Tia. And thank you so much for sending me that that document, the writ of mandamus that was filed in the trial court by Weinstein. He should have did that at first. And the only reason I didn't go over it because it's the same stuff, just a different title. Shout out to Joe. Good morning. I'm gonna say Miss Ine. I can't remember, was it Ine or Ine? You gotta help me. I'm gonna get it down. I know you already told me you gave me the pronunciation. Hello, Mr. Don from Cali. Shout out to Cali. I know it got to be early over there. Let's go, Joe. Shout out to Joe. Good morning. Now I know I'm finna get. Hold on. What does it say, Miss Nita? Don't even give me the line today. Oh, Nita like Anita. Okay. Nita like Anita. All right. Not Anita Baker. Come on here. Y'all, what I missed? So the judge hasn't been here at all today? Hold on. Let me see something. So today, supposedly, the lawyers should get the transcripts, and the transcripts are needed so we can know what was going on in the secret meeting. We want to know what y'all was talking about. And the judge, he's stalling. Who in Georgia can go out there and get him? Who in Georgia can go get the judge and tell him, come on, step into the light. Don't hide now. You was what they call big and bad when you was issuing these orders of contempt. So we got to get them back out here. Get them back out here. Okay, let me see what else we got. Ane. Oh my God. I have to give it like that because people always struggle with it. Come on here. Hello. Good morning, Mr. Nail. He told them he had an hour more redaction. They're supposed to start. Golly, Judge, an hour more. How long was the secret meeting? He's talking about an hour. He's trying to redact the whole meeting. So supposedly the judge sent out an email last night. He wanted to have this hearing today behind closed doors. But I guess overnight he had a change of heart. He said, I'm going to release it to the public. Well, the public is here. She said, I think he came and said there were some video issues and working out something with the order. Now, what he's trying to do is make an order where the lawyers can't talk about certain things. I bet you that's what he's going to try to do. He's going to try to tie their hands. Whatever I tell y'all, y'all can only talk about what I tell y'all can talk about. Somebody said Miss Sylvia said Steele and Bumpus attorneys are in the courtroom. And that's another thing, because we know that the contempt hearing or the show cause hearing is supposed to happen on Wednesday. And those lawyers also want the transcript. Kayla's lawyers want the transcript, because if you're saying my client's in contempt, my client did something wrong, then I need to see the transcript from that day. So it would make sense why her lawyers would be there today. Like, Judge, give me the transcript. Thank you, Cheeky. Right on time, apparently. Came right in and said Zoom messed up and said he'd be back an hour. He went in there and kicked the cord. Oh, we got action. Hold up. I think we got action. Wait. Do we got action? Thank you, Chosen. Thank you, T. He said, "Share Glanville ain't studying nothing, bro. He ain't studying them." China, if he shares things with the lawyers, can they share with their clients? It just depends if he gives them an instruction not to, because he made it clear that he didn't even want the clients in the back today. He only wanted the lawyers back there. Because I guess in theory he can punish the lawyers with some type of contempt if they leak the information, but he can't really punish the defendants. I mean, what are you gonna do? Lock them up? They already been in jail for 2 years. They calling them shit. I told you. This is not the state of Georgia versus Young Thug. This Young Thug versus Old Thug.
Oh, where's Mr. Weinstein?
The Thug listening to music.
Okay, all right, okay.
Look at him. Thug got some music in his ear. I heard about Lil Tay. I haven't heard about the daughter.
All right, thank you, Deputy Ham.
No, the judge just got here. We haven't discussed anything. So you right
Anybody
on.
else joined us since we last recessed? Other than Mr. Uhalski, who I haven't seen so long, he's grown a mustache. Anybody else? Okay, all right. All right, folks. As you all are made aware of, last week the court was going to do an in-camera review of the ex parte proceedings on June the 10th of 2024. In considering whether or not to have an in-camera discussion or review of the records, this court has decided to release the entirety of the transcript of those proceedings
Just go.
as courts won. And I'm going to take judicial notice of the following timeline. On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution pursuant to 24-5-507A, and that'll be marked as courts 2. So the transcript will be court 1. His immunity agreement, Mr. Copeland's, will be court 2. Mr. Copeland, who was represented by Mr. Jonathan Melnick and advised of his rights and obligations, during the proceedings on Friday, June the 7th, which will be marked as courts 3, the transcript of those proceedings, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt, and that will be courts 4, Mr. Copeland's order of contempt. Mr. Melnick informed the court that he was not going to be in attendance of any further proceedings, as he would be on leave effective 10 June of 2024. The court informed Mr. Melnick that his leave, or had discussions with him that his leave was not proper and that he needed to be in attendance on Monday, June the 10th of 2024 with Mr. Copeland. Mr. Melnick relayed that attorney Caleb Bumpus would be representing Mr. Copeland. On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with the court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken down by Ms. Christina Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Ms. Kayla Bumpus, attorney or ADA Ms. Adrian Love. Also present were the DA's investigators, Mr. Long and Mr. Hamilton. The ex parte hearing stood in recess from 9:34 to 10:03 a.m. to await Mr. Copeland's arrival. The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also present were attorney Bumpus, Ms. Hilton, the DA's investigators Long and Hamilton, the court and security personnel, deputies Houston, McPherson, Brown, Sergeant Brown, and Sergeant Hall. The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with attorney Bumpus from 10:17 a.m. to 11:28 a.m. The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m. The court arrived in courtroom 1C at 11:49. The transcript of those proceedings, starting as of 11:49, or when the court presumed that held the proceedings on 10 June in courtroom 1C 2024, that will be marked as courts 5. The proceeding in 1C commenced on the record at 11:52 a.m. A lunch recess was had at 12:51 p.m. The parties returned from lunch, and Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m. In asking then Mr. Steele later that afternoon was held in contempt. However, he was allowed to continue representation of Mr. Williams. The court, in asking Mr. Steele questions of how he received the information that he proffered in open court, was only concerned about the integrity and security of the conversations that were had in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of what was told to him at that time. Jurors Jurors entered the courtroom to resume Mr. Copeland's testimony at 3:39 p.m. The jurors were excused and exited the courtroom at 5:56 p.m. Mr. Copeland was excused and exited the courtroom at 5:58 p.m. The court asked Mr. Steele again whether he received ex parte information, and that would be at 5:59 p.m. Mr. Steele's counsel, Ms. Ashley Merchant and Mr. Alex Susor entered the courtroom. Mr. Steele was held in criminal contempt. That order of that contempt will be marked as Court 6, and the proceedings concluded at 7:41 p.m. The court further takes judicial notice of the following statements proffered by Attorney Steele, Brian Steele, in open court upon information and belief stated to the court, which are still unknown. There are 6 assertions that Mr. Steele proffered in front of the court. Those are contained within the transcript of Courts 5, the proceedings that are held on the 10th of June of 2024 in courtroom 1C, which the court has already said will be part of this order. The first assertion and the transcript bears out exactly what Mr. Steele said, so the court is paraphrasing the 6 assertions that Mr. Steele made. They're more aptly and more eloquently put in the record. The first one involves his concern that supposedly in chambers, this honorable court reporter, court at times, district attorney or district attorneys before the DA's office, as well as investigators, sheriff, and deputies, Mr. Copeland and his counsel met together. None of the defense team, to his knowledge, were present. Second assertion he makes is that Mr. Copeland intended to plead the Fifth Amendment. Third assertion is that Mr. Copeland, as a party, was sworn, and Mr. Steele asserted that this particular conversation was, in fact, a critical stage, and that the defendants had the right to be present. The fifth group of assertions involved Mr. Copeland not going to testify. The fifth group of assertions involved what Ms. Attorney Hilton claimed or said to the witness, to include the court, involving allegations of coercion and witness intimidation, and that his counsel had the right to be present. And the sixth assertion that was made in open court was that Mr. Copeland admitted to killing Donovan Thomas. At some point after Mr. Steele was held in contempt by this court, in the afternoon of June the 10th, was brought to the court's attention, not at the court's request, by security personnel, that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp. The court in no way sought to investigate any facts of this involving this footage, and only considered it for the security and timeline of events that occurred on June the 10th of 2024. Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt. And as I said, mentioned it only for the purposes of considering the security and breach of information that occurred within the court's chambers, not for the whether or not that was truthful or not. Mr. Steele makes further made three assertions on the 10th of June of 2024. One, he asserted that this was, on behalf of Mr. Williams and similar situated individuals, that this was the court held an improper ex parte meeting. Secondly, that Mr. Copeland was a sworn witness, and this was a critical stage. And no, Mr. Copeland was a sworn witness. And third, that he argued that this was a critical stage and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any procedural, substantive, or tactical advantage as a result of the ex parte communication, and the judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives the parties an opportunity to respond. And in this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver, and all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will be e-filed, so everyone will have a chance to take a look at it and use it as they see fit. In this particular, and then the last part of 2.9 before the court goes on, if involves in pertinent part, if a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. And as I mentioned earlier, I'm going to release the entirety of the transcript to you all to use as you see fit, and before any other further examination of Mr. Copeland.
You're too late. You should have been released it.
I'll address the issue of the emergency nature of this particular hearing or this particular conference in front of the court. Is that this involves the state's concern as to what Mr. Copeland was in fact told by his counsel, Mr. Melnick, and his understanding of the immunity agreement pursuant to 24-5-507. And that the conversations that were had in the transcript will bear out that no tactical or other advantage or any testimony that was stated during that particular hearing would be anything other than the court and or the state communicating, along with Ms. Bumpus, his lawyer, who's there the entire time, his witness's understanding of his immunity agreement. In consideration of this emergency nature, the court has taken into account a couple of cases I'll cite for the record. One of them is United States versus Adams, and that's 785 F. 2nd 917, decided in March 31st of 1986. In pertinent part, presence of the accused. Although an ex parte conference to discuss threats against the witness is proper, district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. Presence of the accused. ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal was not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed. And in Adams, the appellants contend that the ex parte conference was improper and it violated their due process right to a fundamentally fair trial. We agree with appellants that ex parte conferences should occur, but rarely, especially in criminal cases. This does not mean, however, that such conferences are unconstitutional. Indeed, some situations the trial judge may find an ex parte conference necessary. Cite La Chapelle, and that's LACHAPPELL versus Moran at 699 F. 2nd 560. It's a First Circuit case from 1983 where the court cites, in the exercise of the court's residual power to ensure a just trial, protect jurors and witnesses, a judge may, in rare circumstances, feel it necessary to confer with a juror or witness on the record, but outside the presence of others, including the defendant. One such conference may be where a juror or witness, having been threatened, wish to speak with a judge privately about a threat. A witness may not feel free to discuss any threats in presence of the defendant or even counsel for the defendant. We agree that the First Circuit, that an ex parte conference is appropriate in that situation. They say C, United States versus Arroyo, and it's ANGULA. It's at 580 F. 2nd 1137, pinpoint 1142, 1142, and 1141, 1142, Second Circuit case. Exclusion of certain defendants and counsel from in-camera proceedings permissible in multiple defendant trial, where certain defendants had cooperated with government and received death threats. And then you've got a citation for that being 439 U.S. 913. Although an ex parte conference discussed threats against witnesses proper, the district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. In this case, the court followed procedures to ensure the conference was fair. First, at no time was the substance of Pooley's inculpatory testimony discussed. And second, the entire conference was transcribed. And that's United States versus Watchmaker at 761 F. 2nd 1149, 1985. Ex parte conference with frightened juror properly were transcribed and the judge's comments carefully framed. This court goes on to say in Adams, two aspects of this conference, however, disturbing. First, when the prosecutor began to impress upon the witness the distinction between being paid for testimony and afforded protection, the trial court should have called the conference to a close. The portion of the record quoted above indicates an attempt by the prosecutor to coach the witness on how to answer questions about inducements from his testimony. The court had already learned all it needed concerning the witness's fears and the prosecutor's plans for protection, there being no reason to participate in such coaching. Second problem occurred where Pooley took the stand. Defense counsel inquired about what inducements had been given for Pooley's testimony, and the prosecutor and Pooley both indicated the promise was the prosecutor would seek to enroll Pooley in witness protection program if he were in fear of his life. Neither related to the prosecutor's pledge to seek immediate protection for Pooley should it be necessary. The exchange occurred before the court, and the court should have made sure that the inducements made as in the ex parte conference were completely and precisely disclosed. Similarly, in this matter, the only thing discussed between the state counsel for Mr. Copeland and this court were the understanding of his immunity agreement. There were no other testimonial statements made by in terms of what Mr. Copeland planned to testify to that were induced or sought by the court. And the transcript in its totality will bear that out, and you can have a look at that. The court's also considered Bruner versus the state. That's 302 Georgia at 6. and this relates to the right to be present and what is defined as a critical stage and under the Sixth Amendment. Bruner contends that he was denied the right under the Georgia Constitution to be present at certain critical stages of his trial proceedings. Embodied within the constitutional right of the courts to a criminal defendant's right to be present, see and hear all the proceedings which were had against him on trial before the court. Ward versus the State, 288 Georgia 641, pinpoint 645. Violations of this due process right are presumed prejudicial, absent a waiver by defendant requiring a trial. However, there were no violation of Bruner's right to be present. The right to be present attaches to any stage of a criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure. And that's Huff versus the State, 274 Georgia 110, pinpoint 111. Thus, a critical stage of a criminal proceeding is defined as one in which the defendant's rights may be lost, defense is waived, privileges claimed or waived, or one in which the outcome of the case is substantially affected in some other way. And in this particular case, the court is of the opinion, basing on looking at the case law, that that this was a proper ex parte meeting pursuant to 2.9, as well as the no party gained any tactical advantage, and that the proceedings as a whole are released to will be in the terms of the transcript. So what was said can readily be seen and utilized by the defendants. Okay, and the court lastly took into consideration Talton versus the State. That's 368 Georgia Appeals at 313, and that involves a Sixth Amendment critical stage definition that was decided June the 21st of 2023. And in pertinent part, in many instances, remand will be necessary when the right to be present claim under the Georgia Constitution is raised for the first time on appeal from criminal conviction. So Mr. Seals raised this at the appropriate time, and the court is in fact considering it. And the Georgia Constitution guarantees criminal defendant to be present, see, and hear all proceedings in which are against him on trial before the court. Criminal defendant's right to be present under the Georgia Constitution attaches to any stage of the criminal proceeding which is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure, but the right does not extend to situations where a defendant's presence would be useless or benefit but shadow. And under the Georgia Constitution, defendant who is represented by counsel need not be present for portions of the trial that involve questions of law and consist of essentially legal argument about which the defendant presumably has no knowledge. It is well settled under the Georgia Constitution guarantees a criminal defendant the right to be present and see, hear all the proceedings in which are had against him or trial before the court. It's Prickett versus the State, 314 Georgia 435 at 441 pinpoint. This right attaches to any stage of the criminal proceeding that is critical to the outcome of if the defendant's presence would be contribute to the fairness of the procedure. But the right does not extend to situations where the defendant's presence would be useless or benefit or shadow. The court further takes no position on whether Attorney Bumpus disclosed confidential or attorney-client matters. The court takes no position on whether Attorney Bumpus violated the duty of candor to other counsels involved in this case. These two questions can be resolved by the State Bar of Georgia and or our Supreme Court.
Okay.
The court further takes no position on whether Mr. Steele, his use of the June 10th proffered information, as his use on behalf of Mr. Williams falls within our guidelines as set forth in the Georgia Rules of Professional Conduct.
No show cause. He canceling the contempt.
The court's basis for having been explained on the record, a written order of this, along with the attachments, will be included in the record. And Mr. Banks, where are you? Sir, as a result of this transcript release, the court withdraws the show cause for your client and others who may be present who are present in chambers on the 10th of June of 2024. As I mentioned earlier, we were going to have a show cause hearing on Wednesday, the 3rd of July. I am canceling that indefinitely. In fact, I've canceled all of that. So we will not be holding that particular hearing, okay? All right.
Get Kayla that. Come on, Kayla.
And then then transitioning to the last matter the court wanted to put on record. Upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our local rules. So this written order is entered. I will enter the order transferring it, and until such time as those two things are decided, then we'll be in recess until that time. And we will just inform our jurors that they're until this is, they're not supposed to come back on Monday until Monday anyway. So I will have Deputy Ingram and Ms. Umana indicate to them that they are still on recess and we're continuing to work. So that's all I have for you at this point in time. Okay?
So he's canceling court.
All right. Ms. Novi, can I ask you a question before you start anything? Madam, didn't your law firm represent one of the co-accused in this case? How are you then, do you have an actual or perceived conflict in this case? How have you been, I'm asking you at this point in time, could you state for the record how it is that you don't think you have a conflict? Because you did represent one of the co-accused in this case, correct?
I did.
Okay.
I did. Your Honor, this has absolutely nothing to do with my representation of Sergio Kitchens. Haven't even discussed that or come up and what happened in the ex parte proceeding. We're just representing Mrs. Bumpus, Attorney Bumpus, in what her position is with respect. Is on mute?
Yeah, you're good now. Yeah.
With respect to this court. So completely different matter. And now we're dealing with a contempt hearing of Ms. Bumpus as opposed to a criminal prosecution of Mr. Kitchens.
Right.
Completely different. And in fact, everything that we've gone through or anything we've learned about this case has nothing to do with what we've done with Attorney Bumpus.
Okay, I just want to, because you may have an actual or perceived conflict. I just want to bring that to your attention. So if you think that it should be addressed, then I'm giving you the opportunity to do so at this point in time. Because you do have knowledge of this particular case, but all right.
Well, I think half of America has
I'm sorry?
I said I think half of America has knowledge of this particular case at this point.
Okay, but they're not before us at this point in time. So what else did you want to?
Well, and I'll speak for the court's purposes. I'll speak for myself and John Garland, who's also our co-counsel with Attorney Bumpus and who was my co-counsel in Mr. Kitchens' case.
All right.
So I'll speak for both of us in that respect since Mr. Garland's not able to be here.
All right.
A couple things that I just wanted to clarify for Your Honor. Is the court still intending to produce an order on what the court addressed orally on our recusal motion?
Yes, ma'am. I'm going to produce an order basically bundling all, since there are 3 motions to recuse, to one to be spun on the wheel so that we don't get 3 separate people hearing these particular matters. So I will do that effective today.
Okay.
So does that answer your question?
It does with respect to that. The other issue was I think the court was holding under advisement our motion to quash.
That makes this moot at this point in time.
Okay. So
since I'm not going to have a hearing at this point or at any time in the future, you can re-raise it at that point in time if you so desire.
That's fine. So we'll
But I'm telling you, at this point in time, I have no desire to resolve that. I don't need to at this point in time.
Okay. All right. Those are the questions that I had.
Okay. All right. Madam, unless you have anything else, you all can be excused. Councils, I'm going to go ahead and, like I said, work on this particular order. I actually memorialized the order in writing and the motion to recuse in terms of the sending it to another judge pursuant to 25.1 through 25.7. And we'll see in a little bit, depending upon how it's ruled upon, all right? All right.
Your Honor, do we have a timeline of when the motion to recuse may be heard?
Don't know. That has to go to another judge pursuant to our local rules. So it will be basically put on the wheel. Of course, I don't have anything to do with that. So as soon as our clerk, Madam Clerk, Miss Alexander and her team spin that, that's not within my information and purview.
They're gonna spin it
Is
all
this something
right.
that we can expedite? I mean, the state does have very concerns that we hold the jurors indefinitely regarding this matter. Is there anything
It's
that
a
can be
mistrial.
expedited so that those decisions can be made on the motion to recuse and we can move forward with the trial?
While I understand your concern, I think the rules of transfer and recusal are pretty clear. That I'm not going to comment on anything that is pending at that point in time. So hopefully it will get done fairly quickly in terms of somebody acting on it. Okay.
All right, thank you, Your Honor.
Okay. Anybody else? Mr. Steele, you rose just a second ago. Do you want to say something, sir? Okay. All right. Okay. Okay. Then we're in recess and we'll see you in a little bit. Okay. All right. We're in recess.
Wow. Wow. It's so much to unpack here. I don't even know where to begin. So did he say that they in recess indefinitely, like until the other motions are heard, court is canceled? I guess so. They killed the feed. Wow. Wow. That's what it seems like to me. Court is canceled until another judge can decide whether he stay on the case or not. And Ms. Hilton talking about she's concerned that the jury will be lost. She's concerned that the jury will be lost. They already been lost. The jury they've been checked out. And depending on how long it takes, so the judge said he's going to put the order in and it's going to go into some type of wheel, random wheel. And then once that wheel is spun, it's going to go to a different judge. How many of y'all believe that wheel is going to be random? Or y'all think he's going to kick it to one of his friends? But I am curious because she said jury has been lost since day 30 and we at day 100. Oh yeah, we're gonna work on that. We're gonna try to get a copy of that because I want to see like what's in it. He's saying he's gonna release it, but I am curious because the judge he said a whole lot of nothing when it came to Kayla Bumpus. He's saying that she was in a hallway on video talking to. Let me see. I got the names down. Steele, Adams, and Shard. All three of them were meeting in the hallway. So he assumes it was her because he had her on video. I mean, she said a random wheel. He said his friend Belinda Edwards. Right. And then also he's the chief judge. Who's gonna go against, the chief judge? The chief judge is not necessarily their boss, but he can control some administrative functions, So it'll be hard for any judge in that building to go against him without him, coming back for vengeance later on. Which, he's shown time and time again that he likes revenge. if you do something he don't like, he's gonna get you. If it's not today, it'll be a week from now, a month from now, or when it's election time, he'll get somebody to run against you. But he's going to get you. But I am curious because they said the judge just said from 10:17 to 11:28. That's like an hour and what? 11 minutes maybe. Caleb was talking to Woody alone. See, he said, we are in recess and we'll see you in a little bit. Yeah, but I don't think that's the case. I think a little bit means until that motion is resolved. Belinda ain't crazy. Somebody said Miss Sylvia reported this morning Belinda Edwards will not be handling the motion anymore. Yeah, I'm sure. You will be a fool to go up against him if you want to keep your job or if you don't want him to mess with you in some type of way. That's why I think that when something like this happens, it needs to go to like another county next door. That way the judge cannot indirectly or directly, retaliate against you. But I do think it's a win. I mean, if the judge is kicked off, then we got to get a new judge, and we don't know what's going to happen because the new judge is not going to be up to speed, which may mean a mistrial in and of itself. And Miss Hilton, we want to see what was in the transcript. So I sent out a email to try to get a hold of that transcript. So, but if anybody got sources faster than mine, send it over and we can go through it. And if anybody since we have time to kill now, anybody want to come up and talk and share their thoughts, let me know and I'll drop the link. If y'all got a camera and a mic and y'all not shy. Because I took some notes down. So it seems as if the judge is trying to say that Woody may have been threatened. At least he cited a lot of cases about threats. He didn't directly say Woody would, received a threat, but that's all the judge was talking about was cases that revolved around threats. And I even made this example a while back. I said, if there's a situation where Woody was in fear for his life in the jail, and he went to the judge with his lawyer and said, hey, judge, if you take me back to that jail, they're going to take me out. Can you move me to another county jail that's next door where I can be safer? No big deal. Because that don't interfere with the rights of Jeffery Williams, Young Thug, and the other co-defendants. Just because Woody's spending the night in another jail besides the Fulton County jail, that's not a big deal. That was an example I used if it was a threat like that. But the judge still did not say today that Woody received a threat. He just talked about all these cases that involve threats without saying Woody received a threat, just to put it out there in the air. So now we really need the transcript. And then he really tried to make Kayla look bad because he said Kayla was in the hallway meeting on camera with members of the defense team. So, he put out just enough to try to frame it to where Woody could have been receiving threats. Kayla did talk to her client for over an hour by herself, which is attorney-client privilege if it was just them two alone, over an hour. And then also on top of that, Kayla was in the hallway on video. We have on video. But I guess they don't have audio. One of them lights are flickering. I guess he don't have audio. But now he don't want to move forward with the contempt. He's saying that it's suspended indefinitely. Do you think they will get a bond out of? At this stage, if it's a mistrial, I believe they should. Because now I had seen a video, I'm sure a lot of y'all seen it, where it was other co-defendants in a different courtroom that they were trying to see if they were going to accept plea deals. And the other co-defendant said, hell no, we're not taking no plea deals. Y'all have proven. See, the state, they were strong in the beginning. They were, everybody was scared. Oh, we're going to sign. You're going to go to prison for 20 years. Now all of the other people that's not on trial yet, it's other YSL members that's having a separate trial after this one. Now they see how weak this case is. So of course they're not going to take a plea deal right now. Ms. Hilton talking about, well, if they don't take a plea deal, we're going to handle them at a later date. How you going to handle them? You're not handling what you have in front of you. So the judge is saying he's going to release it, so hopefully we can get it as fast as he released it. I'm just curious, why didn't he go through it in court? Like, he never went over anything that was said. He gave us timestamps of who was in the room. Kayla told us that much when she came over here. She told us it was 14 people in the room. We already knew that, Judge. We want to know what was said in the room. And obviously, Kayla couldn't tell us what was said because he had her under the threat of contempt. But when her 6 lawyers was in the room today, all of a sudden he's backtracking. Oh, we're not going to have that hearing on Wednesday. You should have been counseled it, Judge. We've been telling you this. Counsel it. Counsel it. Let her come back to Texas. Let's see if we can get some fair use. We're going to share this under fair use. Somebody said Caleb Bumpus is talking right now. So what I'm going to do is stream it from my channel right here. Shout out to the lead attorney. So what I'm going to do is I'm going to see if we can catch it right quick. And I'm going to stream it right from here.
And hear me while you're getting your video worked out. It looked like he was intending on deciding whether you were going to be incarcerated or not. And now it looks like he has done away with that hearing. Is that what you kind of understood? Kind of what's your understanding of what he did in terms of your hearing on the 8th?
It was on the 3rd.
Oh, the 3rd.
Yeah,
I'm sorry.
it was the 3rd.
Yeah,
It was.
Sorry about that.
Yeah.
I mean, I still, like I said, like the fact that he says anything about this video, took judicial notice of this video surveillance is really crazy to me. Because I don't know what its relevance was. If you knew you were going to dismiss it. So it kind of gives me the impression that he didn't want to let it go, but he felt like he had to.
Yeah.
Yes.
That did come out of nowhere, that he would bring in that
And
piece
it had
of
nothing
footage.
to do with anything else that he said.
Right. Not at all. It didn't follow the string of cases. It didn't follow, the decisions. But I wonder if that pressure from Friday kind of led to this right now. But to your point, why did he bring up the footage? Did it have audio? And to your point, like, people in the courthouse talk to each other all the time.
100%. All right, Kayla. All right.
We want to know.
Bumpus now.
Are you the mole?
Listen now. The judge has already said, listen, you free. I can't keep doing this. The Supreme Court's on my ass. They've already assigned a new judge to this, to some of y'all's motion to recuse. So y'all got it. All right. You show up on a Monday to represent Woody, and Woody's there, and you just show up, and you're trying to make sure that Woody testifies so that there's no contempt issues. And then early in the morning, you get a notice that, hey, there's going to be a meeting in Judge Glanville's chambers. How did that go down?
Well, it didn't go like that.
Okay.
It went, I showed up to the courtroom and then they walked me up to chambers.
You got escorted up there. All right, you had your own escort. Who escorted you up there? Was it the security officers or who?
She froze, y'all.
Hello?
Yeah, I can hear you.
Uh-oh,
No, don't
she
freeze
dropped.
up on me now. Come on back, Kayla.
She didn't
Come on
froze.
back. We need you, baby.
Oh,
We need to
yeah.
find out what happened because now Kayla can talk free. Somebody write Kayla in the chat. All right, she back. Kayla, we need you. Yeah, there she go. All right. We back.
Okay. So
we
what
back.
did you ask me? You said
Okay.
after okay, go ahead.
No, you're right. So you go into the courtroom and you're there to cover for another attorney, an excellent attorney. You just show up to make sure, hey, nothing goes wrong. He testifies, and then that's it. And then someone comes up to you and says that you're going to be escorted to the judge's chambers. How did that work?
Just like that. I actually didn't make it in the courtroom.
Mhm.
I called because I was running a few minutes late. And they told me don't worry about it. Just call when I got in the courthouse. So when I got in the courthouse, I was never went in the courtroom, and I was probably the first person there. I mean, I guess, they know the culture of the courtroom, but I know how he is as far as timing, but I didn't want to be late.
Right.
So I was still on time, but I was still the first person there. So no one saw me when I got there, and they just took me straight upstairs.
Okay. So had you ever been in Judge Glanville's chambers before?
I can't remember. Probably so. I don't know.
Okay. Because you actually worked for the district attorney's office in Atlanta as well, right? So you're well accustomed with that courthouse and how it's laid out, right?
Mm-hmm.
And then so you go to the judge's chambers. Then what happens?
Then
Oh, she didn't froze again. Come on,
the
Kayla.
chambers is set up. It's very similar to like an office suite. So we were just in like a sitting area, and we were having casual conversation, and just talking, and then somehow we ended up in the actual chambers at the table.
Okay, so when you first got in there, who was in there with you?
It was just me and Simone.
And Simone is ADA
Hilton.
Okay. And then other people started filing in?
Yeah.
All right. And so you're sitting there talking with Miss Hilton, and then other people start coming in, and then what happens from there?
And then, well, see, it's an interesting in and out because then Simone has to go handle a matter, so she leaves, and Adrian comes in. And when Adrian before we go back there, Adrian comes in, and all of us are out there, and we're just talking about, everything, life, nothing about the case at all, just life. And then we go back into the chambers, and I guess there's kind of this procedural conversation as to how we got here with Adrian. Simone's not there.
Who's Adrian? Adrian Love, the ADA?
Yeah.
Okay. And so when you said that there was some procedural talk, what was that about specifically?
Like just how we got there, me standing in, what happened between her and Melnick on Friday, that kind of conversation.
Oh, got you. Because they were expecting Melnick, but then Melnick let the court know that he had a conflict. And so you were there. And guys, this is totally common. All attorneys do it. Unfortunately, we cannot be in two places at once. So if we get jammed up and we have a conflict, we ask one of our friends who is an attorney just to go and cover for us. So in this case, Attorney Melnick had a conflict. He informed the judge about that. The judge said that, hey, you still have to show up. So he asked Kayla to cover. And Kayla has covered for Melnick many times and vice versa. And as an attorney, you really need good relationships with people, with attorneys who can cover for you. So she showed up just to cover for Melnick, just to make sure that Woody was okay, and then he testified, and that he was going to testify, right? And then what happened, Kayla? So y'all are talking about how you were on the case, okay? And then what?
So it was always my understanding that I was really just supposed to be there because that's the only place that I could talk to Woody. I was always sitting there thinking that I was just waiting on him to be brought up because that was going to be my first time speaking with him
Got
to
you.
see what his
And
decision was going to be, whether he was going to testify or stay in the status of pleading the fifth.
okay, and I think the judge mentioned that as well, that everybody kind of showed up thinking that this meeting was going to take place, but then Woody was late. And so they were pretty much just waiting for Woody, and everybody wanted to know exactly what you said, if Woody was going to testify. So Woody
Mhm.
showed up late. So everybody was just kind of
It
killing
really
time
wasn't
waiting
that
for
he
him.
was. I guess he was late, but that's because he was not at Fulton County Jail, which is why I was not able to speak with him before that day. Over the
Got
weekend, I wasn't able to speak with him because I didn't know where he was.
Okay. And he had you already have a previous legal relationship with Woody in that you represented him a few times in the past. So you guys know each other. Is that fair to say?
Mm-hmm.
Okay. And so then y'all are just kind of killing time waiting for Woody to come to the courthouse. And then Woody gets to the courthouse. All right. What happens then?
And then he comes in, and I guess Glanville does this whatever he calls a judicial, what he takes judicial notice of, where he gives the timeline of what happened. So pretty much what he says is about the truth. I talked to him, but I don't really remember what he said the timeline was, but there was lots of back and forth, in and out, back and forth. Like some things he stepped out on because the state didn't want him to hear. And sometimes everybody stepped out just so me and Woody could talk.
Oh, this is interesting. This is interesting. So
I
first,
actually wrote down the timeline. Sorry to interject, Lee. I
no,
mean,
go
we could
ahead.
go through
Yeah.
it, Kayla, just so we can do this accurately, because
Mhm.
he talked about everything starting at 10:03. That's when Woody arrived, right? And then
Hmm.
from 10:17 to 11:28, apparently you and Woody had a private meeting.
I
Is
don't
that
agree with
accurate?
that, but I can't remember.
Wow.
I mean, I
I
just
don't
don't
Mm.
remember.
remember it being that long.
Yeah, because
Mhm.
that's about
That's
70
almost an
minutes.
hour. Like,
Yeah, it
no.
is. It's over an hour. It's over
No.
an hour. And then he said 11:31. That's what, so between 11:28 and 11:31, which is almost about 5 minutes, that's when everybody reconvened after y'all had a meeting. Then he said at 11:49, so about apparently the meeting left, or the meeting ended at 11:31, and then everyone left and went back to the courtroom at 11:49. So it seems like he's almost trying to slim down the time that everybody was in the room together. So,
The
as I
meeting
wrote
was
that
from
down,
9:30 to 11:49.
wow.
And,
Mm.
Yeah.
there were in and out moments of everyone.
Mhm.
But the
Mm,
meeting was, I was like drained. It went on
yeah.
for a long time.
Yeah. And it's interesting that you guys were in chambers. This never came out where you would, I guess some people would leave and allow other people to speak in more or less confidence. And then they would come back in and other people would leave. Is that right? People were coming in and out to let people speak privately.
Yes.
Now, let me ask you, this is very important. And this is kind of what I thought in the beginning, but you could, it kind of seemed like this wasn't the case. I thought because of the judge's initial posture and how angry that he was, that he had instructed everyone, this is my speculation, that he had instructed everyone that the contents of the meeting were to be private
Hmm.
and that no one should talk about the meeting. Even the fact that the meeting itself took place should be private, because you saw how angry that the judge was when someone blew the whistle and it kind of got out. Did the judge at any point in time, but especially at the beginning, tell all of you guys not to talk about this meeting, that it would be secret, the contents of the meeting were not to be shared?
Nope.
Well, no. And that's
Mm.
exactly why I kept saying, what am I in contempt of when I came on a couple days ago? What's the contempt? I don't
Mhm.
understand. You're mad because of what?
Right. If he never advised you guys of any type of confidentiality.
And Georgia law requires that if a judge wants to keep any type of hearings confidential, there has to be an order, whether it's oral or written. There has to be an order that specifies what has to be held confidential.
Okay. And so you're in there, and then Woody gets in there, and y'all are all in there talking. Now, there were some specific statements that were alleged to have been made in some of the motions to recuse. So, for example, Woody said allegedly that he was not going to testify and that he was willing to spend 2 years in jail not to testify in this case. Can you talk to us a little bit about that statement? Was it made? Kind of what was your feeling about it when you heard it?
When I heard it originally, or when I heard it recited?
When you heard it originally and at the hearing, I'm sorry, at the meeting.
I mean, he just was confused about what was going on. I do agree to a certain extent that the meeting was held to explain to him what immunity was,
Mm-hmm.
and the type of immunity that he was given. But I just think that in the process of it, there was information that came out, which then gave the defense a right to know about.
Mm. Did it seem odd to you when you looked around the room? I think at one point you mentioned that there were 14 people in the room. Did it seem odd to you that there were no defense counsels in the room?
Well, like I said, it was all happening so fast, and I think it was actually maybe 12 or 13. I can't remember the exact number because I couldn't remember how many deputies. But like I said, even though it was 2 hours, it was happening so fast, and I really didn't even get to think about that. I was just there for him. You know, he was asking me questions. He was so concerned about what was going on, and you know, I was just really there for him. But also, it never gave the impression that it was a secret meeting either.
Got you. And let me give a big shout out to Talk That Law. Thank you so much, Talk That Law, blessing the chat with this super generous super chat. And you had Talk That Law is an attorney as well here on YouTube, excellent content creator. And you had talked to him as well about this case, right? Everybody's wanted to know what was going on. Let me show you this. This is one of the documents from the motion to recuse. And it says here that upon information and belief, Judge Glanville informed Woody that Judge Glanville could keep Woody incarcerated until additional defendants were tried. So, you know, when you hear this, did this kind of, what did you think when you heard Judge Glanville say, hey, it's not just 2 years, it could be way longer if you don't testify?
Well, I'm going to say this. That was always what was told to me. Well, no, the word used was indefinitely. And I kept asking, you know, what is indefinitely? Before he got there, I kept asking him, if he wants to stay, I know him. And I know his question is going to be, how long do I have to stay in jail?
Yeah.
And so can you guys just tell me that? So when I have my meeting with him, I can just tell him this is the situation. And so when he got there, the first thing he said is, how long I got to sit? And I said, they're saying indefinitely. And so he's like, what? And I will say that was definitely a turning point in the meeting. I don't know. So I guess is Judge Glanville releasing the transcript to everyone?
Yeah, it's going to be made publicly available, and it's going to be the full transcript.
Yes,
so I don't know. I mean, if you would be open to waiting till that is filed, and then we can just go through it together.
100%. Ms. Bumpus, we can do anything you want, man. We can do anything you want. And that would be instructive to kind of go through it, because I would love to see what exactly was said. So you guys have this meeting. So we'll talk about exactly what the meeting, what the contents of the meeting were when the transcript comes out. Because again, like you mentioned, the meeting was over 2 hours. A lot of stuff was said. People were going in and out. So anybody's memory is going to miss some stuff, but we have that transcript. So that's going to be amazing. Now, you leave out of that meeting once the meeting ends, and you go, I guess, downstairs, and Woody starts to testify. Wait, no, how does it go? That was that Monday. Happens. Oh, he testifies. And then Brian Steele makes a motion that same day and talks about the fact that there was this secret meeting, and the judge just loses it and starts interrogating him. Who told you? Who told you? Who told you? Do you know who told Brian Steele about the meeting?
No, I don't.
No? Okay. Were you the person who told someone about the meeting that it got back to Brian Steele, or like the judge was trying to find out who the leak was, basically?
Well, I don't know exactly who the leak was, but what I'm going to say is I didn't even have a chance to tell anyone anything, because we literally came from that meeting into the courtroom and he started testifying. So I had to sit there to make sure he was okay. When we went on when we went on break or whatever, I did have a conversation with all of the attorneys, and I say that because I was caught on camera, so.
Right.
Oh,
You on camera, you on camera. And the judge has already said, hey, we're not going to go down this road anymore. It's fine. Kayla, I'm not going to put you in jail. It's fine. It's fine. No contempt.
It's fine.
So what you're saying that you were not the initial leak. Is that fair to say?
Right.
But then once Woody started testifying and then went on break, then you did have a conversation with the defense attorneys. How did that go down? Who was the first defense attorney that you approached to say, hey, let me talk to you for a second? How did that go?
Well, it went
and you on camera anyway, baby. So let's just talk about it now. Let's just talk about it.
Thank you so much, Mr. Dunn.
You on camera. The judge is already on game.
Right. So I mean, pretty much there were 4 attorneys right there that I spoke to them together. And of course, Attorney Steele was there, and Attorney Adams.
Attorney Steele, who else? Was it
Adams.
the ball? Oh, Adams. So the black co-counsel of Attorney Steele, and then who else? Was the bald white guy there?
Yeah, Matt. And I think that might have been the only ones, but I talked to them on several occasions that day.
Okay. And the first time when you saw them there together and you go up to them or however it goes, kind of what was your initial communication to them, or initial saying, just say, hey, there was a meeting, or how did it go down?
Well, they already knew.
Oh, they already knew about the meeting.
Yeah. So it was I mean, they didn't know everything, but they knew a lot.
Oh, okay. Because again, you weren't the initial leak. So there was already a leak. So they already knew.
Yeah.
And then you went up to them. And so did they start asking you questions, or kind of how did that go?
Yeah, just went like, then I was able to talk to them and tell them, I guess, from a legal perspective, what happened. Because I was the only attorney there, and definitely the only defense attorney. But I don't know who told them initially, but of course it wasn't a legal perspective.
Got you. So they start asking you questions. Now, when you talked to them, was this before Brian Steele made his announcement to the court that he knew that there was a secret meeting? So he talked to you, and then after, well, let's see if this is like this. First, he gets the information from a leak, from a source, from a whistleblower. Then after that, at some point, he talks to you and kind of confirms that actually there was this meeting. And then after that, he goes up to the microphone and addresses the court and asks the court about the meeting. Is that right?
That's right. And I remember as soon as he did it, I got up and I ran out of the courtroom.
You were like, I gotta get a haircut out of here.
She said she ran, y'all. She ran.
It's getting hot.
I remember it so bad because when he first got up there, I went outside and I don't think it's a secret that I know a lot of people involved on this case, a lot of the family and stuff, because I'm from Atlanta. And I pulled somebody to the side and I said, I'm about to be in trouble. And not because of I thought I did anything wrong, but because I said the only person he's going to think who did this is me. I knew that before it really went down. And then I said that I think I said that before Brian even got up, Attorney Steele got up. But I think he just said he had emotion. And then I went out the courtroom and I said, I think I'm about to be in trouble. Then when he got up there and he did all he did all that, I never went back in the courtroom. I sat in the jury room and watched on YouTube.
She was in the courthouse watching the trial on
I
YouTube.
I heard you were in the law and crime chat. I was like, really?
No, I was in Miss Sylvia chat.
Okay, got you.
Come back to talk that law chat.
So when you heard that Brian was about to make that motion, you were like, I got to get up out of here.
Well, I already knew what he was going to do, and I think he already he was willing to do whatever he needed to do, and he knew how Judge Glanville was going to respond, and he told me, straight up how Glanville was going to respond. And,
really?
Mm-hmm.
So he knew that Judge Glanville was going to press him about the identity.
I don't know if he knew that, but he knew he was going to be held in contempt.
And Brian Steele was prepared to be held in contempt. He was not going to reveal the source of the information.
Mm-hmm.
Wow. And so when you were talking to him and the few other attorneys outside the courtroom, how long did y'all talk, more or less? Do you remember? Was it 5 minutes, 15 minutes, an hour, something like that?
An hour.
Oh, an hour, man. So you were talking to him.
I was talking to him.
Wow.
In all fairness, I did not think, and I still don't think, that I was doing anything wrong.
Correct.
He's attorney.
Correct. You were doing something that absolutely needed to be done, and you should be applauded for it. Somebody write Kayla in the chat, please, now, because we need this. There was going to be a grave injustice without these defense attorneys, talking to Kayla, getting the real information, talking to someone who was also a lawyer who could convey the legal kind of aspects of what was going on in that meeting. Were they surprised at some of the things that you were saying? Kind of, what was their reaction to
They were angry.
Why were they angry?
Just from the information that was put in their motions, how they felt. They had very strong opinions about, they should have known about the meeting.
Gotcha. And so then you talk to them for about an hour, more or less, somewhere around there. They go back into the courtroom, and then Brian Steele makes the motion, and you're like, all right, I'm going to get out of here. And so then after that, the judge says that he is going to incarcerate Brian Steele for not giving up the name of the mole, the whistleblower, the leak. And attorneys from Gactel kind of show up to represent him. And apparently there was word that there was some type of like a protest. 25 attorneys started coming down there mad about how things were going.
Thank you.
No, I was gone. I was gone because he had released Woody, like he said, at 5:58, I think, in his judicial notice or something. And I left at that point. Like I said, I wasn't in the courtroom, but I was still in the courthouse because I knew I was not excused. But generally, once your client is excused, who wasn't my client anymore, and I really can't wait till we get this transcript, because then I can really give you.
Neither can we.
For real. But it just makes more sense to go in a chronological order so you can really understand how we get here instead of just jumping all over the place. But I say all that to say I left, and then I think it goes on for 2 hours. Now I haven't eaten all day. And I'm finally sitting down to eat, and my boyfriend, he's still watching. And
she got a boyfriend. So many people are asking. Look at AV.
Man, that was the most uncomfortable thing ever. I'm happy you said that, because watching him call somebody baby while I'm in the middle is a special kind of hell.
It ain't even like that. But everybody was like, what is her marital status? What's going on? Okay, guys, so she got a boyfriend. All right, so I'm glad you put that out there. All right, I'm sorry to interrupt you, but what were you saying?
He's still watching. I mean, he's watching still, and all of a sudden we hear Kayla, and where's Miss Bumpus? And I'm like, listen, I'm on the way to the airport. So I'm at a restaurant by the airport because I'm about to go. My business is done. He's on the stand. He said she's not excused. Make sure she's here at 9:30 in the morning. And I'm like, oh my God. My
Wow.
kids are in Houston. Like, I didn't make arrangements for any of this. So I'm like, oh my God. So, and then, like, it's very rare that if your client is excused, that you would stay past your client being there. And so for him to say I wasn't excused was really, I knew right then, I knew what type of time he was about to be on.
Come
You
on.
And
knew
so
it. Mhm.
and it's just so crazy because I didn't have any clothes. I came in a suit. I thought I was gonna leave in a suit, like everything. So everybody's like going crazy about this outfit I had on. Like they think
Yeah, everybody
I'm like,
know about
if you
that
guys
outfit.
only knew the whole day, I feel so uncomfortable. Like, oh my God, I have to wear this to court. And
Yeah.
then I'm like FaceTiming people, like, you think this look okay? Like, everybody's like, it's like, then everybody loved the outfit. I was
Yeah,
like,
it
Green
look
one,
okay.
the lime.
I was so self-conscious about it. I'm like, I look a mess. I can't believe I have to get. And the day before, I had on the nicest
Oh
suit, the
man.
nicest shoes. Did not
Oh
see a camera.
no.
But I couldn't wear it to court again.
Yeah, well, it's so crazy. I was looking at your Instagram, Kayla, and I was like, look at the drip. Look at the drip.
Yes, Caleb is
You're a good
starting on
dresser.
y'all. 100%. So let's do this because what the judge said when he just came back on the bench, it wasn't very long. It's a few minutes, and a lot of people were kind of asking for some clarification. So what we might do, if I can pull it up, let's just go and hear exactly what the judge's take on it was. And then, you can jump in or we can get your take as well. So let's see what the judge has ordered. But again, guys, somebody write Kayla in the chat. She does not have to go to jail anymore. The judge has released her. She is in Houston now, so she wasn't sweating it too much in the beginning. But let's see what this judge has to say. All right, let's go.
I'm going to take judicial notice of the following timeline.
All right, so let's listen to the timeline.
On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted an immunity from prosecution pursuant to 24-5-507A, and that will be marked as courts 2. So the transcript will be court 1. His immunity agreement, Mr. Copeland's, will be court 2. Mr. Copeland, who was represented by Mr. Jonathan Melnick and advised of his rights and obligations during the proceedings on Friday, June the 7th, which will be marked as courts 3, the transcript of those proceedings, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt, and that will be courts 4, Mr. Copeland's order of contempt.
And so just to stop there, he was ordered to be in contempt because the way that he was invoking his Fifth Amendment rights. And so you were there just to make sure that the contempt was relieved. Is that right? Was that your stated or your understood purpose of showing up in the first place?
Yeah, that's correct. And also, I think that going back to the meeting, initially I thought that's what we were there for. Because I'm going to be honest with you, and even some other attorneys that I talked to, I had never heard, like, everybody is thinking that, there's so many different type of immunities.
Mm-hmm.
And so they're thinking like, and correct me if I'm wrong, but I think he stated on the record what the immunity was. But this was not something where he, really had a choice in the type of immunity that he was granted based off of their reasonings. And I guess that'll be in the transcript. So I didn't understand what was going on either because, one, I think he also stated that the immunity was granted on Friday.
He did.
So he had just he just didn't know what was going on. It's like, you come to court, here's immunity, now testify. If you plead the fifth, you're going to jail. It's just weird.
Yeah, it's all over the place. And then on
Hey, I'm gonna say this real quick. I'm streaming through Lee's channel live on the fair use. So if y'all want to watch it over there, y'all more than welcome to. But Tony, I'm telling you, I'm not stealing Lee's attorney money by any means. So you're more than welcome to go over there and watch it. It's the same video.
Top of that, he says that you're granted this immunity, but what he did not talk about was when little Woody mentioned or allegedly had mentioned that he had shot Nut. He didn't even talk about that in what we just watched this morning. He didn't mention it at all.
I don't think that was said.
Okay. So
Wow.
that's technically that. It sounds like that was a rumor then.
I don't think that was said.
Okay.
Interesting, because that was a huge thing, and the defense
Yeah.
counsel has been super hot about that. But I guess
I don't think that was said.
Okay.
Okay.
But I think that, you
Mhm.
know, as defense attorneys, sometimes we take something, we put our own spin on it. It's our theory.
Yes.
It's our opening statement. It's our
Mhm.
soundbite. It
Gotcha.
doesn't have to be verbatim. Same thing for the state. When they come out, they come out.
100%. 100%. So let us keep it going here.
Mr. Melnick informed the court that he was not going to be in attendance of any further proceedings as he would be on leave effective 10 June of 2024. The court informed Mr. Melnick that his leave, or had discussions with him that his leave was not proper and that he needed to be in attendance on Monday, June the 10th of 2024 with Mr. Copeland. Mr. Melnick relayed that attorney Kayla Bumpus would be representing Mr. Copeland.
Shout out to Kayla.
On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken.
And I will say this again. Thank y'all for those who are watching it over here. Y'all more than welcome to go to Lee's channel. But I did donate to Lee, AV, and Kayla. They all equal to me, so I gave them the same amount. So I'm not trying to steal anybody's money. I don't want to be accused of that. So y'all more than welcome to go to his channel and watch it.
Down by the ex parte to await Mr. Copeland's arrival. The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also present were attorney Bumpus, Ms. Hilton, the DA's investigators Long and Hamilton, the court and security personnel, deputies Houston, McPherson, Brown, Sergeant Brown, and Sergeant Hall. The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with attorney Bumpus from 10:17 a.m. to 11:28 a.m.
Wow. So Kayla, I don't know if you heard that, but it sounded like the judge just said that they took a break of over an hour to allow you to talk with Woody. Is that how it went down? Did you have about an hour just to talk to him alone?
I don't recall an hour.
See, well, you know, she represents Woody. I don't recall.
Right. I get all
What you mean?
I don't recall.
So for those who don't know, this is Kayla Bumpus. She first came over here when it first happened, and she talked with us. And then since then, she done blew up. So now we got to get her back because, you know, she everywhere now. She all on Law and Crime. She over with the lead. We got to get her back. Let's go.
What you mean an hour, Judge? So this is interesting. So he's putting on the record that Kayla and Woody talked for about an hour. And Kayla says, listen, that's not my recollection, but okay. So this is interesting. All right, let's keep it going.
Hamilton, the court and security personnel, deputies Houston, McPherson, Brown, Sergeant Brown, and Sergeant Hall. The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with attorney Bumpus from 10:17 a.m. to 11:28 a.m. The ex parte
was 10:17 to 11:20 something. So that's over an hour that the judge is saying that you and Woody spoke in private. All right.
The hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m. The court arrived in courtroom 1C at 11:49. The transcript of those proceedings, starting as of 11:49, or when the court presumed that we held the proceedings on 10 June in courtroom 1C 2024, that will be marked as courts 5. The proceeding in 1C commenced on the record at 11:52 a.m. A lunch recess was had at 12:51 p.m. The parties returned from lunch, and Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m. In asking Mr. Steele later that afternoon was held in contempt. However, he was allowed to continue representation of Mr. Williams. The court, in asking Mr. Steele questions of how he received the information that he proffered in open court, was only concerned about the integrity and security of the conversations that were had in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of what was told him at that time. Jurors were Mr. I'm sorry.
And let me jump in right there, because what the judge, let me rewind that just to make sure I caught what the judge is really saying. Hold up.
Those conversations were the subject of proper ex parte conversations or the summons, was only concerned about the integrity and security of the conversations that were had in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of what was told him at that time.
Okay, so what is he saying right here, guys? He's saying, listen, I was pressing Brian Steele for the name, but I only wanted the name to make sure that the security of my chambers was okay. I didn't want the name to find out, you know, what was said and to track this person down. I just wanted to make sure that you know, everything was secure. Everything was secure. What do you think about that, Kayla?
Why did you pull the cameras in front of the courtroom?
All right. He was really investigating who told this information.
I knew that was going to happen from the beginning. When I reached out to who I decided I wanted to represent me, I knew. I said, I'm going to be on camera.
You were already on camera.
I mean, I knew how upset he was. I mean, I don't know if you remember, well, when it initially happened, he was like, you got 5 minutes. And he just like storms out. And I'm like, oh my God. I'm not looking back in
Oh, so you were in the courtroom when you saw that that
yeah,
exchange?
I saw
there?
that. And then Brian, and then he's not even on the bench anymore. And Brian yells, and we know Mr. Copeland admitted to killing that. I'm like,
yes.
And he's like, don't take my notes. Don't touch my notepad.
don't touch my notes. And then it's so funny because I think, you know, I'm in the courtroom the next morning, just pacing in my little green, going back and forth. And Brian walks in, and the first thing I see is those notes with the red writing.
She said, my little green. I love it.
Yes. And then when the judge walks back, what you said is so funny, because when the judge is walking out of the courtroom, Brian's like, yeah, we know that when he said that he killed Nut. I know you were like, what am I even in? Because again, you just were there just to make sure that he was testifying, and all of this starts blowing up around you, right? You had no idea.
See in the transcript that I say, you know, even though I am no longer representing him, now this is before he starts testifying, even though I'm no longer representing him, for judicial efficiency and as a professional courtesy, I am going to stay and make sure he makes it through the day. And everybody says, okay. So that's what just made me so mad. When I'm going to go ahead and tell you about this, when I keep saying, can I approach? It's because I want to be like, you know, I was not his attorney.
So that's why you
knew, and that's why like everybody's like, what am I telling Simone when I'm like going crazy over there? Is that you need to say something. And if you read the notes, I keep saying you need to say something, because everybody knew that you fired happened in chambers. It happened multiple times. And
really?
I chose not because I had to, but just to be nice.
So Woody fired you in chambers as well. Did the judge hear when Woody fired you? Was the judge around to know that? Did the judge know that Woody had relieved you from the representation, and he still went along? So when you were asking, you were saying that you were asking for the sidebar to the judge, and the judge did not.
Yes, well, at first he said yes, remember, and then the defense objected to it. But it was pretty much, I wanted to be like, you know that I wasn't supposed to be here.
Now the judge was fighting really hard to keep you in the case. You wanted out of the case. Woody wanted you out of the case. The defense counsel wanted you out of the case, and the prosecutors wanted you out of the case. Everybody in that courtroom wanted you out of the case except for one man. Why do you think this one man wanted to keep you in?
Well, because, you know, like and it's just so crazy to me because he showed his hand so many times throughout this process. Like you mentioned when I was on here a couple days ago, how all of a sudden does I have to stay to the 25th okay, now I got all these people who stand up and tell me I can't keep her here. So now I'm gonna make a show cause hearing for the 25th. I mean, he just was it seemed like he was buying time to try to see what he could do to me.
Mm-hmm.
And, you know, even he says something about leave it up to the state bar. Well, I mean, I guess he's going to report me to the bar, and that's fine, because
somebody tell him when he report his damn self.
He's not the holder of the privilege. Woody is.
Exactly.
So, I mean,
Ooh.
do what you got to do, sweetheart, because I know what I say that because it's just so frustrating that you keep messing with me.
Yes, and talk about that too. And we were going to get to that, but that might have went over a lot of people's heads. But you know, us three heard it immediately when he said, "Well, you know, the state bar might have to take care of that." What did you understand that to mean to the you know, explaining this to the layman's in the chat?
Well, I already knew that was a possibility. I kept asking my attorney, you know, and I might seem calm now, but I really have been freaking out this whole time. And not because I thought I did anything wrong, but just who wants to deal with this? And I still have to wake up every day and practice law. And, you know, one day I remember telling my clients, like, are you watching TV? You messing with me? I'm trying to stay out of jail. Like, leave me alone. Like, you know, and it's just unfortunate because I never got this. No, seriously, like, you talking about, I don't.
She's like, why y'all keep calling me? I have all this stuff going on.
Right, like, you can't be saying, are you on Instagram? Are you in a hole? So I just started telling people, if you don't Google my name. and they're like, I'm so sorry. Like, everybody is like, all my clients are like so empathetic.
Hey, Kayla said, Google her name. Y'all heard what she said. And for those who just jumped in, I'm just streaming through the lead attorney's channel. Y'all are more than welcome to go to his channel. It's the same thing. So if y'all want to go over there and support, y'all more than welcome. I just want y'all to know this is what that is.
Pathetic right now. They're like,
That's
hi,
good.
Miss Kayla. Is everything okay?
Yes, because you were going through it. Mm-hmm.
I was going through it because it was just a lot. And like I said, the first night, I literally thought I was going to jail. I kept saying, I want my 20 days straight. I don't want
Stay on a weekend.
So, give me mine straight up. I want the 20 raw.
Okay. 20 straight. But I had to do those things to keep from really, you know, having an anxiety attack. And, you know, my mom came to court with me the next day. She was worried. Like, everybody was so worried. And it's just because, like I stated previously, anything goes in that courtroom.
No, thank you,
so
lad.
whether I did something wrong or not, anything goes. Because Ashley Merchant articulated in the most I don't know how she could have said it, comprehensible way.
It was very
that
clean.
You cannot hold someone in civil and contempt. Read him the law, and he still pretty much said, I don't care.
Still did it. You're exactly right. It was basically taking the stance, well, appeal it then if you don't like it.
And then he kept, choosing not to grant certificates of immediate review, you know. And so that was more of the shocking part to me, and the part that was alarming is that I don't know what's going to happen. But anyway, back to your question, I had already told my attorneys, you know, because he has stated so many times that I had violated privilege. She. And so I said, well, do you think he's going to report me to the bar? I mean, that's all I can think of is if he can't get it this way.
And let's even break that down. What does it mean to be reported to the bar? What does that mean?
Well, the bar is the organization that governs attorneys. We are self-governing employment, and, you know, we have people who hold us accountable for being ethical. And one of the most, I guess, detrimental violations is to violate attorney-client privilege. It could disbar you, which means take away your ability to practice, take away your bar card. And he alleged on national television that I had done that.
And so he had alleged that you had possibly committed a violation for which you could lose your bar card.
Yes.
And when you say bar card, you're talking about the state of Georgia bar card, which gives you a license to practice law.
Yes.
And guys, there's no threat. There's no threat bigger to an attorney than losing that license. Guys, we've invested so much in terms of college, law school,
money.
Yes. Passing the bar, setting up our own office, all of this. And it comes to a point, whether you've been practicing 5 years, 10 years, or whatever, yeah, I'll be honest, you really don't know how to do anything else. You really don't know how to, you don't. This is what you do. And if you lose that license, you cannot do the one thing on earth that you know how to do. And so a threat to that license is taken very seriously. Now, a lot of you, not a lot of you, there will be people who file grievances or bar complaints. Y'all have heard of a bar complaint. A bar complaint is where you are being represented by an attorney. You feel that attorney is doing something wrong, and so you file a complaint with the state bar to say, "Hey, you need to investigate this." And I'll be honest, most of the time, at least I can speak for the state bar, Georgia.
Dismiss before they get to my office.
Exactly.
Find somebody to play with, because
yeah, they are not messing around. They do not take complaints from regular citizens very seriously in general, unless they are alleging something crazy.
especially money.
Yeah, you're stealing money. You're stealing money.
Exactly. But I'll be honest with you, there are levels. And when the State Bar of Georgia gets a bar complaint that's filed, it's seemingly, from what this judge is saying, maybe he might do it himself, from the chief judge of Fulton County.
They're gonna look at
and the law, well, the office of the State Bar is really right down the street. This is when you hear it, you're like, wait a minute, that's kind of a threat, right? Or what's your take on it?
I mean, you can also file complaints against judges, right?
Oh, there you go. There we go.
Hey, 2 people play this game. I love it. I absolutely love it.
Right back at you, Judge.
Yes. So let's take a look. Let's continue.
We're really here we're trying to hear Kayla's side of the story, because this just happened and it's fresh. So this is not an intent to take this whole thing. We're just trying to hear Kayla. So when she gone, we gone. But Michelle, I see you. And you more than, I tell everybody, y'all more than welcome to go watch it over there. We gonna be all right.
To hear what this judge is saying. Let's go.
Jurors Jurors entered the courtroom to resume Mr. Copeland's testimony at 3:39 p.m. The jurors were excused and exited the courtroom at 5:56 p.m. Mr. Copeland was excused and exited the courtroom at 5:58 p.m. The court asked Mr. Steele again whether he received ex parte information, and that would be at 5:59 p.m. Mr. Steele's counsel, Ms. Ashley Merchant and Mr. Alex Susor entered the courtroom. Mr. Steele was held in criminal contempt. That order of that contempt will be marked as Court 6, and the proceedings concluded at 7:41 p.m. The court further takes judicial notice of the following statements proffered by Attorney Brian Steele, in open court upon information and belief stated to the court, which are still unknown. There are 6 assertions that Mr. Steele proffered in front of the court. Those are contained within the transcript of Courts 5, the proceedings that are held on the 10th of June of 2024 in Courtroom 1C, which the court's already said will be part of this order. The first assertion.
So this is what Brian Steele has said.
We're just watching the stream. For those, they got the idea. Michelle, y'all more than welcome to go over there and watch it. And I will say this as well. If Lee hit me up or AB and say, hey, we want you to take it in, you're costing us money, hey, I'm okay with that. I'm not making no money off of this stream. Y'all calm down. Golly.
What was and the transcript bears out exactly what Mr. Steele said. So the court is paraphrasing the 6 assertions that Mr. Steele made. They're more aptly and more eloquently put in the record. The first one.
Thank you, Michelle. What's up, Cavell?
Involves his concern that
you gotta get
supposedly in chambers, this honorable court reporter, court at times, district attorney or district attorneys before the DA's office, as well as investigators, sheriff, and deputies, Mr. Copeland and his counsel met together. None of the defense team, to his knowledge, were present. Second assertion he makes is that Mr. Copeland intended to plead the Fifth Amendment.
They funny. Like I'm making a hell of
Third assertion is that Mr. Copeland, as a party, was sworn, and Mr. Steele asserted that this particular conversation was, in fact, a critical stage. and that the defendants had the right to be present. The fifth group of assertions involved Mr. Copeland not going to testify. The fifth group of assertions involved what Ms. Attorney Hilton claimed or said to the witness, to include the court, involving allegations of coercion and witness intimidation, and that his counsel had the right to be present. And the sixth assertion.
And let me stop it right here, because this is very important for what Brian Steele puts forth in his motion. And I just kind of want to get your take on it. And I just want to say from the outset, it's just going to involve a lot of speculation on your part.
And I would also say this. I remember when Kayla came, y'all know who Kayla is. She's the attorney for YSL Woody. What do you say, Woody? When it first happened, she came over here and she talked to us first here on Talk That Law. And this video, people were sharing the video all over social media, different Twitter, all type of sites. And I never told one person to take something down. I mean, you can use it as YouTube. So I just wanted to put that out there as well. But what y'all thinking so far? Is Kayla, is she standing her ground as far as she did the right thing with Woody in the back? Or y'all think that it's some more that went on in the back that we need to know about?
So if you can't answer it because it's speculative, I understand. But it seems like what Brian Steele is saying is that because there was all this talk to Woody from the judge and the prosecutor about jail, about indefinite incarceration, and Woody changed his mind from not testifying to testifying. Brian Steele makes out the argument that there was some type of a coercive pressure for him to testify. Mm-hmm. While you sat in there for over 2 hours, did you feel that there was a pressure for Woody to testify?
Answer that.
Wow,
ooh,
he's like, yes.
She said yes.
And that did you feel?
Wow. So she just said that she, as the attorney, feels as if Woody was pressured to testify. That's a big deal.
Did you feel any of that pressure coming from the district attorney's office, who, and it needs to be said, Woody is their star witness. So they absolutely want their star witness to testify. Did you feel that there was a pressure coming from that office to have him testify?
I feel like everybody in the room put some pressure on them. I mean, whether it was legitimate or valid, like I said, everybody just doing their job. And that's what I told them. People they're just doing their job. I don't know I don't think there was any bad intent, but sometimes things happen. I can't, like you said, I can't say what anyone else was thinking, but I can say what it looked like. And if the transcript is the real transcript, you will see. Like I say, the turning point in that meeting was the part you read in the motion about how long he could be held.
Mm. Was there a point in time where you saw Woody kind of change his mind based on something that was said? Was it because of the length of incarceration? Is that what you think might have swayed Woody to testify?
Yeah.
Wow.
I mean, I can't speak for him, but I just think that was the turning point in the whole conversation.
Mm. Now, you practice, along with personal injury, you practice criminal defense. And your background speaks very well of you practicing criminal defense, because you were on the other side in the beginning and you worked as a prosecutor, as a district attorney, an assistant district attorney in this office, not under Fannie, but in this office in the courthouse. Mm-hmm. Had you ever seen a case where a judge is pressuring a witness to testify in a trial?
I've never seen this.
Mm. And just as a prosecutor, or putting on a prosecutor's hat, how do you feel in general about a judge pressuring a witness to testify?
I mean, I will be honest and say that, in that whole meeting, his role was very, very small. He did not have a lot to say, but it's very similar to what's happening in the courtroom of more ain't that right, judge?
Of more what? I'm sorry.
Like, it's like I feel like they're always like, ain't that right? Yes.
So like
the
confirmation.
State. Yeah, kind of. Okay. I feel like that's what they do in there, and the state is like, right? You know, you're on our side, kind of. I'm not saying that's what it is, but that's what it kind of felt like. Like, you know,
Coaching them.
Got you. It felt like there was some coercive pressure or some pressure to get him to testify.
no, what I'm saying is
The
from the
judge.
state to the
They
judge, it was
pushing the
more of
judge.
a
Basically, what she's saying is, Judge, didn't we tell you this, right? And the judge will say yes. You know, so they leading the judge, pressuring him to do what they want. The prosecutors leading the judge.
I'm saying the judge did not say a lot.
Mm-hmm.
But he was there, kind of, his presence was kind of just him being there, just being in custody, being in the judge's chambers and on his face.
Yes.
Bad.
Kind of coercive in itself, right? The
Yes.
atmosphere is coercive.
The
That's a
atmosphere,
great
you're in
point.
custody, you're in chains, and you're sitting, and I mean, you've probably never been in a judge's chambers. He probably been in jail so many times, court so many times, and that's probably his first time there.
Yes.
And simple.
Oh, so at the actual hearing, he was in chains.
Yes.
Wow. I mean, how much more coercive do you need to be in chains in a judge's chambers where the state is telling you that they could keep you locked up in those same chains indefinitely unless you testify? This is crazy. This is absolutely crazy. Let's keep it going here.
Witness to include the court involving allegations of coercion and witness intimidation, and that his counsel had the right to be present.
And just quickly, do you think that Woody was intimidated to some extent because of the situation, because of the atmosphere, and because of what was being said in that hearing?
Yeah, I do. I think he was very frustrated too.
Okay, let's keep it going.
And the sixth assertion that was made in open court was that Mr. Copeland admitted to killing Donovan Thomas.
And we are looking at some attorneys here. I don't know if you can see them, Kayla. The gentleman. Do you know who some of these attorneys are? Can you identify?
Hey, every once in a while, I'm gonna stop the stream just to let y'all know this is not Lee's channel. Lee, the lead attorney, y'all can type his name in. Y'all can go over there and watch. But I'm streaming it live as it happens because we want to get Kayla's take on what just happened in court. So I'm just letting y'all know what's up.
Any of them that you know?
Yeah, so we'll start on the second to back row.
Mm-hmm.
That's Gabe Banks.
Okay, so this is Gabe Banks. Now, does Gabe Banks represent you?
Yes, he does.
Okay, so Gabe Banks represents Kayla, and I believe this is the same Gabe, guys, that was involved in the whole Fannie Willis, Nathan Wade debacle. I think I don't want to go much into it because I don't, it was a few months ago, so I don't really remember.
And he represented Lucci.
Oh, really? He represented Lucci. Okay, yeah, and I believe I don't know if he specifically represented Terrence Bradley, who I don't want to speak on it because now my ideas are fuzzy. But yeah, if you're thinking this is the Gabe, I think this is the same Gabe that was involved in that whole Fannie Willis, Nathan Wade, Terrence Bradley debacle.
Well, Gabe is definitely a lawyer's lawyer and a judge's lawyer too. He represents several judges right now, several lawyers. I mean, he's a very good attorney. He's so smart, and he used to be Adrian Love. He was like the original head of gangs under Mr. Howard.
Oh wow!
I did not know that. So he also worked for the prosecutors before he went out on his own and starting to get that real money, right?
Right.
Interesting. And then do you know any other of the other remaining 4 attorneys here?
Yeah, that's Kyle.
When you say that's Kyle, which one is Kyle? The gentleman, the white gentleman in the middle
yes.
here? Okay.
And he's brilliant as well. He represented me as well. He had a major playing appeal. He's an appeals attorney for sure. I mean, he's a great attorney, period. But they say what makes criminal defense attorneys, and even with Brian Steele, what makes them so sought after, or what gives them their credibility.
There's a guy here saying he needs help, and that's what they tell him. He's an appeals attorney. Cordero, you need an appeals attorney.
Is when they win appeals. When you can beat a judge is when that gives you your notability. And so he had the case with the Little Wayne bus shooting, and I think he was able to get something with that overturned.
Wow.
Wow. Okay. And so he also represented you in this particular case?
Mm-hmm.
Okay. And then the black gentleman sitting next to him, do you know who he is?
Yeah, that's Julius Collins. He was my lead attorney on this case.
Lead attorney.
Okay, so he was your lead attorney, right?
Mhm,
All right.
yeah.
And then the two people sitting in the front of them, do you know who they are?
Well, I think there's three. There's Nicole Mormon on the very end. She's on the brown jacket.
Oh, you're right. There
Yeah.
are three people. Mm-hmm.
And she's my close friend. She's like the attorney who I call for everything federal. She is like the federal. She goes anywhere federal. She's the federal queen. Like she's a bomb attorney. I think she represented Dirk too.
Oh, shout out to Lil Dirt.
Mhm.
He goes down in Atlanta, guys. All right.
Right.
And then sitting next to, is there any way you know who might be sitting next to her?
That's Kristen who got up at the end.
Oh, that's right.
Yeah. He was
Yeah.
talking to her about conflicts and things like that. She
Well, I
represented
thought that
Gunna
was
before?
interesting too because
Yeah.
Nicole also represented somebody on the YSL case. So I don't know
Yeah.
why he chose, but I guess maybe it's because Kristen was talking.
Gotcha.
Yeah.
Yeah. I think it was Sergio Kitchens who's Gunna.
Mm-hmm.
Interesting. And then the gentleman sitting closest to us in the foreground, who is him? Who is he?
I don't know who that is.
Okay. I think he was co-counsel with
Brian
Ashley
Steele.
Merchant.
He
His
was.
name escapes me.
Yeah.
But when Judge Glanville was trying to throw Brian Steele in jail, it was this gentleman and Ashley Merchant who were fighting to keep him out of jail.
Okay.
And they actually won the day because what the judge wanted to do was kind of the same thing that maybe he might have said or not said to Woody about the indefinite incarceration. They explained, this gentleman right here and Ashley Merchant explained that it could not be an indefinite incarceration, that the most they could do was 20 days.
So what Kayla's explaining, this man here is Brian Steele's, this man here's attorney, and those other four people are representing her.
And so that's what the judge did. So they actually came in and they were a huge help in this case to Brian Steele. So shout out to him. All right, so let's sorry about that. Let's keep it going here. What do we got?
At some point after Mr. Steele was held in contempt by this court in the afternoon of June the 10th, it was brought to the court's attention, not at the court's request, by security personnel that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp. The court in no way sought.
All right, so he naming names. Hold up now.
You see Attorney Sharp lean in. That's so funny.
He naming names. Let's see what he said again, just real quick. Now he's like, I went and pulled the footage because I
What's
know.
the point? What
Yeah.
you know now?
Yeah.
And me and my lawyers are texting during this. I'm like, I know. And it's like, and I'm
wanna see the
also
tape.
texting Woody too. Like,
Hey.
Woody,
Hey, who want to see the tape? We want to see the tape of Kayla in the hallway talking to Brian Steele, Adams, and Sharp.
what I was saying.
Wow. Let's take a look specifically what the judge says about the pulling of the videos.
The afternoon of June the 10th. At some point after Mr. Steele was held in contempt by this court in the afternoon of June the 10th, it was brought to the court's attention, not at the court's request, by security personnel that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp.
Okay, so what the judge just said was, hey guys, I didn't request this information. I didn't tell somebody to go and pull it.
Yeah, you
Somebody
did.
just brought it to me.
He
Somebody
lied.
brought it to my attention.
Judge lying his ass, so he know he requested that footage. He was so mad he wanted. Y'all all saw. He was so mad he wanted to see who told on him, who told about the secret meeting, and you cannot convince me he didn't want to see that tape.
So it wasn't me, guys. Just somebody just went and pulled the footage, but I didn't have anything to do with it.
Yeah, right.
All right. So this is what the judge is saying. And this is the same judge that was so irate, so mad that he couldn't get the name of the mole. But he's not the one who pulled the footage. Somebody else just brought it to him and he didn't even know about it. Right. Supposedly. Let's go.
The court in no way sought to investigate any facts that is involving this footage.
Those
and
attorneys
only
are right.
considered it for the security and timeline of events that occurred on June the 10th of 2024. Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt. And as I said, mentioned it only for the purposes of considering the security and breach of information that occurred within the court's chambers, not for the whether or not that was truthful or not. Mr. Steele makes.
And before we do this, let me just give a big shout out. Just y'all know who she is. Big shout out to Thinking from Texas, Whitney. Thank you so much, Whitney. What does Whitney say? Great banter today. Lead and AV. Have a safe and happy 4th. Shout out to Miss Bumpus. All right. Houston, Texas represent. So somebody write Whitney in the chat, please, guys. Whitney, a huge supporter. She sponsored whole streams. I always say the stream sponsors the person who leaves the biggest super chat. Shout out to Talk That Law and Miss Whitney. So thank you so much. Let's keep it going here.
No, thank you, Lee.
Three is further made.
Lee, they say I'm stealing your money over here, man. What's going on? And hey, if y'all want to go over there and contribute and go to his stream, y'all more than welcome to do that. I'm not holding y'all here.
3 assertions on the 10th of June of 2024. One, he asserted that this was, on behalf of Mr. Williams and similarly situated individuals, that this was the court held an improper ex parte meeting. Secondly, that Mr. Copeland.
Let me stop it right there. Do you believe, either from the prosecutor side or from the defense side, that this was in fact a quote unquote improper ex parte meeting? And I think you're muted, Kayla.
I'm sorry, repeat the question.
Yeah,
I'm reading everybody's comments. I got
no,
lost.
let me go back so we can hear what the judge said.
Mr. Steele makes further made 3 assertions on the 10th of June of 2024. One, he asserted that this was, on behalf of Mr. Williams and similarly situated individuals, that this was the court held an improper ex parte meeting.
Okay, so let me stop right there. Do you believe, as Mr. Brian Steele has asserted, that this was a quote unquote improper ex parte meeting? Do you think that this was a improper meeting?
Well, I think that because he was a sworn in witness as of Friday, I don't think that he was supposed to be in the judge's chambers having a meeting because of the simple fact that he was a sworn in witness who had started to testify.
So you would say that this is an improper ex parte meeting?
Yes.
Yes. All right, let's keep it going here.
At the very least, I agree.
Secondly, that Mr. Copeland was a sworn witness and
Just what you said,
this was a critical stage. And no, Mr. Copeland was a sworn witness. And third, that he argued that this was a critical stage and that he and the others needed to be present at that point in time.
Thank you.
All right, so let me stop it right there. You are a defense attorney now.
Not no more.
If you were representing someone in a similar situation, would you consider the ex parte meeting part of this critical stage that they're talking about?
Absolutely.
Can you kind of explain to the people a little bit about why the critical stage, or what is a critical stage, or why it's kind of important?
Well, a critical stage is kind of just any stage throughout the criminal proceeding where you have certain rights and rights that have to be protected. And I guess what they were saying, the defense attorney, was that, and that's one of the questions that when we were sitting talking is that the attorneys asked themselves, among themselves, is this a critical stage?
Oh,
like
really?
And I thought that was really interesting when he said it, because I remember, I guess, in preparing their arguments, that's like step one. Is this a critical stage? Because if this is a critical stage, then there are certain things that have to be done. And I think that their biggest thing was, since this was a critical stage, that the defense had a right to be present.
Yeah. So if it's not a critical stage, then maybe he doesn't have a right to be present. And if he doesn't have a right to be present, maybe nothing's going on.
Exactly. Yeah. So it's kind of like the foundation to some of their argument.
Yeah, because he came out with like 3 or 4 cases just on that, just a string of cases when he was explaining himself on what a critical stage was. Because Brian was also arguing to have you know, if he was going to have this in camera, to see if Young Thug can be invited into the room, right? And the judge is like, no. So it was interesting, but he definitely spent some time today talking about that as he was explaining what was going down.
100%. 100%. AV is exactly right. Let's keep it going.
To pursue the sixth. Now, Mr. Copeland's a sworn witness, and third, that he argued that this was a critical stage and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any procedural, substantive, or tactical advantage as a result of the ex parte communication. And the judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives the parties an opportunity to respond. And in this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver. And all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will be e-filed, so everyone will have a chance to take a look at it. And
all right, so we are going to get the transcript, and it seems like it's going to be filed in today, guys. It's going to be filed in today. This is so juicy. Let's go.
Use it as they see fit.
And the judge also said that, you know, it can't be that there's this ex parte meeting and then one of the sides gets a benefit or an advantage. Do you think because of this, you know, 2+ hour meeting that the prosecutor got an advantage or a benefit from this meeting?
I mean, they got. I can't say, because like I told even Woody, like, he could have sat in jail for 2 weeks and then decided to testify. I mean, that we don't know what would have happened. I mean, I can't say.
Yeah, but it's clear that the state wanted him to testify, right?
Right.
And then because of this meeting, they got him to testify the same day.
Right. So the only benefit that I can 100% say is that, you know, the timing, they got it right then, but I can't say that he would have never testified.
Right, because you don't know if Woody would have sat in there for the whole 2 years or something like that.
Well, the 2 years was something he made up.
When you say he, who is he?
He just said, can he sit in jail for 2 years? Like, that's something that's why I say we have to go through the transcript, because the 2 years wasn't anything for real.
Oh, that when you say he made up to 2 years, you're talking about Woody made up to 2 years.
Yes.
Woody said, I'll sit here for 2 years.
Yeah.
Got it.
Gotcha. And then the judge and the prosecutor's like, 2 years? Where you get that from?
Yeah.
Got you. Okay, let's keep it going.
In this particular, and then the last part of 2.9 before the court goes on, if involves impertinent part, if a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. And as I mentioned earlier, I'm going to release the entirety of the transcript to you all to use as you see fit, and before any other further examination of Mr. Copeland.
All right, so we're going to get the transcript, guys.
I'll address the issue of the emergency nature of this particular hearing, or this particular conference in front of the court, is that this involves the state's concern as to what Mr. Copeland was in fact told by his counsel, Mr. Melnick, and his understanding of the immunity agreement pursuant to 24-507, and that the conversations that were had in the transcript will bear out that no tactical or other advantage or any testimony that was stated during that particular hearing would be anything other than the court and or the state communicating, along with Ms. Bumpus, his lawyer, who's there the entire time, his witness's understanding of his immunity agreement. In consideration of this emergency nature, the court has taken into account a couple of cases I'll cite for the record. One of them is United States versus Adams, and that's 785 F threats against the witness is proper. District court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. Presence of the accused. Ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal was not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed.
All right, so let's stop it right there. What the judge is saying is like, listen, I found.
All right, for those jumping in, we're just streaming to listen to Kayla, and this is going through the Leeds channel. We're doing it under fair use, so if y'all want to go over there and support him or watch it there, y'all more than welcome to. And yeah, the judge, he's paused court indefinitely. He's saying that the motions have to go to another judge, and the judge from another court will decide if he stay on the case. So until that happens, the judge is suspending all court proceedings. So we may not even start trial on the 8th. We might be stuck here for, the jury might be stuck at home for a while. And the prosecutors, Ms. Hilton, she's concerned that if the jury sits at home for this long period of time, she could lose the jury. Shit, let me tell it, excuse my language, let me tell it, she already lost them. The jury been checked out. And I want one of these guys, if we can get Car Global to come up here after, at the end, they can get up here and defend his position. He's taking up for the prosecutor, so I want to know why. Let's go.
On the case where a judge, the prosecutors, and a witness were talking in the chambers. And the appeals court said that was okay because none of the witnesses' testimony was brought up in the hearing. So not the sum and substance of what he was going to say on the stand was brought up in the ex parte meeting. And I know this meeting was over 2 hours, and I think your advice about waiting until the transcript comes out, Kayla, I think is spot on, because that's really going to help everybody and clear. But just as you sit here today, do you remember if any of what Woody was going to testify to, if that was brought up in the meeting or not?
No, I can't.
And if you don't remember, that's fine. I'm not trying to.
I mean, he made several. I want to see what the transcript says, and from there, I'll fill in the blanks if that's fair. Because if there's an hour,
Kayla's a smart girl. Kayla want the transcript before she really say what happened. She wanted, to make sure she got her story straight. Yeah, so I don't blame her. If anybody can get their hands on that transcript before my sources can, send it to me. My email's in the description.
We're missing, then I have something to say for sure.
Okay, I got you.
But also, I want to say that one thing we may have missed this part, but I actually got to go to court in a second. But I do want to say this: I never felt like Woody was threatened or felt like he was threatened, or that I didn't understand that part because, and I just don't understand where that came from.
Oh wow! Okay.
Threatened? How so? What do you mean threatened?
He says that's why it was an emergency because he was not safe.
Oh, okay.
So what Kayla is saying is the judge read a lot of case law. The judge is saying he can have a secret meeting if a witness feels intimidated or threatened in jail. You can have a secret meeting so they can get moved to safety. But Kayla is saying that's not the case. So she don't know why the judge is saying that Woody felt threatened. The only people he was threatened by was the prosecutors and the judge in the secret meeting.
I don't know if we've gotten to that part yet.
Okay,
Maybe we get to it. But here's the thing. I know you got to go to court. I know how that is myself. So I want you to be able to make it there. Well, before we do that, can you just give us your final thoughts on this before you go? Your final thoughts on what the judge ruled today, how that makes you feel, and kind of what you're thinking about this situation now with the help of this new information that we've gotten.
I just think that, my final opinion will come when I see how that transcript comes out. Because that will be really the integrity of the court. And I'm very interested to see, because the times I can't say that they're incorrect because I wasn't sitting, waiting, looking at the time, but I know how long I was in there and I know what happened while I was in there. And also I think that, there were some, nudges for him to dismiss this. I don't think this is something he did on his own accord
Okay,
or of
but
his own. I
Mm.
don't
When you
think
say
he
his,
just,
you're talking about Judge Glanville?
yes.
Mm.
I don't think he just woke up and decided. I think he was even torn to the point where, we had this hearing for how long, how many days?
Yeah.
And then
Yeah.
you have us sitting. That's why I didn't come, because I would have been so upset. Because then
You had to come in for July 3rd, and he's like, "Oh well, we're canceling it today." Like,
Yeah.
no, but even today, you know how you have these people just sitting in a courtroom, and you're still trying to figure out what you're gonna do. Why? You had a whole weekend.
right,
thank you, Erica.
And
right.
and I just think it's because he realizes that it's not right, and he doesn't know how to fix
The
it.
pressure on his ass.
He kind of stuck in it, huh?
And I don't think he thought. I'm gonna be honest. I'm not trying to. I'm gonna say this in the most humble way
He
possible.
got
I
this
don't think he
big.
thought that I was gonna lawyer up. I think he thought he was gonna bully me. And I think all of my lawyers are great, and I think they all have, different things that they brought to the table. But one person who I knew he wasn't gonna play with was Gabe, and because and that's what Gabe brought to the table for me. He's very smart, but Gabe was a prosecutor. He knows about the ex parte situations as a prosecutor, and that's what I think was really important to me initially when I'm a baby lawyer compared to most of these people. They've been practicing as long as I've been alive,
Mm.
definitely double the amount that I've been practicing, but so you don't know everything. And so initially I was scared, like, did I do something wrong? I mean, because how he acted, I was scared. It's not that I thought I did anything wrong. It's just like, because of how angry and upset he was, I was confused. So I spent days, constantly calling him like, well, what if this happened? Or what is this? What could happen?
Mm-hmm.
Just because, like I said, anything goes in there.
Anything goes. And he'll just say, listen, I'm going to put you in jail for 20 days straight, and then you can appeal it later. But you
Yeah,
the 20 days,
right.
That is
Kayla's
exactly right.
But
All
I
right.
also thought it was interesting that why would you continue? I think the show call should have never. It should have just. I was shocked when he changed the date instead of just letting it go the first time.
Yeah.
Mhm.
Because if the Supreme Court already stayed Brian Steele's and it's the same matter, what do you think is gonna happen even if you do that to me? And it's just like, do you just want to keep being embarrassed by the Supreme Court, or what are you doing?
Yes, yes,
That's
you're
a good
exactly
point.
right.
That's a
And
good
to your point, when the Supreme Court came down, I think everybody sensed a huge change in his demeanor. He
Mhm.
was much more subdued, more subtle. He wasn't getting crunk like he was before.
Right.
crunk.
So I think you're exactly right. All right, guys, listen, if you are in these car accidents down here on 285, I-85,
Yes.
75, I-20, right? Or if you get jammed up and the police are trying to put handcuffs on you, please call Miss Kayla. If you're anywhere around Atlanta or the Houston area, Kayla, tell people where they can contact you most easily.
Oh,
Instagram.
And if
yes,
you got
you
your
can.
social medias.
Yeah, you can go on my Instagram. I've been trying to respond to people's DMs. It's so many. Um,
Mhm.
but yeah, and once you go to my Instagram, you definitely, my phone number and everything is on there. And I guess you
Got
can
you.
put my Instagram in the
I
chat.
absolutely will. And what is your Instagram name?
Bless Squire.
Bless Squire. Excellent. So we are going to let Kayla go to court. Somebody write Kayla in the chat. And thank you so much. You are really, there's so many heroes coming out of this case, so many. And you are absolutely one of them. And you really showed the judge kind of what the deal was. And I know it was looking real sketch, but you have finally won. You have made this judge kind of go back on his own word. The judge had to eat his hat. So somebody shout out Miss Kayla
But I might
Bumpus.
still have a battle with the bar now.
No, you got they're gonna rip it up like they're gonna be like, oh, Judge Glanville, we definitely ripping this up.
Yeah.
Definitely ripping this up. Please come back when the transcript is filed because we want to go through it and kind of get your take on it. And I appreciate your stance of kind of waiting until the transcript comes out because that's going to have everything exactly word for word in this meeting that was over 2 hours. So please, guys, go to Miss Kayla's Instagram, give her a subscription or a follow over there, whatever they do over there on Instagram. I'm not really big over there. but follow her. And especially if you get in any type of legal trouble, call her up. She will absolutely take care of you. One of the heroes of this crazy case down here in Atlanta, Georgia. So thank you so much, Miss Kayla, for coming through. And we look for you to come back when the transcript hits. All right.
Okay, just let me know.
Yes, ma'am. Thank you so much, Miss Kayla.
Thank you.
All right. Shout out to Kayla Bumpus one more time.
All right, y'all. All right. So y'all can go over there if y'all want to finish watching. But that's pretty much it on that. That was the lead attorney's stream. We just live streamed it here through fair use. So we can get Kayla's reaction. The judge said, Kayla, on Wednesday, you don't got to go to jail. I'm a backtrack. I'm a moonwalk. Because I know I was wrong as hell, and now the pressure is on me. The fire is hot. Hey, I'm going to drop the link. Anybody want to come up? They got a camera and a mic that have any opinions on what they think so far. Come on up here and talk to me. We have some people in the comments saying that let me clear this up. I donated, I'll say this again, to Lee, to AB, and to Kayla while they were on the stream. So I'm not trying to take anything from them. And trust me, I'm not making none of that over here. So y'all say, I'm making this money still in it. No, it's not that. And obviously, out of respect, if Lee or AB, have an issue with it, they can just hit me up and I'll take it down. But like I said, when Kayla was over here talking, people shared it all over social media, not just YouTube. And I had no problem with nobody doing that. I didn't issue any copyright strikes and none of that. So I just wanted to let y'all know that for the people that's popping in here saying I'm taking food out his mouth. Hell wrong with y'all. But yeah, so anybody want to come up? Nobody's clicking the link. Y'all had so much to say in these comments. Y'all wanted to, let me see. Let me put it again. Maybe it didn't go right. Oh, we got somebody. Well, thank you, Minister Fears. You can donate through YouTube. We also have a Cash App, Talk That Law. Let me see if I can find that banner. And it's not mandatory if you, if you want to. That's great. Thank you. Oh, where'd he go? Wait. Yeah. But thank you so much, Minister Fears, for that consideration. Okay. Wait, we had somebody in the somebody had just came up, and I guess what happened? Hold on, let me redo it. So the judge right now, he's at a standstill. He said nothing else is going to happen. Oh, shout out to Australia. Thank you so much, Miss Sue. I think that's some Miss Sue. Dun, dun, dun. Okay, let's see what we got. Hey, how's it going, Mr. Michael?
How you doing?
I'm doing well as I can be. What's your take on this so far?
Well, the judge finally got humbled. I think that's the main thing. He finally got humbled today.
Right.
And he's been I won't say a bully, but he's definitely oversaturated the prosecution with power that they normally wouldn't get in another courtroom. I think he's taken it a little too far. I mean, it seems like Brian Steele and the rest of the defense has not been able to file a proper motion or a proper, what's the word when you chime in when the witness is testifying?
What do you mean? Like objection or
Objection,
what do you mean?
Yeah, it seems like he thinks Steele and the rest of the defense never has a basis for an objection.
All right. Yeah, I agree. It's been crazy because the judge has been anything but fair, in my opinion, since the trial started. And some people even suggested that the prosecution, they went judge shopping. Like they intentionally picked this judge for this trial because they know how far they can push him and how much pro-prosecution he really is. So
and it showed over and over again.
Right. It got to the point where he couldn't even hide it.
Yeah.
Like
the world is watching now. He always telling the lawyers that the world is watching you, but we've been watching him the whole time.
And I found it funny today. A lawyer, she represented one of the co-defendants, Sergio Kitchens. They call him Gunna.
Yes.
He's a rapper, and he's saying, "But now you're in my courtroom representing Caleb Bumpus, Woody's lawyer." And it was funny to me that he said that that's a conflict of interest. Why are you here?
Yeah.
And she basically said one has nothing to do with the other. And it's ironic that he's calling out conflicts of interest without looking in the mirror his own self.
Yes, and he's been the definition of conflict.
Conflict, right? I found that so funny that he don't say that.
Yeah. Can I ask you a question?
Yes, sir. Go ahead.
I mean, I obviously you're the expert on this, but how the way they are doing the last week or so, where they're going through Woody's transcripts that he gave in previous interviews, and trying to parse different information on what they want to use going forward.
Right.
Is that standard procedure to stop a trial, to go through previous transcripts in order to assert them?
No, normally, like if I was to have a trial and we know it's going to be extensive, we would do that in what's called pre-trial, before trial.
Okay.
Like, hey, judge, we got all these tapes. We need to work this out before the jury gets here. Because the last thing you want is the jury sitting at home for 2 weeks, 3 weeks. They're going to forget most of the stuff that the prosecutors are talking about, which might be a good thing for the defense.
Yes.
I mean, yeah, if you say they don't have a case, ain't no sense of them remembering, because it ain't nothing to remember. There's nothing there. But normally we would do this before the trial happens. We'll go through all the videos. I had a case we had to go through. We were writing down the timestamps. And if we couldn't agree, then the judge would be the referee. But obviously this judge is no longer a referee. No, he took off his whistle and his referee jersey.
He got a helmet and all.
He got a helmet. Come on here.
Put a P on the side of it, or an F that says Fanny at this point. I mean, it's ridiculous.
Man, it's crazy. He literally joined the other team, but now all of a sudden he wants to go back to being a referee. We can't trust you now.
Now I'm gonna send it to another judge at this point. Now, Mr. Steele, I agree with some of your arguments all of a sudden since the Supreme Court came back and made that ruling.
Yeah, and I don't think he's doing this out the kindness of his heart.
No, somebody got into his ear.
Yeah, and he's slick. He said, I don't want to do 3 separate orders here because I don't want it to go to 3 separate judges. I want this all to go to one judge. Judge, do you already have that other judge in mind that you want these cases to go to? And like I said earlier, that it might be a conflict because he's a chief judge.
So does it stay in Fulton, or does it go to the prosecuting attorneys and they ship it somewhere else in a different jurisdiction?
No, so it won't leave the prosecutor's office. So what we're trying to figure out right now is, can another judge decide if this judge should be kicked off?
Oh, I'm sorry, I phrased that wrong. Does it go to a different county, or does it stay in Fulton County?
It's staying in Fulton County right now, and I think that's a bad thing because he's the chief judge. Even though they're independently elected, he still can indirectly, make their life a living hell. Yeah. So if it goes to one of his, counterparts, and they decide to kick him off, then they got to look out for their own selves. Like, what's going to happen to me? Well, would he come after me? Would he, assign me to, I don't know the how much authority the chief judge have, but would he try to get, one of his friends to run against me in the next election? It's so much that can happen when you are trying to go up against a judge. So I think they should have moved it to a different county where he can't reach. His reach don't go that far.
Yeah, well, can they do that legally? This time, or they got to wait to appeal to go to?
No. I think that the legislature would have to literally change the law, because I don't think the Supreme Court is going to rewrite the law from the bench. But the Supreme Court has essentially said anybody can appeal. So when it goes to the next door neighbor judge and that judge decides to kick Glanville off, then Glanville can appeal and say, hey, I want to be put back on. Or if he don't get kicked off, then the defense attorneys can appeal to say to the Supreme Court saying, hey, he needs to go.
So when would the Supreme Court actually get a chance to hear this?
So I think the Georgia Supreme Court should hear this as soon as it goes to another judge and that judge makes a ruling.
Okay.
The only thing is, if that other judge, sit on his or her hands for, a while, it's going to be an issue because the Supreme Court is only in session certain terms, right? So if the term is over, then you got to wait till the next term. If that term's over, it could be to next year.
So what happens with the trial in the meantime? Does it stay halted until they can sort this out?
From my understanding, the judge said today, and then somebody can correct me if I'm wrong, that he don't want to do anything. He don't want to move forward with the case until that issue is resolved. Which kind of makes sense because, why do all this work for the next week or two and you might get kicked off?
No, I'm saying once the judge decides on the recusal one way or another, does that keep the trial on hold, or does the trial start back up and they start appealing at that point?
Well, that's going to be interesting if another judge can come in so late in the trial to finish it off, because a new judge is not going to know, all of the facts or remember why certain things was kept out in the past. And to bring in a fresh judge, it don't seem like it's going to be feasible to me. I think at this point, it's going to be dead in the water.
So they're going to stick with Glanville more than likely.
They can stick with Glanville, and if they do, then go to the Supreme Court, and the Supreme Court can kick him off. But then if the Supreme Court do kick him off, now it's going to be like, okay, what do we do now? do we start over?
Yeah.
Do we dismiss it with prejudice? That means it can never be filed again. Because sometimes it happens. If a judge, prosecutor, if they're found to be any wrongdoing, then the higher court, the appellate court, can say, you don't get a chance to have another bite at the apple. Okay. You don't get the chance to mess up this trial and then think you get to start all over again. So they could dismiss it for good, or they can just dismiss it regularly, and then Fonnie Willis and her team will have to decide if they want to retry it. My guess is they better not.
Well, that's another question then. Okay, so these 6 guys still on trial. What about the other guys who are waiting for trial? Does that affect them as well, or it doesn't? If the case goes away against Thug, what about the rest of the defendants still waiting?
Well, that's that's interesting too, because they just had a hearing. Was it last week? And most of them guys said they want to go to trial.
Exactly. Yeah.
They said, and I don't blame them, because now you're looking at the prosecution, they so weak. See, back when it first started, they were strong. Okay, we're gonna lock you up. We got evidence. But as they go, further and further, now the other guys are saying, hold on, they don't even have a case against Young Thug. How are they going to try to prosecute us?
They haven't had a good witness yet. I mean,
right.
On there, it's been horrible. It's terrible witnesses. I mean, they haven't fact-checked them. They haven't vetted them. They haven't done anything to make you think this is a believable person at this point.
Right. And I don't think Woody, I don't even think he's going to cooperate when he come back. I mean,
You heard about what happened over the weekend, didn't you?
I've heard a little bit about it, that somebody supposedly passed away that was close to him.
Yeah, in his apartment, allegedly.
They ran in his apartment.
No, they didn't run into it. What the rumor is, rather, what they had on the news is somebody shot at where Woody was staying at, and somebody unfortunately got killed. So.
Woody was there.
No, Woody. They haven't said if Woody was there or not.
Oh, okay, but he was staying there. He was living there.
He was living there.
Oh wow! So do you think he might have been the intended target?
I don't want to speculate on anything like
that. Right. We don't know what we don't know.
Exactly. Speculate on that. But Woody, I haven't heard anything where Woody has said anything that really implicates anybody.
Yeah.
He's told the line just good enough to make sure that I don't implicate anybody and I keep all the attention on myself. So Woody might not be as crazy as we think he is.
I wouldn't be shocked if Woody come out clean on the other side.
Yeah.
But he's just gonna have to get out of Atlanta, because if the streets, don't get him, or looking for him, then it's gonna be that DA's office.
Exactly. Yeah.
And I think he get any little case, I think they're gonna throw everything they have at him, including the kitchen sink.
Woody, he's told the line. He's done a good job at towing the line. I haven't heard him implicate anybody. And I guess on this immunity type thing, so you can say what you want to on an immunity deal, and they can't get you for perjury either or anything like that.
Well, immunity, it doesn't cover perjury or false statements.
Oh, it
But
doesn't.
that's why we need the transcript, because according to whoever the leaker was, Woody was told by DA Hilton, you got permission to lie. Go ahead and lie. Tell all the lies you want. I'm not going to prosecute you. But she said, but if you lie about this one particular thing, then I will prosecute you. That's the only thing that you can't lie about. Anything else you can lie about.
Yeah.
So, if that comes out on the transcript, it's not going to be Caleb Bumpus that have an issue with the State Bar of Georgia. It's going to actually be Hilton.
And love.
Right. And I wonder, because when the judge read the name, it seems like Love was there in the room first, and then the second time it was Hilton.
Yeah.
So I don't know if they were ever there together, but somebody pointed it out earlier. DA Love, she been sliding back little by little. She ain't crazy. She see that water is filling up in the boat, and she gonna jump ship before it gets to God.
Does a prosecutor get this much leeway that Love has had? Love has had a lot of leeway in this trial. I mean, more than, I guess I look at too much Law and Order where the judge always checking the prosecutor and the defense, but Love has been unobstructed this whole time.
Oh yeah, somebody. I don't know how true this is. Somebody say Love looked like the judge's wife. They say when he look at her, he see his wife. He said, I can't tell my wife. No, he said he wanted a happy wife, happy life.
Yeah. She's had a lot of leeway, and then she misrepresented the state on so many occasions. It's like, wow, what's the reprimand, or is it ever going to come at some point? But it hasn't.
Right. I don't think nothing's gonna happen to her, but I think she's smart enough to see the handwriting on the wall.
Yeah.
Before it's wrote, now all of a sudden she can't be there. She got other cases. She's busy. She this and that. Now she's distancing herself away from the BS because she knows what's coming.
Yeah. And the judge, I'm not sure how old he is, but he was a general at one point in the and he had his own law firm. So at this point, I guess, in my personal opinion, he doesn't really have much to lose per se.
Yeah, that has been argued that he's at the retirement age, and some people say he was a 1-star general. I don't know if it was in the Army or the Reserve, but supposedly he has PTSD.
He had a service dog, yeah.
He had a service dog, and I'm like, Judge, if this too much stress for you, go home.
Yeah.
And go to
He's had some episodes where he might come across the bench and attack someone.
Right.
So always locking horns. That's been classical with him and Steele. They've been locking horns quite a bit.
And it might be time for him to hang it up and retire and take his dog to the dog park. Go throw a tennis ball.
Yeah.
Because you're playing with your dog in the middle of court, and while you're doing that, you're playing with these people's lives, and they've been in jail for 2 years without bond.
Yeah. Now, how common are those comfort breaks he gives? Because he'll say it's gonna be 5 minutes and it'll be an hour. He said we'll be back in 10 minutes. They're gone for the rest of the day.
Right. And we don't know. Some people are speculating he's in cahoots with the prosecution. He's been giving them signals. We don't know if the prosecutors need more time, to get their questions together. If a witness is not being cooperative, then they may say, "Hey, Judge, take a long break. This one, nudge him on the shoulder."
Yeah.
They say, "Hey, Judge, we need more time. Woody not acting right. We thought he was gonna play ball, and now he not. So we don't know how to pivot." And DA Hilton was trying her best, but Woody wasn't giving her an inch.
Well, yeah, he's taken a few phone calls during the trial. I've seen with the flip phone he has in front of him. He's taking a few phone calls right while the trial is going on. That's highly unusual.
I seen a judge literally. I remember at the beginning, they were asking questions and the judge disappeared off the bench.
Yeah, he was.
I said, I ain't never seen it like this. While the trial's going on, the judge is not even up there.
Yeah, he's unique.
Now, I have seen judges on their phones, and to me, in the middle of trial, it's really not a big deal unless we need the judge. Because a lot of times when two teams are playing against each other or a boxing match, you want the referee or you want the judge to stay out of it as much as possible.
Mhm.
I mean, you don't really need the judge unless you need the judge. So, you know, being on your phone, that's not an issue to me, you know, per se, because I practice. I know judges, they've been in the courtroom 40 years.
Mhm.
They didn't hear everything under the sun. These cases get boring, they're repetitive. It's the same facts, it's just different, you know, different names. So I'm not, you know, big on that. But as far as the judge just leaving completely, that was just strange.
Yeah.
That was strange.
And, on another instance, Mr. Adams was asking a question, and I can't remember if it was Love or Hilton objected before he even asked the question, and the judge ruled on that. He was so used to overruling the objection or sustaining the objection, he did it before the question was even asked.
Oh yeah, he did that a lot in his tone.
Yeah.
See, when the court reporter is typing down, she can't type down tone. But the way he was like, you know, you could be rude to somebody without the appeals court knowing on paper. He'd be like, "What's your objection, sir?" He made you can tell he sounded annoyed.
Yeah.
And then overruled. And the way he said it with so much force is to let them know, don't keep objecting.
Exactly.
Because I'm going to keep overruling it without actually saying it, you know, because the court reporter's typing her notes down.
Yeah. I've never seen a judge like this, and oh wow.
But we're supposed to be getting the transcripts, and hopefully we get them.
I've been looking for them too. So somebody's gonna post them at some point. And
Right.
I saw that you had Miss on there, and hopefully, you know, you can get her on at some point to kind of set the record straight.
Right, I'm gonna reach back out and see if she wants to come back. And obviously, she has her pick now. She everywhere. She all on you know. She everywhere. She didn't blew up. She's all you know, you too light. You too light. I need at least 10,000, you know, 20, 30,000 watchers. But she might come back.
No,
but
you were the launching pad. I remember a couple of weeks ago when you first had her on, you were the launching pad, and she wanted to find somebody who was reputable to bring on.
Right.
So I appreciate you doing that.
Oh yeah, yes, sir. Thank you for saying that, and hopefully she might come back, and we can go through some of the questions, because I know the people want to know, but it makes sense if we read the transcript first, then we can formulate our questions better to ask her.
Exactly, yeah.
Because right now the judge is painting her in a bad light. He said he's gonna do like a bar complaint against her. She was talking to her client for an hour by herself, so that's attorney-client privilege. She's on video after that talking to defense attorneys. So he's trying to make it seem like Kayla, you know, took all this information and ran with it and told the defense attorneys that I don't think that's the case.
But okay, I mean, hypothetically speaking, I mean, if you were a part of a defense team, can't you confer with them after this type of meeting, or you can't?
Well, the thing is, she's not part of the defense team. She represents Woody, and Woody's not a defendant.
Okay, I got you.
She just represents him as a witness.
Okay, I got you.
Now, if it was, you know, Brian Steele or Keith Adams, one of them, then they can go back and talk. But she really has officially no interest to protect when it comes to
anybody
none of them. Yeah, so hopefully we can get to the bottom of it. The judge it's crazy that he didn't say anything that happened on the transcript. He gave us timestamps. I want to know what they say.
Exactly, yeah. I mean, like,
it's like he just right. It's like he just gave them to us, or he's gonna give them to us, and he's gonna be at home. Like, here y'all go. I'm gone.
Yeah. He folded. I mean, he folded today. I mean, he folded like a cheap tent. All of a sudden, he just caved in and say, I'm gonna give the transcript to you without any redactions. His stance the last couple of weeks were, I might give you a redacted version. I might give you all or some of it, whatever I think is relevant, whatever I think is Brady material. But today he just caved all the way. That I didn't see coming.
And I don't know what his motive is. I don't think he's doing it out the kindness of his heart. No. I think his hand has been forced.
Yeah, they forced it. The Supreme Court down with that ruling, and it was like, you did everything wrong. Here's the roadmap to correct yourself.
So I'm wondering now if he's trying to show a little bit of goodwill to the Supreme Court. Like, hey, I gave them the transcript that they were asking for. Let me stay on this case. Now, you gave it to them how many weeks late?
Yes.
So I mean, you can't really just try to use that now. And I think that's what he tried to allude to. We're required to give the the transcript over, and that's what I'm doing today. No, but you late. So I think that he really got himself between a rock and a hard place, because there's no way he can really survive this. Once you join the other team, you cannot come back.
Yeah, now he's a party opponent at this point.
He sure is. That's why they would have put him on the oath.
Yeah.
Brian still said, "I'm gonna call you as a witness." That's something I do. Just I get a subpoena for the judge. Hey, Keisha, do you have a camera? You want to come up? Yeah, there's somebody else that jumped in the back. I didn't know she. Yeah, but that's where we're at. I'm really curious now about the Woody situation. Woody.
Yeah, if he's going to come back to testify at any point. I mean, because the judge made it clear today that Woody can't come back until this is sorted out. There can be no further examination of Mr. Copeland.
Right.
Yeah.
And that's going to be crazy right there.
Now, as far as the parte meetings, is there a transcript for them, even if the judge keep them private, or at some point could the defense always ask for it? Not in this case, but in any case.
Well, it sounds as if the judge said that Kayla separated with Woody and they had a private discussion for like an hour and 11 minutes. And Kayla said today on Lee's channel, she don't think that that's accurate. And that don't really just sound like all that accurate to me as well. Because if you're in a room full of people and they all trying to figure out, what's going on, I can't really see her and Woody going to the corner for, an hour and 11 minutes while everybody else is still in the room.
Yeah, that doesn't that sounded extreme.
Yeah, that's like
not impossible, but highly unlikely.
Highly unlikely. Yeah, it would have been better. Now, if they went to a private room and they can sit down and talk, then okay, that's more plausible. But for them to just have a whole private discussion while all of those other people are still there is beyond me.
Yeah. Wow.
Somebody said,
but Adrian Love, in my opinion, put Glanville in this spot by being the bully that she's been through the trial, doing everything incorrect, and it caught up with him at some point. It finally came to a head, and still, recognize, hey, you can't do this. You've done everything else wrong, and now all of a sudden, we got you in a situation where you can't talk your way out of.
Right. See why I said it's Woody, not Woody. Yeah, I agree. And the judge, he's military.
Yeah.
So, and not only that, a general. So I'm sure he's used to pushing others around or not getting pushed around. He wouldn't have made it that far. Exactly. So if you can handle the military, surely you can handle one woman, DA Love.
Yeah.
I mean, surely.
Yeah, and he was in Afghanistan and Iraq in the second go around. So yeah, so he's definitely used to battle. And what Love is presenting is, it's a cakewalk to be able to stand up to her. So it just seems so. It seemed like he's just wearing the uniform, like you said. He got a big P on his chest. I mean, he just down with the prosecution. It's so obvious to where everyone sees it. I haven't seen a lawyer or ex-judge or ex-prosecutor come on and defend his behavior at all. I haven't seen anybody to defend it.
Yeah, I haven't seen anyone neither as far as a legal, somebody that's a legal scholar or in the legal field that's saying, okay, what the judge did is the right thing. I couldn't find nobody. The song said I searched all over. I went to the highest mountain in the lowest valley, and I still couldn't find not one. Nobody that could stand with the judge and say he did the right thing.
Just one, you could find one person to carry his Kool-Aid at one point.
Come on here. Not one.
Nobody but Adrian Love, the judge. But what was funny to me is when Steele was held in contempt, and she tried to defend Steele briefly, saying that Mr. Williams should still be entitled to his counsel, and maybe the state can work something out. And the judge kind of listened to her and brought Steele back out after that.
Well, yeah, but to me, that wasn't that. She wasn't being nice protecting Brian Steele. This is what she was doing. So we know that young thug Jeffery Williams has 2 attorneys, Brian Steele, Keith Adams. And when Brian Steele went into custody, Keith Adams said, I will not continue without Brian Steele. Mm-hmm. And so he essentially said, young thug is not going to have any lawyers here. If you lock up Brian Steele and Brian Steele said, I'm not, Keith Adams said, I'm not going to participate, then young thug will be left with no attorneys. And if young thug has no attorneys, the trial cannot go on. It's a mistrial. So what she did was, to save her trial, she told the judge, hey, judge, we don't have a choice. Because if you lock up Brian Steele, Keith Adams saying he's not going to participate, so you got to bring him back. She said, but you can still hold him in contempt. And that's probably how they came up with that weekend stuff. You can still hold him in contempt, but just don't do it right now because we're going to lose this trial. And the judge is like, well, he's blackmailing the court. He's blackmailing the court.
Yeah, Adams said, I'm in possession of the same information.
The same. Exactly. So I think Love didn't do that out the kindness of her heart. She did it because she didn't have a choice. And the judge didn't have a choice at that point, unless he wanted to, lose his trial as well with a mistrial.
Now, could that actually happen to where the, let's say, for instance, Keith Adams or a multitude of those other attorneys would have said, okay, we taking the same stance, Mr. Steele, hold us all in contempt.
Right. Well, then what you going to do? The trial's over. Because even if you try to bring in new attorneys, those new attorneys would need a whole lot of prep time to get caught up to speed and go through all the discovery evidence. And that may take a year. So the trial is over with. So the judge, was really, his hands were tied. And he didn't want to show it. He still was trying to act bad. But I already seen it. I was like, dude, there's nothing you can do.
Well, Ashley Merchant came in. I actually love Merchant. Merchant told him, the judge, you put him in this situation. But he claimed Mr. Steele put his own self in that situation. But we all saw what was happening. I mean, the judge, he's taken too many leaps of faith that nobody is going to correct him. And he's done it over and over again. But we'll just leave that up for review later on. We'll let the proper, party, review this down the road. I mean, he's constantly taking that approach.
Right, yeah. He's saying, I might be wrong. And half the time, I believe he know he's wrong. But what he's saying is, but what he essentially saying is do something about it. Appeal it at the end.
Yeah.
When the trial is over with. And by that time, obviously, if Brian Steele was in jail for 20 days, even if he appeal it at the end, he'll never be able to get those 20 days back. I mean, just like Young Thug won't be able to get these 2 years back. So I believe
the jury members, what about them? Like, their life is, I won't say it's been altered drastically at this point. I mean, there's no way to make up this time that you spent in this courtroom. And if you live in Fulton County, the traffic is always horrible getting to court. So you got to base your whole life about getting to court on a daily basis like it's your full-time job. I mean, and then you have to get there and sit for hours at a time because they're always having these debates and hearings while the trial is going on. It's terrible.
Right. And I'm wondering if when they got on this case, they probably thought like, oh, hey, this is going to be a big trial of the century, and I'm going to be making history. But now they probably like, what the hell I got myself into?
Oh, no. Remember, it took, 10 months to get a jury?
Yeah, I think so. Yeah, about 10 months.
Huh.
So
how does that, is that normal? Have we ever seen that anywhere in America?
Right, unheard of.
Yeah,
unheard of. I mean, even if you want to take for reference the Trump trial that just happened in New York, it didn't take them no 10 months.
They had a jury in that Trump trial, which surprised me. They had a jury in less than a week.
Yeah, they had a jury.
Yeah,
now it don't have to be as short as a week, but even if it's 2 weeks, it shouldn't take 10 months. Right. But now we see what the holdup was, because this judge take more breaks than a little bit.
Yeah. Wow.
He can't sit still to save his life.
We need a comfort break. We'll be back in 5 minutes. Hour and a half. They get back at 11:30, 11:45. Oh, we might as well go ahead and take lunch. You get back to lunch at 1:30. Oh, we got a hearing, so we need to go over some information. All of a sudden, we just let the jury go on for the day. I mean, it's been ridiculous.
Somebody said DJR, everyone is speculating. Let's just see what happens. Sometimes you can talk down on people for no reason. I don't know what he mean by that. I don't know what he mean by talking down.
Well, bring him into the chat. Let's
come up to the chat if you don't mind, DJR. If I'm pronouncing that right.
We've seen this with our own eyes, in my opinion anyway. I'm just giving my personal opinion as a layman on the outside. From what we've seen with Judge Glanville, okay, let's just take the other trial with, what's the other judge, McAfee, when he did the Trump hearing. You seen ran a lot differently. And you had judges and his lawyers on both sides like you have now, and it ran with a lot of different order. It was orderly.
Right.
Chaos.
Which is insane because McAfee is, probably less than half the judge's age.
Yeah, and experience out of all of them.
Right, he got experience. He's smart. He knows exactly what's going on. He's prepared. He's timely. And one thing about it, you're not gonna be able to just get anything over on McAfee because he's sharp.
Yeah.
So I think he's the perfect judge for that trial, and I think he should be like a model to show the other judges how to do it. Now his rulings may not always, like I tell people, a judge, you're not gonna always agree with their rulings or their calls. Just like in a game, you're not gonna always agree with the referee. Mm-hmm. But as long as they are making, neutral calls to both sides, then sometimes you're gonna get a call you don't like. I've had that with judges. You're not gonna get everything you want. That don't mean that they're a bad judge or that they corrupt. Mm-hmm. But when you start doing stuff that's outside of the rules,
when everybody notices it,
and everybody knows, okay, now you cross the line.
Yeah.
Thank you, Ms. Trish. Yeah, the DJ, if you want to come up, let me drop the link for him. Because I don't know, we're not saying nothing that ain't been out there.
Yeah, again, he's entitled to his own opinion, and I won't even argue with his opinion. He's entitled to it, but from what I've seen, it seemed, I don't know if, Thug guilty or innocent for anything they charged him with. But what we've seen from the judge and the prosecutor, it just looks so biased to where it's so obvious that everybody notices. And it shouldn't be that way.
Right. And that's true. Let me see. She said, you are more than generous. You gave them all $100. That's so cool. You didn't even need to do that. I'm subscribed to your channel. Thank you so much for that. And because I didn't want people to think I just want to take leads, stuff. I always, even before today, I've always supported that channel and contributed, like all the time. So that's not nothing new. Let's see. DJ said he's not able to chat, but just pray for the judge. Everyone in that courtroom is stressed out. The next court will figure everything out.
Okay.
Somebody said if he's so stressed, just recuse yourself.
Exactly. But whatever he's taken the last few times he's been on the bench has worked. Like the last maybe 3 to 4, days, he's been as calm as we've seen him.
Right.
Yeah.
I don't know. I don't know what they put in this. She said everyone used your foot. Yeah, everyone did. I don't know. Yeah, we're gonna try to interview Kayla again, Tracy. But yeah, he's been more, more relaxed and calm. Mm-hmm. I don't know if he's taking them good pills or what before he get up there.
Yeah, and sometimes we all recognize when we're defeated. At some point, we can fight it off as long as we can. I've been there. We fighting it. And all of a sudden, it's like they got me.
Right. And as a military man, it seemed like he, fought to the bitter end.
Yeah, he knows the art of war. He knows it.
Right, he knows.
I can wave the white flag at this point. Still, you got me. Still been doing this a long time.
A long time. And it seems as if the judge kind of know, like, he's still trying to save face a little bit. Because at the last minute in the fourth quarter, 10 seconds left in the game, now all of a sudden he wants to almost send it to another judge. you're only doing that because the Supreme Court said that, you know, you have to.
Yeah.
Weinstein just filed a motion in the Supreme Court, and the Supreme Court said, no, first do it this way, file it there, and then it goes to another judge. And if they don't make the right decision, then you can appeal it back to us.
Yeah. And was it supposed to be like that from the very beginning when they first made these motions on, let's say, the 10th or the 11th? Was the judge supposed to send it over to another judge at that point? So that should have been the stance all along, or was it supposed to be all these, you know, legal wranglings that we've had over the last 3 weeks?
Well, it seems as if the judge said that today. He was saying pursuant to, he named 2 different rules that if someone follows, let me see. I think I actually wrote it in 25.1 and 25.7. Right. He had said that pursuant to those rules, he's to assign it to another judge. But the thing is, why are you saying that now?
Yeah.
You denied those motions without assigning it to another judge. The only reason you're saying that now is because the Supreme Court said in Weinstein's motion that's the proper thing to do.
Right.
So now all of a sudden he want to, you know, say, oh, I'm signing to another judge like I'm supposed to. No, it's too little, too late.
So that was supposed to have been the entire time, basically.
So can you say that again?
So that was what he's supposed to did in the very beginning when this first came up.
Oh, right. He should have been sent it. I mean, think about it. If you are supposed to be neutral and you got the whole world accusing you of, you know, being unfair, and to be clear, I mean, we kind of was saying he was unfair even before it officially came out. He was having a secret meeting. We kind of saw that he was leaning more to the prosecution.
Exactly, yeah.
But when the whole world is saying you unfair, and if I was a judge personally, I said, y'all can have it. Y'all can have this headache. He don't like to be there anyway. He take 1,000 breaks.
1,000 breaks.
I would have signed that order so fast. They would have been at the house in the summertime.
Take it. You can have it.
You can have his headache. It ain't what I thought it was going to be. The judge probably thought that he was going to make history, but now it's turning out to be.
Yeah, you're not going to be. What's his name? Ito. You're not going to be Ito at this point.
Right. Okay, let's see. DJ responded. DJ said, I am at work. I will eventually get on video with you, but you are a great brother. I'm not biased on either. However, that meeting might have been legit. All I'm saying, I'll catch you later, bro. Oh, thank you. That's kind of you, DJ.
Yeah. Come on the show.
Yeah. Come on whenever you got time. I know people are at work. They sneaking and they watching. Yeah. Got the volume low and got some headphones in.
But let everybody know I'm gonna be a regular from here on out.
Well, I definitely appreciate you for coming on. When nobody else clicked the link, you said, "Hey, I'm gonna come up there."
I've been following this trial as best I can, and you know, some days it's like you might watch it for 10 or 15 minutes, and you realize they're asking the same question. Oh, you didn't. Like I say, I haven't seen a good witness yet. Maybe I'm missing something, but I just haven't seen a good witness at this point. And so it's kind of like you asking Woody these questions over and over again. You had no witness who came on and said so-and-so did so-and-so. You just got a lot of speculation. Right. And I think they put all their eggs in one basket with Woody. As a prosecutor, I mean, when you got somebody that's shaky at best. At best, yeah. At best, you're going to build your house. You're going to build your house around them. Yeah. You might as well, what's that game? Is it called? I think it's a game where you build up a lot of blocks and you pull out one by one and you try not to keep them from all falling down. And, I know what you're talking about. I mean, I think it's Jenga or something like Mario that. Brothers. Right. Yeah. And they pulling them out, one by one. This witness. At first, they had a solid stack, but once you start pulling out the witnesses, okay, he didn't know nothing. He didn't know nothing. He didn't know nothing. He didn't know nothing. Now, don't know anything either. The cops and the experts don't know anything. Oh no. It's speculation. So now the case is wobbly. It's wobbly. And the wind blowing, it's going to go down. And they still got over 200 and some witnesses, according to Love and Hilton. They still got like 300 witnesses to go. Man,
They need to cut their loss and let them witnesses go. This is, and I understand people are saying somebody lost their life, and they need to get justice for the family. There's nothing preventing prosecutors from charging individual crimes. So if somebody died and you find out the person that did it later on, you can charge that person with murder. There's nothing that's preventing you from finding the right person and charging that person. But what you can't do is have a big RICO and just throw everybody in one group and say, okay, we're going to charge y'all all with it, when you don't even have proof enough to charge one person with it. So,
well, I'm glad you brought that up, because if you believed Woody back in 2013, 14, or 15, why didn't you take that information and use it to get at least an indictment during that time frame? Why do it years later?
Right, and that's why some people are saying that Fonnie Willis is clout chasing. Yeah. They saying that this was way before her time. She wasn't even a DA. She wasn't even the elected DA at that time.
It was Paul Howard.
It was Paul Howard. So Paul Howard, it should have fell under his jurisdiction. If he felt something, happened in that time period, then he could have, took care of it then. But all these years later, when a new prosecutor get in the office, then she can reach all the way back. Yeah. And now, I know she wanted this high profile case, but she got 2 high profile cases.
Yeah,
and both of them in shambles.
They stalled.
Right.
Yeah,
right.
Stalled. I mean,
both of them are stalled at this point. So that's what I'm saying.
Hit over her head, but she definitely didn't manage this the way it should have been managed.
Right. It's too many conflicts, because obviously if she was messing around with Nathan Wade, that's a conflict. Yeah. And then on this side, someone's saying that she may know some of the people that's in YSL, or she used to represent some, or maybe she was talking to some. It's too stinky. And anytime if there's a impropriety or the appearance of impropriety, even if it looks bad, then the person needs to recuse. So I think DA Fonnie Willis should have gave it to somebody else. Keisha, you got something to say? Keisha?
I was just going to chime in on some of the stuff you guys were saying. But I did have a question, or just an understanding. So the judge, when he did the recusal motion, it automatically gave a stay to the trial, right? Everything has to pause, right?
Right. I don't know if it's automatic, but what the judge essentially said is he's going to give it to another judge first and see what they decide. And depending on what they decide is if the trial should be paused. Because if the other judge decides that Glanville can stay, then there's no need to pause the trial, because you have the same judge, the same defendant, you keep going. So
is it a hearing that okay, so I know it was supposed to be assigned to Edwards. So would that be a hearing, with everybody involved?
Well, somebody said that Edwards don't have anything to do with it at this point. The one you're talking about, Belinda Edwards. So I guess it's going to be a new judge. And today the judge said it's going to go into some type of like a wheel, like all the judges go into like a spinning wheel, and they're going to randomly pick out a judge.
Oh, okay.
Right. So right now we don't have a judge.
Right. So, and another question now, Miss Hilton asking how long it would take. As a DA, shouldn't she already know that the judge couldn't answer that question?
Well, I think from her point of view, I think to me it seemed as if she was trying to tell the judge in so many words, like, hey, judge, don't sit on this. Send this to another judge, like right now. Send it to the wheel so they can pick another judge, so we can keep this trial moving. Because I think her concern is the jury's been sitting at home all this time. The little bit of evidence that they did get is probably, gone now. So I'm thinking she's trying to tell the judge to go ahead and start that process to get it over to another judge. Now, we don't know how long that's going to take, because once the other judge get it, they may have a lot of stuff going on. They got to make room on their calendar. Is that going to be 2 weeks? Is it going to be 30 days? And then once that decision is made, then that decision can be appealed back to the Supreme Court. So we could be stalled indefinitely.
Okay, one more question. So the judges, they can't, so by them, knowing the Judge Glanville and working in that atmosphere, wouldn't it make more sense for them to recuse themselves?
Now that'll be a smart thing. I mean, if the judge is worried about retaliation from Glanville, who is the chief judge, then if they get randomly selected, they could recuse themselves, saying, "Hey, I know Judge Glanville. I've been working with him the past 20 years, and I can't see him doing any wrong." Recuse themselves, and then they're gonna put it back in the wood. Then they go to another judge. But you never know. You might find a judge with integrity in Georgia. Is there one? Somebody from Georgia? Is there one? Do we have one? Somebody that got integrity to say, "Hey, Judge, I know you try to do your best. Not really, but we're gonna kick you off and move it to a different judge." But I am curious, will Judge Glanville appeal to the Supreme Court if they kick him off to get back on the case?
Oh, so the judge can appeal too?
Yes, the judge can appeal. Either side can appeal. So if the judge get kicked off and he believe he was kicked off unjustly, he can then file with the Supreme Court with his lawyers. So they have lawyers that represent the interests of judges and say, "Hey, he wants to come back." Now that's gonna be a mess right there.
Right. Okay, I appreciate you. Keep up the good work.
Yes, ma'am. Oh yeah, thank you for speaking with us, and hopefully you come back.
Yes, I'll be back. You got a more honest channel than, it's a couple out there that's a little bit more real and honest.
Oh, okay. Well, thank you. I definitely appreciate that.
Yes, thank you.
Okay, you have a good one.
You too.
All right. All right. See, I'm gonna tell it like it is. I don't live in Georgia. I live in Texas. And guess what? If it was a Texas judge that was doing something wrong, I'm calling you out too. Somebody say, "He ain't got no shame." I'll call you out like Brian Steele and then show up in your courtroom the next day. I'll show up in your courtroom like nothing happened. Okay, we still got business to attend to. Anybody want to come up? They got a camera and a mic. Hit the link. We're just talking about what happened today in court. The judge is promising to release the transcript. So I'm trying to stay on here for a little bit longer to see if he releases it. Because guess what? Soon as I click the off button, soon as I take off this silk purple tie, somebody gonna be calling me and saying, "Hey, the transcript's out." Then I'm gonna be running back. I'm gonna be running back in here, trying to get to this chair. Come on here. Y'all ain't saying nothing in the chat. And for those of y'all first time here, if y'all don't mind hitting the like button, if you want to stick around, subscribe. And if you're here to be nosy, I might as well wear y'all out while I got you. I might as well wear y'all out while y'all here. Oh, here we go. He came.
Yeah, I'm sorry. I had my iPad went dead.
No, you good. You good. I thought you was probably at work and somebody was walking in. You got a hair for knocking down. When you're on the phone, the police, you see the police, you drop that phone real quick.
Yeah.
Yeah, you don't want to get pulled over with your phone in your hand, so you got to drop it on the floor. It seems like he's trying to work out his connection issues. But yeah, for y'all, we got some of y'all. Oh, you stealing from the, come on. It ain't nowhere near close to that. Thank you, Erica. Nowhere near close to stealing. I've always supported that channel. And every channel is different. If Kayla was over here like she was at first, she stopped by here first, and everybody else took that video and ran with it. I have no problem with it at all. So we good over here. Let me see. Anybody from Atlanta can verify if that shooting was actually at Woody crib. Anybody from Atlanta? See, I don't know the little Tay dude. Somebody said that Woody mentioned him in the trial. Hey, can you hear us, Mr. Michael?
Yeah, I can hear you.
Okay, yeah. We're trying to see if somebody can verify if where that shooting took place in Atlanta. And I don't even know. And it could be totally unrelated to this case. So we got to remember that too. Sometimes we get so caught up and we try to connect the dots and be connecting them the wrong way.
Exactly. Yeah, you want to have the facts before you start making accusations to some degree.
Right. Yeah, I don't know too much about it. That's why I'm straying away. Let me see. Hilton questioned him regarding Tay shooting at him. Oh.
Yeah, that was allegedly the guy who got shot over the weekend was this kid Tay.
So wait a minute. So Tay, I must have missed it. So Tay was to be like allegedly the person that was shooting at Woody and Woody's kid and the mother of his child.
Yes, but I'm thinking it was some guy named Tay. It might be more than one who allegedly got shot over the weekend as well.
So they're trying to say this is the same Tay. This is the same Tay that was shooting at Woody in the past.
Obviously, I mean, like I say, this is like there's a couple of D's and there's a couple of Tays, so it
right.
Different people with the same name.
Right, because if the dude was shooting at Woody and Woody's child, I don't see how he, because I know Woody put up a post on Instagram about the guy.
Mm-hmm.
So I don't know if that's any that holds any weight. Because Woody, he spoke highly of the guy.
Exactly. Yeah, he did. He said I wouldn't be hanging around this guy if he would have shot at me.
Yeah, right. Shot at me and my, the mother of my child and my child. Like, wait, what?
Mm-hmm.
Yeah, so maybe that could have been the police got it all wrong, all backwards.
Mm-hmm.
Let me see. Attorney Bumpus did not violate attorney-client privilege because there were multiple third parties present at the meeting. This honorable judge keeps threatening those who expose them. And what the judge is trying to say today, Ren, is that supposedly Bumpus and her client Woody was had a private meeting for an hour and 11 minutes.
Is there a proximity issue when it comes to what's privileged and what's not?
Well, normally if it's in the presence of third parties, so presence can be broadly defined. It don't say like if you're within 2 feet or 10 feet.
Okay.
It's just, it basically if somebody got some listening ears or some itching ears, as our old folks say, and they can hear, then that breaks the privilege, because the privilege is supposed to be confidential, not for the whole world to know what was going on in the room. So, but Kayla said, we heard her earlier, she don't think it was that long.
Yeah. But
Kayla's smart. Kayla said, hey, I'm gonna wait for the transcript.
Yeah, that way nobody don't try to misquote her. So that
misquote her.
Exactly. Yeah, I agree with that. Yeah, because we're gonna take a story and we're gonna run with it before we actually see it on paper.
Somebody said, do you think that the court reporter or the judge got together and scrubbed, not scrub the ground, but scrub the transcripts, cooking the books, if you will?
Yeah, I think he knows the scrutiny is on him now, so he's not going to take any more risk at this point. He has to play it straight going forward because he know everybody watching and everybody's looking to come down on him at this point.
Right. And I mean, if there was 14 people in the room, they better not try to change anything.
No.
Because somebody say that, hey, something was said and it's not on that paper, then it's going to be an issue. And not only that, I believe she records all of her meetings as well. She not only types it, she records the voices. Okay. So if she mistypes, later on she can go home and listen to the recorder again to get it straight. And people are saying that not only do they want the transcript, they want the tape. And I agree, the lawyers should have the tape.
Now, I know Steele at one point asked for any video recordings. Now, are these normally video recorded, or is that just something he just adding in just to be sure?
What do you mean video recording?
Yeah, still ask for any video recordings of the transcripts. I mean, of the meeting as well.
Oh yeah, he's probably just covering all, his bases. Like if there's any video, audio, any type of way to have a record. But I don't know if the judge would have cameras in his, his private chambers. I've been in a lot of judges' chambers, and I've never seen cameras in there.
Okay,
so they'll be watched 24/7.
Answer this for us then. Well, what about why do they call it in camera if there's no camera?
Right. I think that's some Latin stuff that we still holding on to.
Okay.
That don't mean the camera like the American use of the word camera. It just means in private.
Okay.
So it's the opposite of camera. It's the opposite.
Okay.
It's just somebody said, do they have any videos of Bumpus talking to Steele Adams and others? The judge said that there is video of Kayla Bumpus talking to Steele Adams and Shard, the other attorney, defense attorney. Wait. Somebody said he already tried to walk that back, that there may not be audio. Nah, Judge, we need that tape. We need the tape. But I'm sure that we're gonna get. I don't know who can release that tape. The judge might can release the transcript, but as far as court security, who's in charge of releasing the video of Kayla talking to Steele Adams and the other defense attorney?
Well, he's the chief judge, so wouldn't that fall under his purview?
Yeah, but the thing is, now he's saying that he's not worried about it anymore. He's saying, I don't care about.
Yeah.
I don't care about who told who what.
What? Yeah.
So now, with that happening, there's no really need to, get the tape because there's nobody's in jeopardy of going to jail. Somebody said that. Okay, Steele was talking about the body cams of the officers in the room.
Okay, that's why I was asking you about that. That's why I wonder why he got where he came up with a video from, because he definitely mentioned that in one of the hearings.
Right, and I believe somebody said that they were ordered to turn off their body cams, which is crazy in of itself. If that's true, but you own it. You know a lot of stuff about this trial.
Yeah, I've been watching it. Yeah, I've been watching it.
And you know the details.
Yeah.
I done seen lawyers get caught up in trials so much because they start confusing and mixing up, details.
Mm-hmm.
And listening to you talk, you like, nah, he said something about cameras. Yeah. And sure enough, it was about those.
But yeah, I was wondering where he get that from, because it's like you said, it's hard to imagine the judge having somebody going around with a camera. I can't see that.
Right. And normally, lawyers are asked for whatever records of video, audio, type, paperwork, handwritten notes, release it all.
Yeah.
So I think Brian was really covering all of his bases. He said, how can they say it's a complete record when the court reporter was in and out of that fake meeting? Yeah. So they're trying to say the court reporter wasn't even there the whole time. So
how can you have it? Well, I guess that would be a question then. I guess that's a legitimate question if that was the case.
And Kayla did mention, she said the judge was kind of like the enforcer for the prosecution. So the prosecution telling Woody, if you lie on the oath, I can prosecute you for perjury and false statements. Ain't that right, Judge? And the judge like, yeah, she can. And any right, Judge, I can hold him indefinitely, not until this trial is over, but until all the other trials are over.
And we don't know,
right, Judge? We don't know.
Yeah.
And I seen the clip, that other judge they got in there right now. He old school.
Yeah, and you don't want him either, to be honest with you.
Right.
You don't want him either. I mean, you want McAfee type judge. You want somebody who got an even kill. McAfee was firm, but he was fair, and he kept order in the courtroom. What we've seen now is total, chaos. It's like the British Parliament almost. I mean, it's crazy.
Crazy, right? Just yelling across the aisle.
Yeah.
And the one thing about this judge, he's even tempered. He reminds me of my grandfather. You don't gotta yell and raise your voice
to get your point across.
Mm-hmm. He gonna say it. He gonna say it one time. He was pretty. He didn't never yell when the finding was getting a little bit emotional and upset.
Oh, well, Miss Willis, I'm gonna if you continue this type of behavior, I'm gonna strike your
The whole testimony, right?
Yeah, yeah.
Right. He
didn't calm down at that point. I mean, she got
right. He didn't have to, hit the gavel or jump up or yell at her or just walk off from the bench and be disrespectful. Some judges get mad and just walk off.
Yeah, and she took him serious too. She stopped.
Right. I mean, because he single-handedly had the power to remove her whole office from the case.
Yeah.
So that's somebody you might want to listen to.
Yeah.
And go ahead.
No, go ahead. I'm sorry.
No, I said once he told her, told her that, she calmed like all the way down.
Yeah.
And the judge just he let him continue. And I think he was fair. And truth be told, quiet as it kept, he probably wasn't even going to make her testify. She kind of marched in there.
Volunteered.
Yeah. He was kind of looking like, what the hell you doing here? I wasn't even going to rule that way.
Yeah, she was like the bullfighter. I'm ready. She was tooting that horn. She was ready to go.
But see, I think she was mad because the Ashley Merchant, the other lawyer, was insinuating that she messed with Nathan the first night they met.
Yeah. And
tried to paint her in a light like that.
Mm-hmm.
And she was like, she came down marching. She like, oh, no, I'm finna get this B. She talking about who I slept with on the first night.
Which was irrelevant, but
y'all grown.
Yeah.
If y'all did, right. And that's right. At the end of the day, that's what it really boiled down to. I think the issue, the bigger issue is, was she receiving, did she have a financial incentive to prosecute Trump? Or is she getting some of this money, this kickback money? If she's paying Nathan Wade $750,000, $1 million, and if he's, kicking some of that money back to her, leaving it under the mattress when he walk out in the morning, is that, appropriate? And, they're going on trips, they're taking vacations. Nathan right now, he's going through a divorce, and guess what? He don't got no money in the bank.
Yeah.
So Nathan, where is this money?
Yeah. And all of this was self-inflicted. With both of these cases, in my personal opinion, these were self-inflicted wounds.
Right.
I mean, you take Alvin Bragg or Lita James or Jack Smith, all of them, you haven't heard anything. Right. Period. That's an impropriety involved in the case. Mm-hmm. But these two Fulton County cases, self-inflicted.
Yeah, I agree that the whole Nathan Wade thing. I mean, it's better just to stay away from it.
Yeah.
If y'all they say you don't. I'm gonna keep it clean. Where you don't do something where you eat.
Yeah.
You don't eat where you all that.
Yeah,
you know exactly, what I'm talking about. Eat where you sleep and all of that.
I'm gonna keep it simple. You can't kiss and tell.
You say what?
You can't kiss and tell.
You can't kiss and tell.
and his Nathan Wade's old partner, I can't remember his name, but the Mr. I don't recall guy, he didn't like, I don't recall, but he the one put this whole thing in motion.
Which one?
The dark-skinned guy, I can't remember his name.
Hey, Ms. Gail at night here from the lead attorney ABC the 7th Power. Thank you so much for stopping by. I've always seen you be doing some great work over there on the channel. But thank you for stopping by. Go ahead.
No, I was just gonna say, the guy who was texting Merchant the whole time about Wade and Willis, and was saying when the relationship started. I can't remember his name.
Wade. He used to work with Wade.
Yeah, the guy who worked with Wade.
I know who you're talking about. He the one that was talking to Ashley.
Exactly. Yeah.
Trying to low key. I guess I don't know if he was trying to use that as a favor to talk to her. And what she do? She burned them.
She burnt them. She had to. She had to at that point. I mean, you put it in motion. This is why I started this whole thing, because of what you told me.
Right.
Yeah. So
and he was sitting on the stand looking crazy.
I don't recall.
His name Terrence Bradley.
Terrence Bradley. That's it. Yeah.
Terrence Bradley.
Yep.
Thank you, Coco. She said Terrence.
Yeah.
Yeah. Yeah, he didn't got up there on the stand.
He got amnesia.
You didn't went over there trying to talk. I don't know what his end goal was, trying to talk to this woman. I thought, first of all, she married woman herself.
Yeah.
But he just telling her all this and that, and I couldn't think of why else is he talking to her like this.
Well,
And
let me
then
ask you another question about that then. At the end of when Sadow and Merchant got finished questioning Bradley, the prosecution burnt Bradley about, something he had done with a previous employee. But Bradley really didn't hurt them with his testimony that first time he was up there. But they still burnt him. That female prosecutor burnt Bradley about, stuff he had did. And that prosecutor was gone at that point. She never came back to work on that defense for Willis at that point.
Right. I think her and Willis was kind of clashing.
Okay.
Because I believe that she didn't want, you can see her face, she didn't want Willis to testify, but the attorney was like, if you're not going to take my advice and you're going to do what you want to do anyway, and it's already looking bad, then why should I go down with you?
Yeah.
That lawyer was like, hey, I'm a successful attorney on my own right. I don't have to have a stain against my name because you want to come down here and do what you want to do. So they're saying that one of the attorneys will be going live on somebody else's thing, and maybe we can watch some of that. If some of the people don't get mad, they're gonna say, "Oh, you taking food out of what's her name, Megan's mouth?"
Weinstein will be going live. Okay, let's see what
Weinstein talking about. And if anybody y'all want to go to these other channels and tell them like, hey, they're listening to some portions of your and they're not comfortable with it, I'll take it down. But like I know when people come over here and they steal stuff and copy it and don't give me credit, I don't care. I don't even, matter of fact, I wouldn't even say it's stealing. They sharing it.
Yeah, that's
sharing it. They ain't even stealing it. They can't be more than welcome to come over here and share it. Y'all, they gonna say it don't matter. We're gonna share it anyway without your permission. And I'm cool with that. So, but if Weinstein do go live on Megan's channel, if somebody can let me know, we can try to see if we can catch some of that while we wait on the transcript.
Now, what can Weinstein possibly say at this point besides whatever the judge said? He can't really divulge into any information, can he?
Well, I don't think he's under any duty to keep it a secret. So if he has some insider information, maybe he has a copy of the transcript itself. Hold on. Somebody said he had that footage pulled when he left the courtroom told still. Oh, okay, talking about the judge. Okay. No, Weinstein might have some inside information. Maybe he's already been assigned to a different judge.
Okay.
So, I mean, there's a lot that he may know sitting inside the courtroom. Because, we're sitting halfway across the country. And, he's right there in on the action. But I mean, as far as any details, because Weinstein wasn't in the room, so he's not going to know what the transcript said.
No, yeah, that's true.
So he'll be learning about it as we learn about it. But I mean, it should be coming any minute now. I haven't seen anyone that's released it yet. And I've been looking.
Well, did Steele and Weinstein and Shard and all those guys look at it before the judge came into the courtroom today, or he just came into the courtroom and said, I'm going to release it? Did he have an in-camera meeting with them?
I don't think so.
Okay.
Because Kayla said that Woody never even hinted about being threatened. And that's what the judge was harking about. Like, Woody was threatened. I was allowed to have an ex parte meeting, but Kayla was like, he wasn't never threatened. So I don't think the judge will be reading that case law about threats and stuff.
Yeah, he took it out of context again.
Right.
Yeah.
Knowing that the defense attorneys, because if the defense attorneys had the transcript or they already went over it, and then the judge was talking about threats, then I'm sure one of them would have went back up there when the judge asked him anything else. I know Brian Stewart went up there and said, hey, you quoted all these cases about threats, but we were just in the office and got the transcript, and it says nothing about threats here.
Yeah.
So, so I don't think they knew. And when they were talking, everybody was looking at the judge. Nobody was like reading the transcript or trying to follow. Like Brian Steele's eyes was locked.
Yeah, he
on the judge.
He was just like this.
The whole time. Right.
Yeah, he was intense.
And when somebody lying and you have the paper in front of you as an attorney, you're gonna be fact checking. Okay, you said this, that's not true, as they're talking.
Yeah.
But Brian wasn't looking down. He was looking directly at the judge, so it makes me believe that he don't have anything yet. He don't have anything yet that can contradict the judge.
Right.
Somebody said Megan live. If we can, when Harvey, is it Harvey Weinstein?
No, I don't think it's Harvey Weinstein. No.
I mean, not Harvey. Oh my God, Harvey. Right, not Harvey.
Oh,
And speaking of Harvey, he was another man that his case got threw out.
I saw that. Yeah, it did.
Because the prosecutors brought in a whole lot of evidence that was more prejudice than probative.
Yeah.
So his case was threw out.
Yeah, but Bragg say he gonna try him again, and they say they're gonna try him.
Oh,
again.
Bragg said he gonna go again at him.
Yeah, they say gonna go again.
See, and that's what I don't want to happen in this case.
And not only that, they're gonna add some more charges to Weinstein allegedly at this point.
See, that's crazy, and that's what I'm thinking. If the judge throw this one out, or the Supreme Court throw it out, will Fonnie Willis say, it don't seem like she'd like to go down without a fight neither. Would she try to retry it?
Now, if they were to try to let's just say best case scenario, they had a retrial. I mean, a mistrial. Would Thug be able to get a bond at that point?
Well, I guess the new judge would have that discretion.
Okay.
And I believe that they should get a bond, because now that we know that the evidence is not as strong as they allege it to be, I think they should get a bond. They're not going nowhere. Yeah. Because at first they were like, the whole YSL, they're dangerous, don't give them a bond.
And it worked.
Right, because they start all taking plea deals.
Mm-hmm.
So I'm like, okay, if they're so dangerous, they need to be held without bail. Why would you give them probation?
Yeah. Now, you have you ever seen a RICO case where somebody get probation on a RICO?
It's possible.
It's possible. Okay.
Yeah, it's possible. We don't call it that in Texas. We call it engaging in organized criminal activity. Okay. It's the same thing, but yeah, it's possible as long as the law doesn't mandate prison time.
Okay.
Like in some states, it's like a mandatory prison term or mandatory minimum.
Mm-hmm.
But if the legislatures have probation as an option, if in the event that your client is found guilty, then they could be sentenced to probation.
Okay.
And I done had, where is it when I see doing the interview? Okay. Yeah, I done had clients get probation worse than that. But see, here in Texas, we have a unique system where you can pick whether you want the judge or the jury to sentence you.
Really?
Right. So in this case with Glanville, there's no way I would let Glanville pick the punishment because he's pro prosecution.
No,
so I will automatically fall to have the jury in the event of a guilty verdict. I want the jury to assess punishment.
Right.
So that's one of the good things I like about Texas, because 12 people, they can't agree on what they're gonna eat for lunch.
Mm-hmm.
So they sure ain't gonna all agree to send nobody to prison for an extended period of time, unless it's like a crazy or gruesome case.
Well, just like in this case, it's going to be hard to get 12 people to agree. That, there's a crime being committed at really any point that the prosecution has proven.
Right.
This has been a terrible prosecution. I mean, the witnesses are horrible.
Oh yeah, the witnesses, and I think that they built their case on Woody and a few other witnesses. But when you really go back and look, I think Tick. Yeah,
Tick, and then Bean,
right?
Bean say, "I'm so tired.
I'm tired. Look here,
man, that's crazy.
If you all of that, just go home. Just go home."
And then the one guy they brought in from prison, and he was like, I don't know no Walter Murphy.
No.
Yeah, he was funny too. These have been some characters now. They're TikTok and Instagram famous at this point.
Oh yeah, Woody, he blew up so much.
Yeah,
he got so many followers and stuff. I just hope that he can use this as a new opportunity. Hey, Annabelle, yeah, I'm hearing that she lied, but is Weinstein Let me get this man first name. Let me before I call him Harvey again.
You don't call him Harvey.
My bad, YSL.
We call him YSL Weinstein. Yeah.
Right, Weinstein, right? YSL Weinstein. Oh, Doug. Shout out to
that's
Doug.
it. Yeah.
My bad. Doug. Mr. Okay, somebody saying Doug. Shout out to Mr. Doug. And, you know, he was the one that filed a motion with the Supreme Court.
Yeah, the mandamus. Am I pronouncing it right?
Right. That's right,
Okay.
mandamus. And from my understanding, the Supreme Court said that first you need to file a mandamus in the trial court.
Yep.
And nobody's filed a mandamus yet in the trial court. Everybody's filed, you know, motion to recusal, but nobody filed a mandamus.
No, I think didn't Steele and Weinstein file a mandamus early on during the jury selection and then the beginning of the trial, and that's why he's saying that the that writs or motions die in Glanville's court.
What do you know? What motion? What writ they filed?
Yeah, they I think it was a mandamus or something similar to a mandamus.
Okay, it could have been. It could have been because mandamuses are used in the most extraordinary or rare circumstances.
Mm-hmm.
So it probably was a similar motion, and that's what the Supreme Court is saying. You have to specifically call it a mandamus. And I believe the Supreme Court, they don't want to set precedent to where anytime a lawyer has a problem, they go
straight to them.
Yeah, you go straight to them. They're like, hold on, you know, we don't want that much work. They don't want to set that precedent. They saying go to the trial court first and then let another judge that's in that same, you know, building decide it. But for you to come straight to us, we might be opening up
Pandora
box for a lot of lawyers. When they're not happy, they're going to start falling straight to us. And we like, you know, it's not that serious to come straight. I was saying if somebody has a problem at a restaurant, you know, they had a hamburger and the cheese was left off.
You don't go to first.
Right. You
then
don't
the manager, then the corporate, yeah.
Right. You don't go to the district manager, regional vice president, CEO.
Not off the top, no.
That's
understandable.
Right. They're gonna be like, no, go back first and go through those proper channels. And then if all of those proper channels saying you're not gonna get the cheese you paid for, okay, now we have a problem.
Exactly. I agree.
Now you can bring it to the CEO, the vice presidents, things of that nature. But to come straight to me first,
yeah,
that's the Supreme Court is saying, that's only for extreme situations.
And like this has raised to an extreme situation. I mean, this has become one. Over time, it has got to the point where we're at a tipping point, one way or another.
Right. And then to be fair, it might seem like crazy extreme to us because we're on the outside looking in, but to the court, they deal with craziness all the time, like death penalty cases, something like that. Like somebody's getting ready to be executed in in 30 minutes, and we need the court to step in. Okay, that's extreme to them.
Okay, yeah.
But for them, they're like, okay, they're still in trial. Nobody's been convicted. So we still have time to fix this. There's nothing that's happening right now that can't be fixed. If that makes sense. And even in the cases of there's a lot of abortion cases going on. Now, if a lady is suing so she can have a legal abortion, then that's something that's an emergency. Because if the Supreme Court hear it, a year later, it's too late. It's too late. It's moot. It's moot. So now they're saying, that's some emergency, like a time emergency. But if it's
go back to what Shard said in one of the Shard told the judge say that somebody can review it later on, but Shard said we're trying to win it right now. We don't want to go to an appeal. So does that calculate in the same verse as something extreme?
Right. So he's basically saying that we don't want to wait to the end of the trial to fix what's wrong. I mean, in a sense, you still have 6 defendants in custody without bond, and it's been like for 2 years.
Yeah.
But the question is, even before all of this happened, they were still in custody without bond. So is that really the nature of the emergency?
Okay.
Because before the secret meeting, before the jury selection begun, all of this happened. The judge was still holding them without bond, and we kind of probably know why now. I think the DAs, was trying to get the judge to hold him without bond so they can take plea deals to flip.
Yeah, and I'm surprised they haven't really got anyone to flip, which has been good. They haven't found any good witness to flip at this point. I'll put it that way. Yeah, they don't have a Sammy Bull at this point. They don't have anybody who's been a credible witness to say so-and-so did so-and-so.
Right. And that's the and I think that's the crux of the matter. They don't have anybody. And you gotta be, we don't know what we don't know.
Well, we haven't seen anybody up to this point. I'm
point.
going to rephrase that. I'm sorry.
Right now, no, what I'm saying is we don't know if they're not telling because it didn't happen, or they're not telling because they're scared for their life, or they don't want to be a snitch in front of the world, because this trial is on TV.
Yeah.
So maybe that's at a disadvantage for the prosecutors, because not only are Young Thug now watching, you potentially tell on your friends, but the world is watching. How are you going to go back into the world?
Exactly. Yeah.
So, and I mean, if they had somebody of substance, I think they would have put them on
first.
Yeah. Because, the evidence and data show people remember, what they hear first more than what they hear squeeze in the middle.
Mm-hmm.
And
at this point, you're wondering what else can you possibly bring up at this point?
Right.
To have a in excess of still over 100 witnesses. Like, who else can you bring in, and for what reason?
But I think according to Miss Infamous Sylvia, she also has a YouTube channel. Mm-hmm. I believe she stated that she asked the DAs, she said, how much longer? On my question, are you done? And they told her we'll be finishing up in August.
August of next year?
Right. That's what it had to be. Because the show ain't on August of this one.
No way.
And not only that, we got to remember, once the prosecutors are done, we don't even know how many witnesses each of the defense lawyers have.
Well, let's say you, hypothetically speaking, you are a defense attorney. You've seen what the case they put on. Do you even try to put on a case if you're the defense at this point?
Maybe just a little bit,
but
only to button up certain issues.
Yeah.
Only, to clear up certain facts. I mean, even though we don't have to present any evidence at all, it's always a good practice. If you have some evidence that can help you out, then that might just be the thing needed for one or two jurors that may be holdouts.
Yeah.
And you might say, okay, you want to give them the tools, you got to give them a reason why you should be found not guilty. So if you have if you give them the arguments when they go in the back room of why should we be not guilty, then they can say, well, I guess, the defense attorney did bring in this one witness, and this one witness said this, then I think that would really help.
I just think the case they put on has been so poor that it's like, do I even need to do anything at this point? They've dug a hole and buried themselves, so I'm not going to help them out.
I've had cases like that where the prosecution closed, they rest their case, and the judge would turn to the defense. Somebody said Glanville got it. And they asked the defense, do you wish to present any evidence? And I stand up. Since the prosecution has not proven their case beyond a reasonable doubt, the defense also rests.
Yeah.
And and at the same time signaling to the jury they didn't prove their case. And sit right on down.
Yeah.
And the jury that's how it normally, in most cases, that's how it normally goes, unless you have like expert witnesses, because 9 times out of 10 the defendant normally does not testify.
Yeah. Unless
it's like a rare circumstance where it's maybe a he say, she say type of case, and the defendant is the only person that can clear their name, then you'll put them on.
Yeah, because I don't see Glanville giving a directed verdict. I mean, that would be feasible in this case as well, but knowing his reputation and track record, I don't see him giving a directed verdict. which
Right.
he should, but I couldn't see him doing it.
Right. And a directed verdict is when the judge can enter a verdict. He can take the verdict off the hands of a jury and enter a verdict himself. For those that's wondering what a directed verdict is, but there's a catch. He can only enter a directed verdict of not guilty.
Exactly. Yes.
He cannot enter a directed verdict of guilty because that would deprive the defense of their right to a trial by jury of their peers. So, but I think
nope.
You're right. It'd be a cold day. Yeah. Oh, a cold day.
We're gonna let the jury decide. That's an issue for the jury. I can see that now. Yeah.
Right. That's how I normally go.
Yeah.
Judges are really reluctant to ever grant that. I've never seen a judge
yeah, I was actually involved in a civil case where the judge issued a directed verdict in my favor.
Oh, okay.
Yeah, so that's how I'm familiar with that.
Oh, okay. That's good. That's good. And it's more common.
And she was that was rare. After 30 years on the bench, giving a directed verdict is rare.
Wow, yeah. And it's more common in civil cases because obviously nobody's liberty is on the line. So you have way more protections in criminal court. So now if the prosecution does not prove their case and no reasonable jury can conclude that they prove their case beyond a reasonable doubt, then a judge can step in. But a lot of times the judge would say, there's enough material facts here, issue that the jury can decide. The jury can decide whether they're guilty or not. And since he's sole prosecution, he might send the verdict form back with the jury with a big G on it.
This is your only option.
Right. One option.
One option.
And I've had those too. The verdict forms will be wrong. I thought, hold on, we only got one option for them to pick.
Guilty.
I thought, no, we got to go back and. That's why it's important for the lawyers to read the jury instructions and the verdict forms.
Yeah. Now let me see. Now let's say, for instance, this trial was to get tried over again. If you Brian Steele, do you just try this in front of a judge, or do you continue to have a jury?
Oh, what do you mean?
Like instead of having a jury trial, you just have a bench trial.
Oh no, jury.
Yeah, jury every time. Okay.
Jury. Yeah, because it's just so unpredictable
for a judge to know what direction they're gonna go in.
Well, I'll say that because we don't know. It's really hard to convince 12 people. They all have to be on the same page. But one person, let's say you get somebody like a DA Love. Let's say we knew nothing about this case, DA Love in Glanville. We don't know nothing about they behind the scenes.
Yeah. And
you done put your whole future in the hands of this one man, not even knowing that he's already made up in his mind you're guilty. I think that's a dangerous thing to do unless if you know the judge and the judge has been leaning your way. Some cases you can tell by pretrial motions. If the judge, let's say it's a DWI case, driving while intoxicated case, and the judge throw out like most of the evidence, throw out the blood, throw out the breathalyzer, throw out the video. Okay, so he's leaning towards he's leaning towards the defense heavy because he done gave you all the tools you need. Then you can say, "Hey, I want a bench trial." But also, not only that, she said, let me see, talked aloud. Weinstein said they are hoping the judge recuse themselves in Fulton. If not, they would move forward new jurisdiction. Oh, okay. So they're pretty much saying they want all of the judges, if I got this right, to recuse.
Well, kind of like what Trump trying to do in the other case. He want the whole district attorney's office off the case.
Right.
You know, so which I guess technically would make it put it in a different jurisdiction, because you can't come from Dallas to Houston, can you, and try the case as a different prosecutor, or the same prosecution team go to a different venue? That's not possible, is it?
No. If it moves, then other district attorney will take over the whole case.
Yeah, and no other district attorney won't either one of those cases.
Right.
Trump or Thug, nobody wants to deal with that.
Especially now, because what started off as, may have been strong cases. I remember when they first came out, they were doing the press conference.
Yeah, it sounded good.
It sounded good.
Yeah.
When you first start a relationship, it start off good.
Yeah.
It start off good.
And you're only hearing one side of it at that point as well. So, we tend to, myself included, sometimes the first thing you hear is what you believe.
Right.
Yeah, and it's hard to retract your brain and say, okay, let me be non-biased and wait for more information to come out. I've learned to do that over time.
Right.
Yeah.
And that's really hard, when you only got one person, one side. And that's how a lot of cases get indicted.
Mm-hmm.
You only got prosecutors in the room. The prosecutors get to go in there and say whatever they want to say. And that's why they say you can indict a ham sandwich.
Yeah, that's literal.
Anybody can be indicted. We didn't hear rumors of them indicting dead people, put the wrong name on the paper. Yeah. So, and the grand jury always votes because they only hear one side. When you come to trial, and you got seasoned attorneys like Weinstein and Brian Steele and Keith Adams and the others, then and then they hold their feet to the fire. Like, nah, you may run over a public defender.
Not us.
Yeah, not us. That's not happening.
And then, see, that's the big difference in this Trump case and the YSL case is you got money in order to fight it. If you're an average citizen, you don't really have that type of money and that access to these type of lawyers to fight the case.
Right. Yeah, I agree. And money is so important. People try to save money when it's time to hire a lawyer. No, I don't want to pay that money because I need to save it. Like if you get a public defender and God forbid, you get sent up the river for 10 years, imagine how much money you're gonna lose.
Yeah, there's no price tag on
right, because you didn't want to save some thousands that you didn't want to pay a lawyer.
Take it all, as long as I can stay free. I figure it out. Take it all, every last dime.
Right. And I get called all the time. Somebody may call, and then a year later,
man, I wish I would have got you back.
Right. Yeah. It's time for trial, and they offering me, and they want you to do it at the last minute.
No, it's too late at that point.
It's too late.
It's hard to read your man. Like Steele is a great appellate lawyer as well. So that's why he knows the different times within the case to come ask for an objection, making sure things get on the record. He knows how to do that.
Right. Yeah. And it's a big difference between a regular lawyer and an appellate lawyer. And I know someone, I don't know if he was joking, but I know a guy said he's in prison and he needs someone to represent him. Mm-hmm. You need an appeal attorney, someone that specializes in appeals specifically, not a regular trial lawyer. And you're also going to need an appeals attorney in your jurisdiction.
Exactly.
We can't just cross state lines and just represent anybody we want to. And you have some lawyers that are barred in multiple jurisdictions. But Brian Steele, I think he's a good appeal attorney because he knows.
He knows, yeah. Steele was able to get Young Thug's brother out of prison off a life sentence.
The one that was just recently sentenced, or he had another one?
No, the same one.
The same one.
Yes.
Oh, wow.
He was doing a life sentence and Steele got him off. It's
somebody,
he tells the story that he was in prison and he talked to Thug and Thug told him you'll be home in 2 years, and he was home in 2 years.
That's let me say, I see you drop your $100 early. They be going live. Oh yeah. Yeah. I've seen it where it was an issue with the lawyer that Young Thug's. Well, maybe I don't know if that was his brother or his nephew, but one of the lawyers didn't bring in his IQ and all of the things that could have helped reduce the sentence. Mm-hmm. And then on top of that, he had some issues with being there. Like he was held in contempt for not being there one time, and then another time he was late again. And the judge is basically saying like, what's going on here?
Yeah.
If you got too much on your plate and you can't handle it, you need to, let somebody else take over. But you have some attorneys, they just want money. They get as much money as they can from all these different people.
Yeah.
But now they don't have the time to actually work the cases.
Yeah. Well, this right here is a prime example of it. None of these guys could actually work another case at this point. As long as this trial is lasting, it would be almost impossible to work on anything else.
Right. And then some of them are getting paid by the state, and I believe the judge capped them.
Yeah, he did. And they've tried to get off of it on multiple occasions.
Right.
Yeah.
So they are the real victims here.
Yeah, exactly. And the jury.
See, nobody's capping the judge pay.
No, or the prosecutor.
Or the prosecutor. Right. If we cap y'all pay, I bet you this trial will be a whole lot faster than it is now.
Yeah. And then you got to go back to the, I'm assuming, correct me if I'm wrong, but you got to go back to the county commissioner and say, we need more money for this trial. Each time from the DA's office, they got to keep getting money from the, the prosecution, and the court has to get more money from the county commission as well, in order to put staff and security for the trial. Right.
I wish I was in that commissioner's court. Don't you even fix your mouth.
Nope, you're done.
They come here and ask for no more money.
Well, yeah, just imagine how much they spent on the Trump project and this one. That's probably the whole budget for the year.
I see it coming at the door. If you don't get out of here, I already know what you want. No. And then on top of that, we don't even know what you did with the last money. They saying it's under a mattress.
Yeah. I know. What's his name? I can't think. It's the guy to Ohio, Jordan. Not Jordan. Yeah, it's Jordan. Was it Jim Jordan out of Ohio? He said that's Christina Willis about some of her spending and where it went, and she's not she's not capitulating, so he wants to have her held in contempt.
Oh yeah, she better give him what he wants. Whatever documents he wants, just give them to him. Right now, she might be feeling comfortable because Biden's president, and Biden's people are not going to go after her. But he may not always be president.
Yeah, that could change quickly.
That could change, right, real quick. And then guess what? It's going to be a new AG, and then they may really come after you for contempt.
Well, they are. They will. If Trump gets elected, you can guarantee they're going to come down on everybody.
So my thing is, whatever papers it's public record. If he wants some papers, because supposedly she was given grant money by the federal government to buy youth stuff, equipment, and all this type of stuff. But they said that she didn't use that money for that. And that's why she got rid of that one girl, that one whistleblower.
Yeah.
Because that whistleblower said, hey, that money was supposed to be for the youth.
Yeah. And they went and bought everything else besides that.
Yeah. And then gonna try to go to the commissioner's court and ask for more money.
Exactly.
Because if you don't get they're gonna have to cuss. Keep from cussing if she come and ask for some more money.
And and their thing is, really you have to go to the jury to get you off in Fulton County. Seems like you got to go to a jury trial. That's your only solution to get out of a case. No matter how bad it is, the prosecution, they don't have anything to lose.
Right.
So their thing is, if you want to beat us, go to trial. It's simple as that.
Right. And I think so. I think that's the
you need to have a whistleblower channel. Okay.
Have a whistleblower. I guess they're talking about the girl that told on.
Oh, the whistleblower. Okay,
the whistleblower. Yeah.
I can't remember her name. I know exactly who. I see her face, but I can't remember her name. But yeah.
Somebody said, shaking my head, Coco. That was the worst part I heard. Using children's funds, you got to be corrupted.
Yeah.
Yeah. If it's for the kids, use it for the kids.
Yeah.
I don't care if it's iPads or whatever they need to just get it.
It was supposed to be for juvenile intervention, try to get them before they actually got into trouble. That's what it was. That was the program that's supposed to have been set up.
Oh, wow.
Yeah. But remember, Paul Howard, the previous DA, he had set up, several different LLCs and nonprofit organizations and started funneling money to that and actually wasn't spending it on what he was supposed to spend it on.
Oh, wow.
Yeah. He got in trouble behind that. That's one of the things that Willis capitalized on to say how corrupt he was in order for her to get elected.
Right. She said a lot of stuff she was going to do different. And she specifically mentioned that she wasn't gonna have no relations.
Yeah, I remember. Yep, I won't be sleeping with anybody under me.
And then Nathan Wade gonna get himself on national TV and say I wasn't underneath her.
He was a subcontractor or some. What he said, was it a subcontractor or?
Yeah, I think so. Yeah, independent dude. She the DA for that. She's the elected district attorney. Yeah. You didn't come in there on your own free will. She brought you in. She hired you.
Mm-hmm. And she can fire you. And she can fire you.
Right. When it was time for somebody to go, the judge said, one of y'all got to go. Guess who went?
Yeah.
It was him.
Yeah.
So she was definitely above you. Coco said he was on the top.
We stand corrected, Coco. You're right, Coco. We stand corrected. I'm sorry.
Not us.
Yep. We stand corrected, Coco. I'm sorry. You're absolutely right.
Oh man, y'all are funny. That's what they say now.
Yeah. But honestly, I can't blame Wade. I can't say if I was in that same situation, I wouldn't have taken advantage of it. So looking at it through those lenses, you got to ask yourself, what would I have done in that same situation? I might have done the same. I would have done the same thing. I would have took the money and got the ass simultaneously, just like he did.
Come on.
Let's keep it real. So people tend to don't realize that more than one thing can be true at the same time.
Hey, you're right.
Was it an improper relationship? Would I have taken the ass and the money? Yeah.
You're right. And I mean, and quiet as it is kept, the money was, I think, his main motivator. I mean, he was getting paid, they say upward of $750. So if this trial would have kept on going, he could have been $2 million or more.
Exactly, yeah.
So I mean, that's a big motivator. And
what's Alvin Bragg's salary? Do you think it's $300,000, $350,000 at the most?
That sounds about right, but that's New York. Let me see.
That's why I was using him as the biggest example.
Let me see. So they said about 200, 212.
That's it.
That's what I'm seeing.
Wow.
But they say his net worth is like 42 million.
I don't believe that.
You don't believe the salary?
No, the net worth. USA Today maybe a few weeks ago, fact checked that same thing. People were saying his net worth was over $20 million, and they say that just wasn't correct.
Oh, okay. Let me see.
Yeah.
Let me see. I can go here. Okay, I see. Yeah. I'm see if I can share my screen right quick. Present, share screen. Show what I'm looking at. I just typed it in. And it do say right where you said it says false.
Yeah. I'm on it.
Yeah, it says false.
Yeah, it's false. Yeah. And one thing about Bragg, I mean, I'm not familiar with him. He kind of came out of nowhere and say, he's ran a clean, as far as we can see, he's ran a pretty clean outfit.
Okay, so they said an annual salary of approximately $200,000.
Okay.
220, between 1 and 249, 210. Okay, so maybe in the twos. Yeah, I don't know how he's surviving in New York.
Hey, I was thinking the same thing. That's not enough.
Right. Because in Manhattan.
Yeah, his wife must have a good job as well.
Probably so, unless they get some type of separate allowance for living expenses and vehicle expense, something like that.
Yeah, he has to. Plus, yeah, he has to, and there's no way around that. In New York City, $200,000 is not going to take you very far.
She said Wade made more than the president gets yearly. Yeah, Wade was making a killing.
Yeah, I mean, think about it. The president makes 2 and some change, and
I think he
that's
made
3 salaries, 3 years of president's salary, right there.
I think the president made 400.
Oh, that's right. You're right.
Yeah, I think it's
You're right.
400.
Exactly
Yeah.
right. Yep.
Yeah,
Yep. They
400.
went to 400.
Yeah. So, but you know, for a president, that
You don't have to pay for anything.
Right. You don't have to pay for anything. Yeah. So that's good, and some of them even donated back.
Yeah.
They said they're gonna make their millions from writing the books.
Yeah, exactly. After office.
Yeah, I thought was it. They said there's some change to them. Let me see. It's not as bad as it sounds. Would you ever take on a RICO case? I've had cases like that in Texas, but it's not as bad as it sounds. It's basically where they get a group and just try to group everybody into one big group of individual crimes.
Yeah, so basically it's a conspiracy theory.
Right.
Yeah.
Right.
It's a one big conspiracy theory.
So, okay, somebody say the whole office of Fulton be placed. Yeah, it says a lot of people still sitting in jail in Fulton County, trying to get. And my thing is, if your jail is overrun, it's falling apart.
Yep.
And you got all these people sitting there waiting for trial. Why not release them if they non-violent? And you can't even trust them when they say that you can't release them because they violent. And the only way I would release you is if you're on probation.
Yeah.
So okay, so a piece of paper of probation is going to stop someone from being violent.
Not in America.
No, she's in Dallas, Judge Boyd, but I do watch it from time to time when I get a chance to hear on YouTube. But yeah, I like her from what I've seen so far. They say you like her because you ain't practicing in front of her. Let me get some Dallas judge lawyers up here. They're gonna say, But it's for the most part, I've always seen her be fair. Yeah. But I don't know what's going to happen. So I guess Weinstein's saying that the transcripts are not released yet. Coco, do you know that? Or anybody else that went over there to Megan's channel? Oh, thank you, Amy, again with the super sticker. That's kind of you. Always supporting.
Yeah, thanks, Amy.
All right, thank you. Thank you, Amy.
Yeah, Glanville has become a household name across the country. I mean, everybody's popping up. This is one of the stories that seem to be, got people fascinated behind this, especially after Steele went to jail for his client. Well, not to jail, but held in contempt for him.
Right. Yeah, I think he would have, Brian, he already kind of made him a national hero. But, Kayla was so worried about going to jail. I mean, who wouldn't be?
Yeah.
But if she would have spent one night in that jail, they would have paraded her around in the streets.
Yeah.
As a hero,
yeah.
Because from what we've seen so far, he had no reason to even attempt to try to hold her.
And he done folded now. I don't even want to have a hearing on it. As far as I'm concerned, it never happened. It's on hold indefinitely.
Somebody get Judge Glanville in the chat. Tell him
to
come over here. We got some questions.
Yeah, Judge, we need some. You got a lot, but I don't think. I mean, he could be defiant the whole time. He gonna go out like Trump. I did right the whole time. He's gonna be defiant.
He gonna go down with his shield or own it, huh?
Yeah. I did it. Deal with it. That's basically his approach. You can always have appellate court review it 10 years down the road.
But it was just so curious to me. He kept insinuating that Woody was being threatened. His life was in danger.
Yeah.
And then Kayla comes on over at the Lee's channel, and she said that it was nothing like that happened. The only people that was threatening him was the judge and the DAs.
Yep.
So I'm curious as why the judge read that in the record.
But did they ever say who called for the ex parte meeting? I mean, Woody was already in jail, wasn't he?
Woody wasn't
in jail
there
from Friday to Monday, and then Monday morning is when they had the ex parte. So
right.
I can see him being threatened in jail. I can see that vantage point, that somebody might have threatened him or knew that he was in jail, and they can get to him. They probably would.
Right. But you gotta, Kayla, she's saying that today.
Mm-hmm.
So we gotta remember, Kayla talked to him that same morning when he came from the jail, and I'm sure she talked to him since then, and especially since today.
Yeah.
So he would have told her, like, hey, that was his lawyer. Hey, I'm being threatened in the jail. She said that none of that was ever mentioned. Matter of fact, she said she was escorted up even before Woody was, before he was brought up from the jail, because so they can't say, okay, he's receiving these threats. They already had the meeting planned.
Exactly, yeah.
That meeting was only for the purpose of getting him to change his mind and to testify.
Yeah.
That
made them look really bad, and he would decide not to testify after pleading the fifth.
Right. So, when Kayla, when she came over here and talked to us, she essentially said that it was 14 people there, and the judge was trying to say it was attorney-client privilege. She said it was the prosecutors, the security guards, and come to find out, if they body cams were turned off, or Ms. Weaver, wasn't there, that's going to be an issue. Because my thing is, if they weren't there, then we can say what we want to say. Woody can say what he wants to say happened.
Yeah.
And then
remember, he's going to ask Woody.
Right.
He's going to ask him.
But my thing is, the judge, if you had them turn off their body cams, or if you told Ms. Weaver to leave the room so she can make a record, then anything Woody say is to have more credibility, because you can't say Woody's lying. No, you shouldn't destroyed the record, tampered with the record. So now Woody have more credibility than me. If Woody said that you pressured him and y'all had him jacked up in the corner, we're going to say that that's what happened.
Right.
And it's nobody's fault but y'all for taking away the cameras and the court reporter as evidence. Judge only listed, Judge only listed 10 people in there. Kayla said it was 14. But I don't know. Yeah, I don't know if he called them all by name. I think he just said like the court security. So that could mean, Yeah,
he said the deputies.
Right.
Hilton, Love, the two investigators, himself, the court reporter, Woody, and Bumpus.
Right. So when we come to, deputies, that could be 2, it could be 6.
Yeah. So we got him and so let's Miss Kimmy count. So Woody, Bumpus, Love, Hilton, the judge, the court reporter, the 2 prosecutors, the 2 DA investigators, and then 2 deputies. So that's 10. That's about right. That sounds about right.
Yeah. And I mean, in Woody, he's still at a disadvantage.
Yeah, that's a lot of intimidation right there.
She said she thought he named 4 deputies.
But that'll put us up to 12 then. That's still, 10, 12.
Right. Yeah.
That's still a lot.
Yeah.
There's a lot of people in one room. I don't know how big the chambers are.
Yeah, that's really, for the purposes of this, that's,
Now, would the prosecutors, investigators be allowed to be in the room at that stage?
And that's the whole argument. I don't think so. Not without the defense. Yeah. Because a material part of the trial is happening behind closed doors. She said, but he be leaving folks out. Maybe he was counting his dog. His dog was in there. So I'm going to subpoena the dog.
Yeah, we up to 10 people regardless. That's 10 no matter what.
Right. And that's, for the purposes of this motion, he says 4 deputies in their names. He says 4 deputies in their names. Thank you so much, Ms. Kara Clemens. Will the jury know now about the secret meeting? They been new.
Yeah, they knew. Yeah, I know. Some family member told them, "Hey,
right.
today, guess what happened?
Thank you so much for that. Yeah, but yeah, come on. They sitting at the house.
Yeah, they know.
They know. And even if they're not watching any social, I mean, you can't have not only TV, but if you open your phone, Instagram, TikTok, all the Twitter.
Ain't no way these jury members stayed off social media over these last 6 to 8 months. No way.
And especially more so now than ever because they've been at home for a long time. And now they're starting to get curious, like, what's going on? Mm-hmm. What's really going on? Why are we still at home? What's going on with the trial? So I'm sure, or like I said, family members, hey, such and such, I know you on that trial. Guess what? The judge about to be kicked off.
Yeah.
What, girl? What he did? I knew it. He's somewhere right about him this whole time.
Taking out them damn breaks. I know for a fact the jury is mad at the prosecution because they're taking so long. We didn't sign up for this.
Right.
There's no way we signed up to come in here every single day for this same mess.
Take us so long to say nothing.
Yeah. I don't give a damn about Woody or Bean or any of these guys.
Somebody said the jurors, they writing their books.
Yeah, I can't blame them.
One thing I can't, especially in trial, attorney is wasting time. When they say the same thing 10 times, 10 different ways, like that's how attorney Love do. She'll say the same stuff over and over again.
Yeah,
while she's talking to the judge. I'm like, okay, you already said that. And see, Judge McAfee, he's real good. He can say, we covered that already. Let's move on.
Move on. Sadar in the courtroom with him. That's the best in the business. Steve Sadar, one of the best ever.
Oh, yeah. With his cowboy, they call him Attorney Boots. With his cowboy boots on.
Yeah. Sadar don't play.
He don't play. Like, yeah, I'm with the judge. Let's move on. Don't belabor the point. We got it. You want the judge to do. And the thing is, she tried so hard. We already know that the judge is leaning your way.
Exactly, yeah. So
you don't gotta play it off that bad. Just make your argument. He gonna rule in y'all favor and sit down.
But you've seen it happened last week or the week before last a couple of times. Love and Hilton, he's made a judgment against them. They've re-argued it and he changed his mind.
He changed his mind. Yeah. That happens all the time, and that's when I think Doug Weinstein, no Harvey, he said, "Judge, that it got to come a point in time where you're gonna have to stand on what you said.
Yeah,
you can't keep changing your ruling. When you make a ruling, you have to stand on it, and the prosecution have to honor it." But he said DA Love would talk the ears
off a donkey.
A donkey. That's what he said. Y'all can find the tape.
What Steele and Love is Steele say, I don't give a damn about Miss Love. I care about Jeffery Williams.
He said he done with her.
Yeah, he done with her.
He done. As far as he's concerned, Love don't even exist no more.
Yeah. The Love is a disaster, man. She's the most hated person in any chat room that watching this trial. I mean, they hate Love.
I think even so, I think the jury as well.
Yeah.
I mean, the prosecutors, like, I think they win in certain small battles with the judge, but it's gonna cost them the war.
Yeah, with the jury. Yeah.
And if Fonnie Willis know, like I know, DA Love she's not a likable person.
She bad for business.
She bad for business. The jury will vote the other way just because they don't like her.
I understand that trick.
Right.
Yeah, that's the way they're gonna talk for real.
So I'm not understanding why Fonnie won't, why she don't see that. And not only that, people are saying that DA Love is gunning for Fonnie's job in the future.
Now, that's not going to happen either.
Right, yeah.
That's not going to happen. Yeah, I can put that rumor to sleep right now. That's not going to happen.
Yeah.
Love couldn't beat you or I right now.
Come on.
She can't beat nobody.
Matter of fact, she recently ran an election in a smaller county. She was trying to be the DA over there. Love.
Wow.
And that dude beat her with a stick.
Yeah, you see the results of it.
She didn't stand a chance. Let me see if I can find it. Hey. Somebody say, why you being so tough on her? You got to pray for him. Well, guess what? DA Love.
Have kindness in her heart. Amen.
Right. Come on. Let me see. I'm gonna show this right share. Can y'all see that?
That's in Dublin.
Dublin.
Wow. Is that the same? That's not the same Love, is it?
Yeah, that's her.
That's her.
Yeah, that's her.
Adrian Love, right? Yeah, she wasn't gonna win in Dublin. That's right there in Central Georgia. She's not gonna win down there at all.
Right. So why she go down there wasting them folks' time?
Didn't stand a chance.
Why she go down there playing
No,
with them folks in Dublin?
no, that's not gonna happen.
And people, you know, they get upset. Y'all talking about, hey, she playing with these people's lives.
Yeah, and the jury's lives too.
And the jury's lives. The
Yeah.
least we can do is say a few things about on YouTube. Golly.
I mean, honestly, like right now, the jury has been compromised to the fact that it's like their whole equilibrium is off right now because they don't know what to think. I mean, this trial keeps stopping and starting. I mean, in your experience, how long can you give a jury off?
I've never seen nothing like this happen. I mean, even when they're trying to come to a verdict, like right now, I don't know, do they have a verdict yet in the Karen Reed trial? Let me see. That's the lady that supposedly ran over her
boyfriend in Boston.
Right. Oh no, he declared a mistrial. Look.
Wow.
He declared a mistrial. I just searched it. Right, because the judge was trying to force them to he was trying to force them to come to a decision. And we're already on like day 4.
Yeah. He should have gave him a little bit more time.
Yeah, just a little bit more. But after that,
what lawyers always say, we only need one.
We only need one.
We only need one.
And I'm curious to know what the count was. See, I go back there. If I was a lawyer, I go back there and talk to him. And if it was like hey, it was 11-1, 11 not guilty, 1 guilty, then that can give you an idea of where they at.
Yeah. Because
I'm sure the prosecutors now, they're going to have to decide whether to retry the case, or they may even go at it with a plea deal.
Yeah.
Like, hey, instead of chancing it again, we'll give you a plea deal, probation, or, time served or something like that. Just as long as you admit that you did it.
She got support now. She can raise money at this point.
She got support.
She got support. She can raise money. She seems like a sympathetic victim as well at this point. So no.
And then she also see what we see in this trial.
Mm-hmm.
We see that the prosecution case is not as strong as they thought. It's weak.
It's weak.
So now she probably feel like, okay, I can beat them now.
Yeah.
So I don't know even if they should even try this case again. But from what I understand,
she has a lot of support now.
Well, she said the judge is going to meet. You talking about for Ken Reed?
Oh, I guess they're going to meet to decide if they're going to have a retrial.
That's probably what that ought to give the prosecutors 3 weeks to figure out if they want to retry this case.
Mm-hmm.
Oh, LaShawn said yes.
That sounds about right. That's reasonable.
Yeah, y'all can't make up your mind in 3 weeks like this other old school judge with the other YSL co-defendants. The one I don't know his name, but he old school, the one we talked about earlier.
Yeah.
He was trying to tell them, are y'all taking a plea deal or we going to trial? And one of the lawyers said, we're still working it out. We're still trying to see. And the judge was like, no. This case been going on. He said before the creation of Adam.
That's a long time to sit in jail 2 years without a trial. That's crazy.
And the lawyer's still talking about plea deals. We passed that. And the judge was right. The judge was like, if y'all don't have a deal in place now, then we're going to trial.
Exactly.
And that almost is a sign of it can show a sign of weakness to the other side.
Mm.
You've been working with them trying to get a plea deal for a year, 2 years, and y'all haven't been able to work them out. But now, you're in court asking the judge, maybe judge, there's a chance that we can work something out. I would have been like, no. As soon as the judge asked me, no, judge, you ready for trial?
Can they have 2 YSL trials simultaneously?
I don't think so because D.A. Hilton is working both.
Oh, she is? Okay.
Right. She was there in that room that day. So there's obviously she can't be two places at the same time. So, but she, you know, she told the judge at the end of that hearing, she said, well, since nobody's taking the plea deal, I guess we're going to handle them after we get through with the first trial. And that was funny to me.
Yeah, that's crazy.
I'm like, how you going to handle, somebody you going to handle something. You can't handle what's on your plate now.
Exactly. Yeah, that's crazy.
And she better be scared.
Yeah.
If this transcript come out and it's showing that she's telling the witness to lie, and as attorneys, we are sworn, we're always under oath. We're officers of the court. So you definitely don't want it on record that
you voluntarily
you
in perjury.
Right.
Trying to deceive the court. I mean, that can be a bar offense right there.
Yeah. Yeah. And that could come after your license.
Yeah, that's what you don't want.
And how you gonna work as an attorney with no license?
No, you can't.
You can't.
You can't. It's just that simple.
At that point, it becomes a piece of plastic.
Yeah, a memory of that.
It's gone.
Yeah.
And also, and the judge, you know, he made it seem like he's going to report Kayla. I don't think.
No, that's not going anywhere.
If you know, like I know, he better leave that alone.
Yeah. Hey, give me 3 minutes. I'll be right back.
Oh, yes, sir. Go ahead. Yeah. So anybody that's joining in, if y'all don't mind liking the video so it can spread. Y'all spread everything else. I'm just playing. Boy, some of y'all be on here for a while on YouTube in general, not just here, but on YouTube. And then when it's time to go, do something, like say vote, for example, I'm not gonna vote. That's 10 minutes. The line too long. You might as well. Oh, it ain't gonna count. Well, do it anyway. Do it anyway, so you can think it count in your mind. Anybody else want to come up? Let me know. I'll drop the link again. They have any insights? Man, the last time I dropped the link, oh my God, it went crazy in here. I had it was like 10 or 15 people in the back trying to get up to gang up on this one woman. She said that Young Thug. She said Young Thug was guilty, all of them guilty. And she haven't even seen all the evidence yet. Boy, they jumped all on her. Somebody said, where that lady at? Right? She might be watching. Shout out to Miss Lavonda. Miss Lavonda, I have my email in the description. I thought you were going to email me. I didn't get an email or a comment. But yeah, they had her mad. It was crazy. And Coco, I think you said she said something to you, but nobody could figure out. I couldn't. Like, she said something to you directly, or she's talking in general? I mean, I don't think so, because they said Gunna didn't come in to testify. He's not on the witness list. So that's like a plea deal that the jury don't even need to know about. No, I was actually on live when they were debating, but it wasn't enough for me to see. We already know. We've seen this movie before. We know these politicians been around a long time, both of them. We already know one gonna say this, and one gonna say that. We know the talking points. But I did catch a summary of it. You couldn't help it, but it's been on social media. I caught a summary of it. It was the same old. Okay, here we go.
With the presidential debate.
Right.
Oh my goodness. I love Joe Biden, but I wish we had some better options, to be honest with you.
Right, out of the whole, the whole country. I know we got 300 or some million people, maybe more now.
Yeah.
This is all we got. This is all we got from all sides.
Yeah, that makes no sense.
Out of the whole country?
Westmore, governor of Maryland. That's who would have my vote.
I don't think. Let me see. Westmore, governor. And you probably like, how don't you know these people? Let me see.
Yeah, Westmore.
Oh, I think I know who you're talking about. Yeah. Oh, yeah. He was the first. But he's still young, though. I don't know if he's
50 years old.
Oh, he's 50?
Close to it.
Let me see. Okay, yeah, he's 45.
Yeah.
So he eligible to be the president, but and I think JFK probably was, young.
Yeah, Clinton was too. And Obama, yeah.
Yeah, I don't know. See, let's not talk about Joe. Somebody said we'll take Joe in a wheelchair. But
over
the thing
Trump,
is,
yes, over Trump, yes.
But see, he given his last years of his life, to his country. Most of us will be trying to play with our great grand somewhere.
Exactly. Yeah, him and Trump both. I mean, Trump, you got Mar-a-Lago. I mean, why would I want to be in the White House when I got Mar-a-Lago? I mean, please.
All right. So a lot of this stuff seems like it's more of a headache.
Yeah. Than it's what it's worth.
Than what it's worth. Yeah. I'll let these young folks take over.
Yes.
Because I can't, see myself trying to do all of this and that when I'm up there like that.
Yeah. And Trump, you got it made. I mean, it doesn't make any sense. Logically, it doesn't anyway.
Let's see what this say. I'm concerned because people in Fulton County were saying they still got to vote for him because they didn't cry. He says the one thing we'll learn is to be lazy. Yeah, I mean, we recently had an amendment they tried to pass on the Constitution because judges were trying to stay in office longer, and that amendment failed across the whole state.
That's in Texas?
In Texas, yeah, they wanted to increase the age limit for judges, and especially right now, that was a bad time to put that amendment on because we're looking at the age now of Congress and the people in office, and we're saying, okay, it's up there. So Texas, like, we're not going to increase any age limits right now. So a lot of judges across the country across the state had to step down, or not step down per se. They can't rerun.
No. Now Texas is Texas the only state where the governor can run unlimited terms?
Ooh.
Because it seems like y'all done had some governors that been in there forever each time.
Yeah, they get in office and don't want to leave.
Yeah, y'all. I think that's the only state that has it unlimited with no cap.
Let me see. How many states have unlimited for governor? Let me see. Okay, say 13 states do not. Yeah, 13 states do not. Somebody said Texas almost there. We got Texas so big, it's crazy. Like whole states can fit inside of Texas.
Yeah.
That's why we're like one of two states that have two Supreme Courts, because I mean it's just too much. I don't know if the other one is Oklahoma that have two. Yeah, Oklahoma. A Supreme Court for criminal and a Supreme Court for civil.
Oh, really? Okay. That's actually a good idea.
Yeah, I think so too. Because
that's a good idea. That's a good concept.
They can devote their time.
Mm-hmm.
If it's a death penalty case and we need to have a hearing right away, then you need justice that's not busy with let's say motions to remove a judge from Fulton County.
Yeah.
All right. See, the Supreme Court, they got a lot on their plate because in Georgia they only have one.
Yeah, it's only one.
And not only that, they have the laws written to where if it's a murder case, and since there's a murder case in this RICO, the lower level appellate courts can't touch it.
It has to go to the Supreme.
It has to go to the Supreme,
mm-hmm.
which is, wild in of itself, because normally you at least stop by the lower court first.
Yeah.
Just give them a chance to get it right, and then you bring it up. But to go directly up on all of them, that just seemed like,
Now, say for instance, total worst case scenario, Thug and his co-defendants were to lose this case. Wouldn't it go to the trial judge for appeal first before it goes to the appellate court?
When you say they lose the case, so you're saying if they found guilty?
If they're found guilty, yes.
Well, normally what we do here is file a motion for a new trial.
Okay. Which goes to the trial judge.
Right, it goes to the trial judge.
Right.
And then once that's denied, then you go through the normal appeals channels, like the appellate court, the immediate appellate court, and then to the Texas Court of Criminal Appeals, which is the Supreme Court for criminal cases.
Yeah, and I couldn't see Glanville issuing a new trial. I just couldn't see that.
No. Yeah, that the Supreme. Then since the immediate appellate courts can't touch it since it involves a murder case wrapped into this RICO because of Donovan Thomas, then it has to go to the Supreme. But yeah, I don't see Glanville. My thinking of him doing the right thing is long gone.
Yeah.
That ship has sailed.
Yep. These last couple of days, well, today, his goodwill, he followed the law for a change. I mean, that was a breath of fresh air that he couldn't fight it anymore. He realized that today, I can't keep resisting what they're asking me at this point.
Right.
Yeah, he finally gave in.
And I'm still trying to figure out what's taking him so long to release this transcript. Do I need to get on a flight and come to Fulton County, Georgia, and print it out? My damn self. Golly. It don't take this long.
Well, are you surprised?
No.
You can't be surprised at this point, not coming from him.
He holding on to it as long as he could, but hey, it's out.
Well, they tried to probably prepare some kind of press release. Well, he can't do a press release, so to try to, I don't know what his end game is at this point.
Right. I mean, it went from him possibly losing this case to maybe even him losing his bench. Because even after this case, I'm sure the lawyers are going to press the issue.
Yeah, you have to. You got to make an example out of him now to make sure nobody else is, putting on a jersey that they shouldn't have on one way or another at this point. This has to be punishment.
Right. Because if not, and we got to remember, these people still live down there. Yeah. And when I say these people, these defense attorneys. So there's a chance that they're going to have a case again that ends up in his court when the TV cameras are not there.
Exactly.
And if he's brave enough to do this with the TV cameras not there, imagine
what he been doing. Like this
dude
reign of terror forever right now. This just didn't start on this trial.
Right. So, and we got to remember the Supreme Court probably is only moving so fast, and I could be wrong, is because this case is gaining a lot of attention.
Exactly.
And when Brian Steele was, supposed to go to jail, I believe they moved right away.
Yeah.
To stop him from going to jail. Now, had they have done that, if it was just a normal trial, nobody knew about, nobody's talking about it, probably not. It probably took them a while to even, figure out like what's going on. Somebody said we're going to lose some jurors on this trial.
Yeah, you really don't have a choice but to lose some jurors. You've already lost some mentally already. They've been checked out.
Yeah, I wouldn't be surprised if some
every day.
Right. Some may even just flat out say, hey, Judge, I can't come back.
I can't come back. Yeah.
I can't come. At this point, I'm compromised. They can even say that if they want to.
Yeah.
Say, hey, Judge, I've tried to obey your instructions. I tried to obey the court orders, but every time I turned on the TV or I got on my phone, the radio, I was just hearing so much about this trial. So at this point, I believe I can't be fair. He don't got no choice but to let you go.
Yeah. I mean, think about the 12 jurors in addition to how many alternates does he have on this trial? Is it 4?
I believe 6.
6. Okay, 6.
Right.
Okay.
Right, 6.
Yeah.
So, I mean, I wouldn't even want nothing to do with it at this point. This is really a way for them to
to really figure out a way out.
A way out.
Yeah, this is your chance right here. Take it. If you
Right.
could,
Take it.
I'm done.
Done.
You gonna hold me in contempt too?
Big done. And it wasn't a juror held in contempt because she had her phone one day
I believe so.
that he ended up locking somebody up, locking it. That's insanity.
No, I think did he make a buy lunch?
He made
That was a different lawyer he
a
made.
lawyer.
Yeah. Again, another example of him doing crazy. Now, he made one juror write an essay or something, didn't he?
I believe so. And a lawyer. He made a lawyer write an essay too.
Yeah. See, that judge, is crazy.
Now, and that's real crazy coming from somebody that don't know the difference between civil contempt and criminal contempt.
Yeah.
And he don't know a lot of the different rules.
Yeah.
So instead of having people write essays, about random stuff, maybe they need to write an essay about the rules that he can actually read and learn something from.
Yes.
He
wanted to hold Steele in contempt until he complied. You can't do that.
Right, you can't do that. Right. And when he seen Ashley and them come in there, Ashley came in there with her famous pink coat on.
Yeah. The merchant of death is what they call her.
That's what they call her. Come on,
merchant
Ashley.
of death. Yeah.
I'm gonna have to get a pink tie next.
Yeah.
In honor of Ashley.
Yeah, Ashley don't play, man. I
Ashley
like
don't play.
Yeah, she do her homework. That's one thing. Ashley does her homework. She knows what she's talking about when she's saying it. She ain't just coming off willy-nilly.
Right.
Yeah.
And that's what makes her such a good attorney.
Yeah.
It's not about this drama and acting in the courtroom. It's about actually knowing the law.
Exactly, yeah.
And she came in there at a moment's notice. She got the call, hey, Brian's in jail. She probably like, what?
Let's go. Call the troops up.
She called the troops. They showed her 25D.
Yeah.
Somebody said they came in there like some superheroes.
Yeah, and you know what, Glanville, I can't have all y'all in my courtroom. I don't want you in my jury box.
Yeah.
So he only let her and the Sousa come in at that time. And she told him that, Judge, you put my client in this position. He didn't put himself there, and I respectfully disagree, ma'am.
Yeah, he said he don't want nobody in his jury box.
Yeah.
Dude, we'll stand along the walls.
Oh, yeah.
Over no, we stand on the walls.
Yeah.
No, you don't want him in there because you're wrong.
He's wrong.
There's two left shoes.
Yeah, he had him in there today. He had at least about 6 or 8 extra attorneys in there today.
You see how much room opened up?
Yeah. All of a sudden, it became Moses in there. Yeah.
Right.
Yeah, Glanville.
Hey, Rod. Yes. Like what? What you mean? He said security reasons. Ain't no security. And Ashley said these are members of the bar.
The bar, yeah.
They're not gonna come in here and jump on you.
They got to be searched in security protocols. They got searched when they came into the courthouse. I mean, what did they put some kind of magic trick on going up 8 floors? I don't get it.
That's so wild because in some jurisdictions here in Texas, if you're an officer of the court, then you skip the security, to get in the courtroom as fast as possible, get in, get out. Because here in Texas, you may not. It's not a small town, so you're not going to be in one courtroom the whole day.
Exactly. Yeah.
You need to get in as fast as possible, get out, go to your next court, so you don't hold it up the process. And you don't have time to be waiting in a long line like you at an airport, taking your shoes off.
Yeah, he's just making excuses. I mean, we see in the same pattern of behavior where it just seems so uncommon, I guess would be the right word, that you don't see in a normal courtroom, the things he's done and the things he said.
Right.
Yeah.
Yeah, I agree. He really crossed the bound on all norms. Nothing is not the same, since he did this. Once he put on that prosecutor uniform with the P on it instead of a J, it was over.
Yeah.
It was over. He can't come back in my eyes as an attorney. I'm not, and I don't want people to be confused. I'm not talking about him as a person, as a man. He served the country, all this and all that. He may be a good husband at home with his wife when he not sitting in DA Love face.
Yeah.
But I'm coming at him basically because of his judicial duties when he's in the courtroom in that black robe.
Exactly.
Now, that's all I'm worried about. It reminds me of Dak Prescott, the Cowboys. He was the quarterback. And people were saying that he got to go. We keep losing in the playoffs. He got to go. And they were
replace him with.
Right. And people were saying, we're not talking about him. He's a good father. He's a good husband. He's a good man.
Mm-hmm.
But we said he got to go as a
quarterback for the Cowboys.
For a quarterback for the Cowboys. We ain't talking about none of that other stuff, but you got a good question. Who are you going to replace him with?
Yeah. Well, you see what I have on, don't you? And
Come on here.
I've been sick for the last 5 or 6 years now since Brady's been gone. It's hard to replace somebody.
Right. And he was gone before he was gone.
Yeah.
I mean, before he was officially gone, I don't know if him and
Belichick.
If Belichick was acting like Glanville, trying to run something stubborn. He acting stubborn. That's what we're trying to figure out. We want the transcript. That's what we just killing. We want the transcript. And supposedly it's supposed to be coming out, so we just trying to wait and see. I haven't seen anybody report on having it yet, and I believe they said even Weinstein don't even have it. I think they said he's still waiting.
It's been at least 6 hours? Well, no, at least 5 hours at this
Easy,
point.
right? Yeah,
5 hours,
right? And longer than that because
you came on after the fact.
I came on after the fact.
Exactly, yeah.
Right. So, and they said that he was trying to get everything together. Then somebody said the transcripts with Gad. I suppose that's the cop that lost her report. She ain't got a report nothing.
Yeah, Detective Gaither.
Wait a minute, you have it, Simone?
Email it.
Right, send that to the email. Yeah, you got that. Send that to the email. Oh, okay. Certificate of discovery. Oh, okay. Mr. Don. Shout out to Mr. Don again. Thank you so much, Mr. Don, for your kind contribution earlier today. Appreciate that.
Thank you, Don. Keep it going, brother.
Right. Always support. He's out there in the Golden State of California.
Clay Thompson got to find a new home.
Oh, yeah.
Might be coming to Dallas.
Come on over. Come on over. Everybody else, they switch teams so much now.
Yeah, it's crazy. Yeah.
Not defense.
Glanville ain't switched teams yet. Oh, he signed with Dallas already? Anthony said he signed with him. I didn't see it.
Oh, can you send it? What's she at? I got it. Talkthatlaw at Gmail. All one word. Talkthatlaw. It should be in my description somewhere. In fact, let me open it up. Oh, look, I didn't want to. Let's see what she got. Thug, Glanville, she do a ratchet.
3 year, $50 million. Okay, Ant. Thanks for the info, brother.
Oh wow. Okay, I haven't been on my let me see. want to thank Minister Fears. I've been I haven't even been on my emails. There's so much going on. Let me see if I can share my screen. That was kind of you. See if I can share it without having some confidential stuff on there. Thank you for the $100. He said, "For your God bless you, young man. Thank you. Thank you so much. Definitely appreciate that."
Yes, sir.
I'm glad I got to check my. See, I would have, I would have never knew. That was yeah. I just started. I haven't been on Twitter or Instagram. I just created them, really just to say the names. So nobody want to take them. Let me get your name. I don't use it. Okay. Yeah, that was kind of all of y'all. Let me see. Make sure I'm still not okay. Dear woke Christian. Oh, okay, we're both watching TL. I don't know why it's okay. Okay, that might be a good idea. I gotta reach back out to Dear woke Christian. He has a stream plan. Oh, thank you, A-Rod. She only sent the first page, but it's from. Okay, well, let's put her name because we give her credit. So they won't say I'm taking nobody's stuff. She only sent the first page, but it's from a gift from Virgo 4. So shout out to a gift from Virgo 4. Thank you so much for that. That was kind of you, Minister Fears.
Thank you, Minister Fears.
Yeah.
Keep watching.
Yes. I'm glad some of y'all stuck around. Wait, not. That's my email. Yeah, we can get that transcript. We be in some good business, so we can find out what's really going on.
What's really going on?
What's really?
Is it fact or fiction? Does still have a valid point, or was he a conspiracy theorist?
Right.
You know, we report the facts, not anything made up. We want the truth.
We want the truth. What's
we'll
going on?
call Steele out. If he was wrong, he was wrong.
Wrong, right. I want to see what's going on. Like Marvin Gaye say, what's going on?
Let's get it on. Let's see it.
Let's get it on. Car Global, you want to come up or nah? You just nah. Car Global was he said I called him out. I wasn't really calling y'all. I was just you had a different position than me. So I just wanted to see what your thoughts were. It wasn't nothing like that. So if you want to come up, let me know.
We're not anti-Glanville.
Come on.
We want the truth.
The truth. And the transcript's going to have the truth.
Yeah, fairness, transparency.
Yeah. Man. They holding that, ain't they? They holding them cards.
He done changed his mind. Love say, don't do it.
Don't you do it.
Don't you do it. Love done told him, don't do it.
She done down there broke her anger run down in them high heels trying to get to that chambers.
I wasn't in the courtroom earlier. I want to be heard on this.
Right.
You need to go to the appellate court first.
Right. Oh, man. Transparency, what a concept, right?
Yeah. We all want to believe in that, don't we?
Right.
It's like a fallacy at times.
And we still going to be raising, one eyebrow at least because you didn't wait so long to release them. Is it right?
Yeah.
Is it right?
And what did it say? The look of impropriety? If it looks like it, you don't want to cloud our judgment that we already skeptical. Well, we can't have an open mind when we do have it.
Right.
He should have released them when they first asked for them. That would have been, in my opinion, the best route to go. When they first asked for the transcripts, hey, we didn't do nothing wrong. Here it is.
Turn it over, yeah. Come on, Joe. I think Joe said he's trying to come up. She does. I just asked for the second page. Okay. Well, if you can send me that first page, we can get started on that.
Now, have you been on Thugger Daily to see if they posted it?
Let me see. 30 days. Let me see. Now I don't see nothing on his page.
It's not out then, because they normally try to be the first to the punch.
And he also has a comment here. Let me see what he said. Let's see if I can share it. That's a good quote that he put up. All right, go ahead.
Wow, that's true.
Right. Kind of poetic, that Lil Woody. Lil Woody, the reason that the case exists and also the reason it's falling apart.
Wow. I love it.
Oh, man. And see, he even said the case is on pause until a different judge
Decides that Glanville should be removed. Wow.
And that was 4 hours ago.
Yeah. So Thugger waiting too.
Right. So now we're going to be sitting in limbo because we don't know. The jury was supposed to come back on the 8th. Now we don't even know.
I doubt it.
That might even be grounds for a mistrial because I never heard of a jury been out so long. They compromised.
Well, you heard Miss Hilton say earlier that she didn't want the jury out indefinitely. I'm not sure what that means exactly, but she did raise the issue to the judge.
Right.
And you know, you heard what he said. I can't really comment on it.
No, I haven't got the email yet, Simone. Let me find out you done sent this to somebody else. Yeah, she said that, but
what does that mean, though? What exactly? How long can a jury be out? Since all this is new territory for everybody.
Right. This is maybe grounds for a mistrial, but as far as what she's concerned with, I hope she don't think she's still winning this case, or if she ever was winning it.
No.
Like, hey, I don't want the jury out. The jury already been out. They were out before they were out. The jury
love is a complete and utter miscarriage of justice within herself. So, if any black women, I'm just gonna be honest, any black women gonna dislike her on sight.
Y'all heard what he said on site.
Yeah, they
on site.
Her behavior.
They said Woody wasn't dealing with D.A. Love because she supposedly locked up his brother. Somebody said they been out long. So I said D.A. Hilton, sit down. You talk about the jury, she concerned. They been out. They been out. What you need to be focusing on, did you pay the court reporter enough to take that line out?
Yeah.
Where you told Woody he can lie.
And see, still wouldn't have pulled that out his hat just for the hell of it, I don't think.
Right.
And I don't think whoever told him would have just made that up.
And we know for a fact that he talked to Kayla because it's on video. The judge said today, Kayla's on video talking to Brian Steele.
Yeah.
So in my mind, if Brian Steele was comfortable enough to say that in open court, somebody that was in the room told him.
Yeah.
I'm not saying it was Kayla, but somebody told him.
Yeah. And the judge, you remember how angry the judge got because of the fact that he felt like Steele had too many details.
Right.
He had too many specific details. Not that the ex parte meeting happened, but everything that was said within the ex parte meeting.
Right.
Almost verbatim, almost. Like he already had the transcript.
Right.
Yeah. And I just don't see Kayla Bumpus, just making that story up just for the heck of it, or whoever said it. I don't see them making that up. I just can't see that.
Right. No, because it was too specific. Now a lie is usually more general. but they said what was said, who it was said by, who it was said to.
Yeah, and what the reaction was.
What the reaction, right?
Yeah.
Right. The judge co-signed it.
Yeah, he co-signed
So
it.
yeah, that's roll a whole
He
lot
put
to
his
make
stamp
up.
on it. Yeah, he put his stamp on it. He
Right.
all but confirmed it to everybody when it happened.
Let's see. So let me see. I think we got a page. I don't know what specifically, or would he say specifically? It is. Let's see. So this was filed today at 11:20 in the Superior Court of Fulton County, state of Georgia.
Mm-hmm.
And we got the 6 defendants here. I'm glad they're using the real defendants so people won't be confused instead of using Khalif, you know.
Yeah, and a couple of those guys, they haven't mentioned at all throughout the whole trial.
Right. But a lot of them are getting the benefit of going to trial with Young Thug since he got some sharp lawyers.
Exactly.
They all can get a not guilty. Okay, we got certificate of discovery. This is to certify that I have this day in accordance with OCGA 17-16-1 serve counsel of record for the above listed defendant with a copy of the following marked items from Dropbox. We, the state, the crooked state, are also filing a certificate with the court. However, the media listed below, due to its nature, has/have not been filed with the clerk's office. Come on.
Yeah.
She's saying the media Brady material from DDA Hilton to defense counsel. Brady material.
So this is not the transcript information then, is it?
I don't think so. Let me. If you do not receive any of the above check items, please contact the prosecutor immediately. If the defendant elects to opt into the discovery process as required, okay, got the Dropbox link. Please contact me. Okay, I certify that I have on June 6th at 8:10, June 10th at 6:54, June 12th at 9:23 serve the within a foregoing Brady material upon the counsel record for the defendants by email to the court and said attorneys. Okay.
Yeah, this is not it, because this will come directly from the judge. It wouldn't come from Hilton.
Right. So it seems like this is some type of Brady material.
Mm-hmm.
And okay, I think she said she's gonna get page 2 for us, but let's pull up.
Now remember, Steele asked the DA's office for any Brady material involved in this as well during that same time frame. So this might be finally she turning that information over to Steele.
Right. And no, it's all right. No, it's not the transcript. I just seen what I had. I didn't know. No, I didn't have it. Thank you for that.
Okay,
Whatever else, yeah.
Thank you so much, Simone.
Whatever else you get, send it.
Please.
Yeah, we can dissect it. Kayla said, let me see. Kayla said Steele knew before she spoke with him. Right. She's saying that he already knew the information and she was pretty much called up on to confirm it. But we don't know what parts came from the other person, and maybe she filled in some gaps. Somebody said, what if it was Rudy?
Maybe Love told Steele she want this trial over with too.
You said who?
Love might have told Steele.
Love told her.
Yeah, we don't know.
We're gonna figure this out together. Yeah, but I'm keeping a sharp eye on his email.
Yeah, we should have had something by now.
She said, I've been on, right. Can double jeopardy? Somebody said, can double jeopardy be used in this case? Well, if it's a mistrial, it just depends on how the court rules. If it's without prejudice, that means it can be filed again. Mm-hmm. Because the only way it's double jeopardy is if it goes to a verdict. But a mistrial is not considered double jeopardy.
But if the judge dismisses it, since the jury's been impaneled, does jeopardy attach at that point?
Well, the issue would be if it's, I'm trying to see how to explain this. If it's a mistrial for purposes outside of the control of, let's say, the prosecutors. If it's a mistrial because of the judge, or it's a mistrial because a lot of the jurors got sick and ran out of people,
Okay.
then even though jeopardy is attached, it's not a mistrial because of the fault of the, let's say, the prosecutors. But let's say the prosecutors caused the mistrial.
Okay.
It's their fault. They've been playing dirty. They willing and dealing. They sneaking and creeping. They in the back room with the lights on talking to the judge. Okay, now, since the prosecutors caused it, you don't get a second bite at the apple. Now, jeopardy attaches and you can't bring it again. But for this purpose, it's going to be tricky because the court itself is alleged to be in
the cause of the problem.
The cause, right? The court itself. So how do you, remedy an issue with the court who's supposed to be neutral? But if the court is in bed with the prosecutors, and hopefully not literally, nowadays you never know. The court, right? The court's in bed with the prosecutors. Then could the prosecutors in turn be punished by the court saying you can't bring this case again, which I think is fair.
Yeah.
Young Thug shouldn't have to sit through this all over again because the prosecutors did something they had no business doing, and the judge went along with it. So I think it'd be better for the lawyers to attack the prosecutor's angle, the prosecutor's conduct, more so than the judge.
Now, in this right here case, since who would have had the responsibility to call the ex parte meeting, and who responsibility was to let the defense know?
Well, I mean, the prosecutors, they want to win, right? They want to win. Like I said, two teams playing. The other teams are going to do anything they can to get a tactical advantage or an edge. That's expected.
Okay.
You see players going to go talk to the referee after a call, trying to tell them, hey, you need to watch him, or that was a bad call. He's hitting me first. He's fouling me first.
Okay.
So you expect that, but the referee, the judge, is the person that we really hold to high regard. So, judge, even if I come to you as a person that's playing on the other team, I'm biased and partial.
Yeah, trying to get an advantage.
Right, but you as a referee, you're supposed to put me in my place and say, hey, I'm not going to accept your, I'm going to watch the game, I'm going to call it close, but I'm not going to make any backroom deals. I'm not going to let you influence the court, because being a referee, I know better. And I think she said literally in bed with.
Yeah, and so Love's argument was that this was a civil contempt between us and Woody and his attorney. It didn't have anything to do with the defense. Does that have any validity to it?
Well, if it would have been in theory, let's say the judge wants to know if Woody's going to testify or not. That's simple. He could have got Woody in there with Woody and his attorney. Hey, are you testifying, or are you going to sit in jail until you change your mind? Woody could say, no, I'm not going to testify. Okay, lock him back up. You don't have to threaten him, or this is what I could do, or just lock him back up.
Okay.
And you don't need the prosecutors in the room for you to do that.
Yeah, see, that's what I'm asking right there. Did
Right.
the prosecutors even have to be present at that particular meeting between Woody and his attorney?
And I think that's what's really the issue, because now it's been said that they bullied Woody into testifying, number one. So you intimidated a witness. Not only was the prosecutors intimidating him, you had the judge in on it. They said the judge printed up the law and showed it to Woody. And then not only that, it said that Woody, he basically felt like he had no choice because he's in handcuffs, and he's in a room surrounded by security guards, so he wasn't free to leave. So that's more pressure added on to him. And they essentially, not only that, they was telling him what he can and cannot say when he testifies. She's telling him, you can lie about this, you can't lie about that. So once you start, tampering with a witness like that, you need the other side in the room for sure. That's when they cross the line. They cross the line big time. And obviously, as a defense attorney, if a witness is in a room getting pressure to testify, pressure to change their mind about testifying, or given permission by the court, I mean, because the court co-signed it, the court didn't stop her from saying, hey, you can lie if you want to, I'm not going to prosecute you. I mean, all that's going on, I need to know about that because that's going to directly affect my client.
Exactly, yeah.
Because now you told Woody he can lie, he's going to come out and lie, and that could potentially put my client, in prison. Or you telling him not to say certain things about certain people like Donovan Thomas, that could also put my client in prison. So, of course, as a defense attorney, I need to know about that, and I need to know about it when it's happening, not 3 weeks later after the fact.
And still said that, Judge, you should have told me. I shouldn't have had to find out this way. That's the words out of his own mouth. He say, you should have told me.
Right. He's saying, who told you? And Brian, he was right. He said, you should have told me.
Should have told me, yeah. And he had a valid point with that. You should have said something, Judge Glanville. So, again, this is another self-inflicted wound. But shouldn't Love and Hilton know the same thing? They should have known, hey, we need to probably let the defense know what's happening at this point.
No, I don't think so. Because you got to remember, it's still a tactical advantage because they know if the other team is there, you're not going to get away with half of the stuff.
Mm-hmm.
You're not going to get away with half the stuff going on. Well, you more than welcome to come up, COE, capitalize on everything. If you say my analysis is wrong, maybe you work for the Fulton County judge. Come up here and defend your position. I don't care. He's on 265 people. I don't care if it's 20. It ain't gonna change the facts.
Yeah, we're not making
right.
Yeah,
what we made up? Please tell me.
I can take a correction.
Right. Please tell me what was made up. Was there not a secret meeting?
Yeah.
I'm gonna put the link for you. I mean, come on up. You have a right to defend your position.
Yeah, I want to hear this. Yeah. Please.
These are not facts. And I ain't have no interpretation. I wasn't in the room. We're going by what was said today. The judge said that Kayla was on video. And Kayla even mentioned it today on the League's channel. She revealed some more details today. No, I want to know, you said what facts? The transcript was not dropped, so how are we talking facts? Somebody said that's Glanville. Glanville on his burner account. Come on.
Thank you, Judge. Judge, we appreciate it, buddy.
Right, come on up. Come on up. The transcript was, we're talking about the meeting happening in the first place. It shouldn't have been no secret meeting in the back room, no matter what was said.
Yeah, that's not up for debate at that point. That's something that's not up for debate.
He's talking about, the meeting shouldn't have happened. I see someone always got something to say, but nothing to debunk it. That's what I'm saying. All right, we giving him the floor.
Yeah.
The floor, the chair, the mic.
We've said anything wrong. I mean,
right.
show us something that invalidates it and take it under advisement.
We're gonna give them all. Eric May say he didn't get the sofa, the chair, the flow. Hold on. Okay, and go ahead.
No, I'm reading what he said out loud.
Okay, yeah. The judge gave us 3 cases where it could have been done. Okay, and all those cases dealt with threats to a witness.
Direct threats to a witness.
And guess what Kayla said today on the lead attorney's channel?
Didn't happen.
It didn't happen. So where that leave the 3 cases?
And I think the oldest one he had was 86, was it? Oh, that's one of them from 1986.
Yeah, he went way back to 86.
I mean, like, dude, 40 years ago.
He went to go dust them off to try to come up here.
Yeah, just to have some kind of validity to what he said. He went to 1986, nothing in the millennium.
Right, but okay, well, you addressing the year, address the part where his own attorney said that Woody did not relay any threats to her. Yeah, he went and found some cases that dealt with if a witness threatened a judge allowed to talk to him in the back.
Mm-hmm. But I think the still sticking point was that the defense still had to be notified. Glanville had to keep this a secret the entire time.
Right, he could have notified them after the fact.
Yeah, he didn't do it at all.
Let's say Woody was getting threatened and they moved him to a separate county. He could have told the defense attorneys after the fact. He could have said, hey, just so y'all know, I had an ex parte meeting. We had a complaint that the witness, so we moved him to another county. Mm-hmm. And that was what was discussed.
Yeah.
And then we also have a record of it if y'all want to, review it or appeal it later on. That's easy.
Yeah, that was easy.
But this judge, what he did went around the world. He did tell them
you don't supposed to have it. It's ex parte.
Right.
Those are his exact words that they weren't supposed to ever know about this for the most part.
Right. Somebody said that's Ural family.
Yeah. So I mean, some stuff you just can't get around. I mean, in this right here case, if he would have had the meeting and say before they went into court and let the defense know, hey, we had an ex parte meeting. This is what these concerns were about. Here are the transcripts. Let's go from there.
Right. Well, I won't even say this is true. There is no timeline when he had to tell them. If that's the case, he can tell them next year. And if he can tell them next year, how will Young Thug's attorneys, Brian Steele, Keith Adams, will be able to cross-examine Woody about this information if the judge had no timeline? I mean, the judge had to tell them because they have to be able to ask Woody when Woody got back on the stand. Mm-hmm. Hey, is it true that the judge threatened you? Is it true D.A. Hilton gave you permission to lie? Is it true that's the only reason you're testifying today? So I don't know about that timeline theory. I don't think that's accurate.
Well, let me pose another question, and you help us all out with this. Let's say, for instance, nobody finds out about it until Woody is being cross-examined by Steele or Mr. Adams, and he brings it up. That, hey, the judge or the DA told me this.
Right.
Why he's being cross-examined. How would that play out?
Well, and that's going to be a big issue because now that's exculpatory evidence. That's what we just read. Okay. That's what D.A. Hilton likely sent over to the defense because any evidence that can exonerate the defendants has to be sent over by law to the other side. So that's probably what we just read. D.A. Hilton is sending over that Brady evidence, which he should have been sent over. And let me see if I can share my screen so we can all see what is Brady evidence.
Now, did she cure the problem before it became a pillable issue, or is it too late, or the time frame fits now?
Well, I won't necessarily say that it's too late per se, simply because they still have time to cross-examine Woody.
Okay.
It only, to me, it only seems to be a bigger deal is if Woody's off the stand and they didn't know about it, and then you can say, okay, well, my clients were only found guilty because you didn't release this meeting that y'all were pressuring him in the back room. And obviously it was a case of Brady v. Maryland in 1963, and the rule requires the prosecution that they must turn over all exculpatory evidence to the defendant in a criminal case, and it defines what exculpatory evidence is, and that's evidence that might exonerate the defendant. Mm-hmm. Now, if Woody is saying, that he allegedly killed somebody, that's exculpatory evidence. If Woody's saying, I'm going to lie, or, they innocent, that's exculpatory evidence.
Okay.
Or him getting pressured. So I'm sure that's what D.A. Hilton turn over because she knew she had to turn it over. Let me see if I can find that again.
So if Woody would have been on the stand and this would have came out, that would have changed the dynamics up again.
It could have, until the defense attorneys had enough time to investigate these claims. Let me see where we can find it at. So Brady material from DA Hilton to the defense counsel. And because of its nature, it hasn't been filed with the clerk's office.
That's a red flag within itself, isn't it?
Right, yeah. Right. So I'm thinking she's turning over, even though the court is going to release the whole transcript, and she still has a duty as a prosecutor to turn it over, no matter what.
But was she supposed to wait this long though?
I think the only reason she waited this long because she was trying to see if the judge could save her. But now the judge is releasing the transcript.
Yeah, he took away her cover then.
Right. So now she said, "Oh man, I got to release it."
Right.
But whether that's error or not, I mean, who knows? In theory, they're supposed to release it as soon as possible, as soon as they get it.
Yeah.
So defense attorneys can have time to investigate it. You can't just give it to us while we questioning the witness.
Yeah.
While they on the stand, we don't have time to give it to our own private investigators and figure out, get to the bottom of it. So she might not even be timely. It might still be kind of late. But now that the court is on hold for like 2 or 3 weeks, it might be hard to use that as an argument.
And she tells you right there the nature of it.
Right.
That sounds
right. That she can't release it. Right. Yeah. The nature of it. You can't tell a judge when he has. I'm not telling them nothing. The Georgia Supreme Court done already sat them down a couple of times.
Yeah.
So they're gonna be the ones to tell them. Crazy how they use an old case law. I always tell the defense, you got something newer, like the case law doesn't matter because it's old. Right. Yeah, I always ask the defense attorney, you got something newer, but when he quote cases,
they always in the 80s.
He got the whole.
Yeah.
I maybe jump out the window with my comment. This is a terrible thing. Fulton County Authority was so wrong. No, I don't think. Yeah, that sounded about right to me. I don't think you. Then the judge ruled. I'm trying to find. We already explained the timeline and why the timeline is important for the defense attorneys to have it. Because without having that evidence, they can't question Woody about what happened in the back room. How can I question Woody about what happened in the back room if the judge don't tell me about it? And according to your logic, the judge don't have a timeline to tell me about it. He can tell me about it in theory when the trial is over. How is that? That defeats the trial, right?
Oh my God!
That defeats the very purpose of the rule.
Exculpatory evidence.
He told them he would let it release before cross. And that's what we're waiting on. And the rules say that the defense should have been notified promptly. Somebody say, please move on. Judges may initiate, permit, or consider. Somebody said, picking and choosing to read the whole thing. That's how people do, even when it comes to Bible verses.
Yeah, as long as it fit us right.
We're gonna get that one little piece. And they say, hold on, but you got to keep on reading.
No. This is the one you hear the most. The money is the root of all evil.
Oh, yeah.
It's the love of money.
Right. They get that wrong.
Always get it wrong, man.
Right. All right.
Yeah. We all do it, so I'm not off the hook either. I've quoted Bible verses to fit my circumstances at a particular time and place, so I'm not off the hook either.
Right, and I tell people this is just our take on what we see in front of us, and that's why I wanted to drop the link. You more than welcome to come and defend your position of what you think is right, but he was not, and still rushed the point. So still is the poor lawyer. not the judge.
Yeah, Steele was supposed. As soon as he found out about it, Steele jumped on and did it. What he's
Right away.
That's why I'm raising it. I want to get this on the record. Those were his exact words. I need to get this on the record. I need to complete the record.
Somebody said the other day was the judge's nephew. I think he's sending different family members. He said, let him come. Come on. Whosoever will, let him come. I'll drop the link. Somebody said they working in shifts.
Yeah.
Getting over here to these comments. To me, the jury has lost all focus. Oh yeah. This is that's done. Only exceptions for scheduling. Believes no party will gain procedural, substantive, or tactical advantage. Now, if you get right, it's it right here. You got a witness jacked up in the corner, and I'm
with
trying
shackles on.
Right with shackles on.
Yeah,
and it might sound far fetched, but this is almost a literal picture I'm putting in my mind. They got this man jacked up and telling him, "You're gonna testify, and we're gonna hold you in jail indefinitely."
Yeah, and think about it. The Fulton County Jail is one of the most dangerous jails on the planet. It's like damn near Russia or Siberia
right.
jail. Yeah, not to get killed in there every week.
Right, and I believe DA Love, she kept in one clip, she kept saying over and over, you need to let your client know he's going to be in the Fulton County Jail. She kept emphasizing Fulton because she know that the other co-defendants in that courtroom are in Fulton. Oh, in Cobb County, but they got YSL, the other YSL associates, or some of them are in Fulton.
Yeah.
And they can get to him if need be. So I think that was kind of like an indirect threat. That could just be me, but for her to emphasize what jail, what does it matter with jail? Normally we say you're gonna be in custody.
Yeah.
You know, you're gonna be held in custody. But for her she kept saying Fulton County Jail, and I picked up on it. I said, she's sending a message to this dude that hey, you might not only go to jail indefinitely, but you might not make it out.
Somebody got shot in the jailhouse.
With a gun?
Yes, you can pull it up. I swear, you can pull it up. Somebody actually got shot while it was either the Atlanta City Jail or the Fulton County Jail, but somebody actually got shot.
That's wild.
That's real. Somebody got shot in the jail.
And for him to shot in jail.
Put Atlanta, shot in jail in Atlanta.
Shot in jail. And for those who coming in, we're waiting on the transcripts. Hopefully the transcripts will be released soon. And if we got the judge's nephew, COE, if they got the judge's nephew on the line, tell the judge to go in his briefcase and give us a copy. Let me see. I see a mother of a Georgia prison worker.
No, not that. No,
not that. Okay.
Yeah, it's been a while ago, but yeah, here it is right here. Inmate shot inside Fulton County Jail. I just dropped the link.
All right, let me see. Oh, you said you dropped the link? Okay, let me see if I can find it.
Yeah,
did I miss it?
It says this comment has failed to post.
Oh, maybe because it's a link, and sometimes they don't let you put links inside the comments.
Okay, I got you. Yeah, just type that in. Inmate shot in Fulton County Jail. So that jail has had its problems.
I'm not saying that it is safer or not safer. I'm analyzing the case, the law with the facts of the case.
Okay.
No, because COE said he lives in Fulton, or he or she, and it's safer without Woody and YSL gang. But that I'm not analyzing the safety of the community. I'm analyzing whether the facts fit the crime that they're charged with. Now, and like I said earlier, if they terrorizing the community, then the DAs can charge them individually with whatever crime they're accused of. If somebody breaking into cars, you get that person and you charge them with breaking into cars. Somebody breaking in the house, you do it like that. But for you to group everybody together and say they all doing it and they working with each other, that's a stretch. Oh, all right. Thank you, the Honorable Yvette Daniel, for stopping by. Former sheriff, and she gave her insight about, you know, her time in law enforcement and you know, things that what goes on and how officers are trained. Wait, what court? But thank you for stopping by. I know it's been a long stream. Okay, you said, okay, inmate shot in jail. What year was this?
2011.
Oh, okay.
But they've had, you know, just a lot of things happen in there. So
throughout the year,
what his vantage point is, if I got a way out of here, I'm gonna take it.
Right. But I mean, it seems as if, oh yeah, I do see it. You're right. Yeah, that's the one I just clicked on. But see, it seems as if he was prepared to do some type of time. Because we got to remember, on Friday, he went to jail. Like, Woody went to jail over the weekend. So he was prepared in his mind to do some type of time.
And also, you got to take into consideration, Woody's been locked up damn near every year for the past 15 years.
Right. So, you know, a weekend is, you know, it seems like it's light to him.
Yeah. But
so it seems like we have Thugger Daily. Shout out to Thugger Daily. And please don't come over here saying I'm taking this man's stuff. I believe when Kayla came over here and first talked, I believe he posted it there. So it's all love. We all sharing what we can share with what we got. Let me see if I can pull it up.
Still filed a new motion?
Yes, still filed a new motion. And we ain't got to go through the whole thing. We can just kind of see what we can see. And see if I can open it.
You almost got to ask yourself, how many more motions are left filed at this point?
So, okay, shout out to Thugger on Twitter.
Shout out to Coco, too. Coco, you've been doing a great job.
Oh, yeah, Coco on it, ain't she? Shout out to Coco. Thank you, JC. I love for the people, right? We just
JC, love for you too, sweetie.
Yeah, we're just trying to get to the bottom. Oh, okay, let me see. I want to share, but I don't know if it'll be big enough. Well, we'll just see what we can do. Oh, no, that's going to be too small. Let me see if I can blow it up. Hold on, y'all. Let me see if I can blow it up and make it bigger. It's because it's on Twitter. It's hard to... It's hard to really get a hold of it. Page 1. Okay, let me see if I can just save it and open it. Wait, who is this? Police investigators charge Lawrence cellmate. Or is that the shooting from Oh, hold on. Yeah. Okay. Yeah, we're waiting on the transcript. I'm gonna try to pull up what I can here. And since we're working with the links, it's kind of hard to present. Let's see. And if anybody else want to come up, let me know. Let me know. I don't know. Somebody said that his family members, they ain't come in and talk about with that straight job. Exactly. I'm just gonna save it and see if I can do it that way.
And so I know I mentioned Glanville mentioned earlier about a will that gets assigned to the judge. Now, who's going to decide? So that are they going to do that for that recusal hearing as well too? Is that the same way it's assigned?
The recusal hearing. What do you mean? I think he said they all gonna go to one judge.
Okay, no, I'm saying like the recusal hearing, the picking of the judge. How is that going to work? Who's going to decide who the judge is going to be at that point?
Oh, that's interesting. So what you're saying is if another judge get it and another judge kick him off,
yes,
who would be the new judge to take over? Yeah,
that's a long shot. Trust me, and a highly unlikely probability that he gets off the case. Not saying he shouldn't, but I just don't see none of those other judges standing up to him at this point. I just don't think they're going to be worth the repercussions they think they might face.
Right, and it all depends on what authority do he have as chief judge. Now, if his authority is limited, then there's not much he really can do.
Mm-hmm.
But if his authority is broader, but because it don't even sound like he control what cases you get. So I don't know. As I have to look and see what powers are granted to the chief judge, or is it more so an honorary title, which without much without holding much weight.
Okay.
And we're gonna try to get Kayla up here just to ask her just a few questions. She's probably tired. I know she wore out.
She's been doing the rounds. Kayla is
right.
a hero. Shout out to Kayla.
Shout out to Kayla. I know she probably wore out. It's a lot.
Yeah.
Can when you go to all these different channels and platforms and say the same stuff over and over again, I know it could be a lot for her. But it's gonna be hard to read. What I'm gonna just do is I'm just gonna read what it say, and just to give y'all an idea of what he filed. So he's filed a proffer, and a proffer is basically, Judge, had you let me do this, this is what I would have shown. Had you let me cross-examine Woody, this is what I would have got out of the testimony from him. These are the questions I would have asked. So it's showing the appellate court what you were trying to do, even though you could not do it because you was prohibited for whatever reason by the trial judge. So it ain't really the, we want the transcript.
Oh, you see what Coco said? Yeah.
What she say?
Yeah. She was saying what Bumpus said that where did it go? So I like that quote. That she Bumpus is not tired or worn. She gonna keep fighting.
Oh, come on.
I like that. Thank you, Coco. There you go. There it is. Yeah.
She said she not tired.
Yeah.
Yeah.
They're not going to release him no time soon. They still trying to figure out what the fallout going to be, more than likely.
That's what it's appearing to be.
Yeah, they trying to figure out the fallout.
Let me see. Which is crazy. I mean, because he had weeks.
Yeah.
Let me see. He had weeks to get this together. We need somebody to ask where he go. I think I've seen his name. COE, if you still here, can you please?
He said, well, what rule he wants you to show him?
Please tell your
uncle
to release this transcript.
Release the transcript. We Ronald Reagan, tear down that wall.
Right.
Please.
Take it down. What y'all doing?
Yeah, they trying to figure out the fallout. That's the only thing I can think of. I'm probably wrong, but I think they're trying to figure out how we spin this before we release it. This is gonna look bad.
Bro, now you just know he coming in court today. You would have just knew that he had it together.
Again, I thought from my understanding, maybe I misheard this, but he said that he would have the transcripts ready for the defense to go in there and read today.
Oh.
He said he would have them ready where they could go in there in camera, because you remember they had an argument because Steele wanted Thug to be in the room when the transcripts were being read, and he told Steele that Thug couldn't be in there.
Right.
So he made it sound like today when they came in at 9 o'clock this morning, the defense attorneys would get a chance to read over the transcripts, but obviously he backed out on that too.
Yeah. He notice of attorney proper. And I'm trying to figure out, he had no reason to keep them out of the room in the first place.
Yeah, this could all been avoided. This was a self-inflicted wound. This was self-inflicted.
Somebody said he didn't went on back home to Glanville's house.
Yeah.
But the thing is, he said it's going to be a secret, but supposedly he sent an email last night saying he's going to make it public.
Still hasn't done it.
Right. So my thing is, notice of attorney proper. Let me see. But for him to stop the case completely, that threw me for a loop. I thought he was going to at least try to keep working until
until they got around to it.
Right.
Yeah. Now, based on the rules, basic rules, was he supposed to stop it at this point so another judge can hear it?
That's what it sounded like he read today. It sounded like he acknowledged that the rules said that he was supposed to stop and give it to another judge. Okay, we got somebody else. Carr, why don't you come up? Laugh aloud. Y'all got any criticism for the defense? Or y'all pro gang members? Laugh aloud, just ask.
Stop.
Now, you could, I guess it would have been a fair question if the defense was in the back room with a witness.
Yeah.
And
a sworn in witness.
Right. And the prosecutors found out about it. I guess that'd be a fair question.
Yeah.
But
or if somebody's intimidating any witness, whether it be Woody or anybody else, that's wrong. Simple as that. No witness should be intimidated.
Right.
They should have a chance to come into court and tell the truth without any pressure from either side. No more, no less.
Right. And Dee makes a great point. The defense doesn't have a case to present. The state does. The burden of proof is on the prosecutors.
Exactly.
And it's hard to really, talk about Brian Steele saying that he did something wrong when he did the right thing by calling the judge out.
Yeah.
Now, had he sat silent, then we would have had an issue with him.
A huge issue.
He's right. Had he found this out and didn't say nothing, oh yes.
Yeah. Or if he put a witness, if any of those defense attorneys put their own witness on the stand and didn't witness prep them or know what they were going to say when they asked the question, that would be defense malfeasance right there within itself.
Right. Exactly.
So we're not criticizing the prosecutors per se. We're criticizing their methods and the judge's methods.
Mm-hmm. Because the judge is the one at fault.
Yeah.
And
that's self-inflicted.
Right. Yeah. Self-inflicted. So Car Global, that's why, now if you just wanted to just make up something to talk about the defense for, I don't know, maybe they wore a light color suit instead of a dark color suit.
Yeah. At this point, there's really not a whole lot to criticize.
Right.
I mean, because anytime an objection comes up, they raise it. Anytime there is something they wanted to discuss, they bring it up. So, I mean, if they weren't doing that, then you have a serious problem.
Right. He just, and I know we get a few of them every once in a while that come over and have different opinions, and that's fine. But my thing is, if y'all, you have an opinion,
support it.
Yeah, support it. Just give me some. You got to support. You got to stand by your argument. If you're gonna get a degree in school, you write a paper, a thesis or a dissertation. They're gonna want you to defend it.
Yes.
They're gonna ask you questions about it, and you gotta explain to them why you took the position you took.
You can't just take one. Oh, you wrong, and did not.
And right, you wrong, and I'm gone, and log off.
I don't mind being disagreed with. Help me understand your vantage point.
Hold on, Glanville responded. Let's see. Glanville responded saying the court clerk has to assign it to another judge. I don't have anything to do with that. No, you said you're going to release the transcript, though.
He made that clear.
Right.
Multiple times.
You don't need no court clerk for that. Just give it to one of the lawyers. They can upload it. Yeah. No, something ain't right.
Glanville trying to bow out at this point. He's trying to figure a way out.
And yeah, I mean, they said he started way late today.
Way late compared to what?
Oh wait,
Get
right,
prepared to which time?
right.
Yeah. I mean,
They say he. Let me see, Brian. Let's see, yeah. Let me see. File type.
I know we over 5 hours at this point, if not longer, since he said that.
Right. And we still don't have none. For those who popping in, we waiting on the transcript. We want to go through the transcript. I believe somebody said he on Pacific time. Yeah, we won't know if it's the real one. I guess we'd have to verify with Woody and Kayla.
Yeah, Kayla say once they come out, she's gonna make sure she fills in all the blanks.
Right. Yeah, I think Kayla said once the transcript comes out, she'll be able to talk more in detail about it. Which I kind of get it. I mean, it's hard to really talk. Yeah, that's I'm gonna pop on over here just to say something, just and don't know what they be talking about. Some of the stuff. And somebody said, "Oh, you doing this and doing that. You taking their views."
This is obvious. This is not a alternative vantage point. These are what we're seeing with our own eyes.
Right,
Simple.
right. You sure right. You
And okay, you remember maybe a week, maybe 3 weeks ago, the guy that sits in the corner with the African American gentleman with the gray beard. He's a lawyer, and he was saying that he made an objection that Woody didn't even know his client, and when Miss Hilton asked those questions, and he asked for a mistrial based on that. What was the basis for asking for the mistrial?
Wait, which one?
The guy that sits in the corner, he sits in the far right, and his lawyer has the gray beard, the other black lawyer that's involved in the case. So you got Weinstein in the front, and then to your far right in the corner, it's a black judge. I mean, a black lawyer.
Oh, I think he got a son that is it Matthews?
Yeah, I'm not sure what his name is. I don't think I ever knew his name. Matthews, okay. YSL Matthews, okay. Yeah, and he asked for a mistrial based on the fact that Hilton tried to link his client into an event that happened before Woody even knew his client.
Oh.
But obviously the judge denied the mistrial, but he was like, why are you asking about my client involved in something that, you know for a fact that he didn't have anything to do with? And Glanville, denied the mistrial right there as well.
Probably just put it in their heads.
And that's what he raised. He's like, you getting in the jury's mind that, you're asking a question that doesn't pertain to my client, and that Woody would not have any knowledge about.
All right, somebody, wasn't your client in the car when they shot up that lady's house? And they know Woody don't know. Woody said, I don't know.
Yeah.
It'll put in their mind that he must have did it. He must have did it. So yeah, they real slick. You gotta watch them like a hawk. Somebody said we need to follow motion for not in a timely manner. Right. We need to follow at this point, we need to follow our own motion. We need yes, Matthew Smooth. Yeah. He got a
okay.
Yeah. Yeah, he real proper.
Yeah.
He sharp.
And see, Steele is about the only one who's aggressive with the judge. He doesn't kind of hold back. Even Keith Adams will kind of be gentle about the way he asks questions and lays it out, and he approaches the judge in a real subdued manner. Steele is like, hey man, this is the way it is. And so you kind of like both approaches when it comes to those guys.
And I don't even think that Steele started out that way. he was always
yeah, he was a gentleman.
Yeah, he was always respectful and this honorable court this, honorable court that. He asked the witness, "Can I approach you?" Court, "Can I approach?" He was doing all of that extra stuff.
Until Adrian Love came on. Oh my God.
He said, now he's saying the hell with all that.
Yeah, man.
That's dead. That's
nothing to do with Miss Love. I could care less about Adrian Love.
Right. He done with her. He was trying to play nice. But see, playing nice, and she took advantage of him.
Yeah, she did.
And now he's saying that she made him like really look at the law in a different way. Because he said he really loved coming to work, but now seeing her sitting over there.
Oh my God, I hate to come in here.
Right. He said
I love what we do.
Love what we do.
Yeah, but I hate DVF. Love. Prosecutor love. But what do you think happens if Love loses this? Well, when Love loses this case, what happens to her? Does she have a place in the DA's office, or is she done?
I don't know. Fonnie had already kind of made excuses for herself. Why she didn't do nothing wrong with the Nathan Wade case. So they might, get together. Good. Why they trying to kick me out? All I did was trying to get Woody to testify.
Yeah.
And they get together and go have some finally say some Grey Goose.
Yeah. We can work this out in the cabin.
We'll work this out later.
They take it to the cabins. Yeah, you're right.
Yeah, I don't see her just getting. Because you got to remember, I always like to remind people that most of the stuff that happens from the top.
Yeah.
They know. Fonnie know who she got on this case.
Yeah, that's right. Yeah.
She the one that put it up. It always amazes me sometimes when people get upset with a worker. The first thing they holler out, where the manager at?
The manager's the one who trained them.
The manager trained to hire them, and they're gonna both laugh when you walk out and talk about you.
Yeah, let me go get a supervisor. Can you go get me a supervisor? Yeah, right.
And then they don't even be scared. Go get her. I'll go get her for you.
Yeah. That doesn't work. Now, if you want to call corporate, now that's different. But
no, that's different. That's different. And calling corporate in this case is the Supreme Court.
Yeah.
They didn't call corporate on Judge Glanville.
Yeah, exactly. Yeah, they have. That's a good way to look at it too.
They didn't call corporate because they can't get nothing done in there. Somebody said Love will open her own firm, and I want to know who's gonna be a client. Well, somebody said that Love below. y'all are wild.
Yeah, that's funny. But think about it, though. If you're a defendant, you kind of want somebody like that too.
That's like a pit bull.
Yeah, you want a pit bull who don't give a damn. Right. So I get it.
Right.
Yeah, I get it.
That's willing to put themselves in the jailhouse. Yeah. Right. She might not be. You got a good point, a real good point. Yeah. You need somebody that ain't scared to get in the mud.
Yeah.
Take the gloves off.
Oh, yeah. Yeah. She the donkey, and
Oh, she said they say her lowness has no bounds. She would go low as they can go.
To the center of the earth, she go over to the center. And then when she get there, it ain't as hot as y'all really think it is.
Come on. It ain't gonna be hot as hell. Yeah. So you're right. She might have a good little practice.
Yeah, we want Adrian Love on the show as soon as the trial is over with.
She gonna put her sign up.
Yeah. Talk That Law is gonna interview Adrian Love.
Oh, come on.
Yeah.
Oh yeah, that's something I definitely reach out for that.
You gotta have her on here as soon as she get done with the trial. Her and Hilton.
She gonna. Oh yeah, I can see her. Yeah, y'all both come and gang up on me like y'all ganged up on the mother lawyers in there.
Fannie Love and Hilton Law Firm. Done. Cut it out. Now y'all forgetting the name Glanville. Willis, Love, Hilton, and Glanville.
Glanville, right? Willie Love Hilton and Glanville. Y'all know what? I can see. Hey, we can get her on. She definitely more than welcome to come on and defend her position.
Yeah, Don, that's a good one, buddy.
He said they all her partners, huh?
They
Willie
partners.
Love Hilton and Glanville.
Yep, they are bound by the hip.
Yeah, that'll be good. If we can get them on, I can see her coming too. Getting her facts out, what she deemed facts. Let me tell you something. What you call yourself, talk that like Mr. Purple Tile. Let me tell you, you not gonna be talking about me. I'm saying, oh, for real, do tell. And what else?
I got a witness for you. Right? I got Day. He coming in and he know everything you did from 1999.
Ooh, right. Hey, we know what you did.
Yeah. Before you went to college, when you were still in junior high school, over there in that lady classroom, this is what you did.
This is what I
Come on.
Oh man. I'm telling you, they are. And
what Miss Shanti say, Glanville couldn't handle them women. She might be right. They'll kick Glanville out. He wouldn't last with her.
No, he couldn't. They'll run him out of there.
You walk around with he'll have him on a collar and a leash. Yes, goodness, yeah.
Yeah, and so my thing is the court, because we're in it's gonna be 5 o'clock here in Texas. So what time is it?
East Coast? Yeah, 5:55.
And how long do the courts stay open?
They closed at 5 or 4:30 rather. The clerk office closed at 4:30.
Let me ask him. Let me email back the Dear Woke Christian. He was saying that he may go on 7 o'clock Eastern time. So what is that? Is that an hour?
Yes, hour and 4 minutes to be
an hour. He's saying that he may go on to cover the transcript.
Sampson say Judge McAfee turned his YouTube off.
He did what now?
Sampson right here, yeah.
Oh, so he gone for the day. The court's closing.
That's McAfee, yeah. The court closes. The clerk office closes at 4:30 though in Fulton County. The clerk office does, but you can still file anything even after hours though.
Somebody said still did file. Okay, we're gonna see if we can find that.
Yeah, that's what you remember I said earlier. Still filed. He filed 2 of them, I believe, or it's 2 of them that's been filed before the 3rd one came a couple of weeks ago.
Okay, I'll put that in mind.
And the judge still ain't ruled on them.
Let me see if I can find Brian Steele.
Mandamus.
All right, let me see if I can find him. Okay, let's see one. Yeah, still just filed something today, and I see it. Thugger Daily had released some pages. It's basically just a proffer. Let me see. Yeah, but I don't think it's none of the substance that have anything to do with the Mr. Winfrey. Who is Winfrey?
He's one of the lawyers there as well.
Oh, he's one of the, okay.
It's Steele, Adams, Weinstein, Matthews, Miss Williams, and I guess Winfrey would be I think he's the older guy that sits behind Steele next to Shard.
Oh, okay.
Yeah, got his hair slicked back, and
Okay.
Yeah, he stood up and said that he heard them trying to intimidate Woody at one point.
Somebody said they thought Winfrey was a defendant. Wait a minute.
Well, maybe he is. Maybe he represents Mr. Winfrey, something like that. Maybe I'm wrong about that. I'm sorry.
No, I don't see any defendants with that name.
Okay.
Let me share my. These are the defendants right here. Unless he's a defendant outside of this case, maybe a defendant in a separate case.
Okay, YSL lawyers.
Oh, okay, so she just said Winfrey has a separate case.
Okay.
Let me see if I can find him. Jimmy Pee Wee Roscoe Winfrey.
Yep.
Lee. Okay.
Yeah,
So she has a good point. I am not surprised at anything these days, but a lot of people act as if they don't realize the defense are doing their jobs. What would you want if they represented you? Prosecution as well.
Valid point. But just don't prosecute just for the sake of trying to say you won.
Okay, I think I've seen this guy. Yeah, he hasn't seen his attorney. And I think one lawyer went up there thinking that he was the attorney. They said, no, that's the wrong guy. And right, prosecutors are not supposed to win and win. They're supposed to see that justice is done.
Mm-hmm.
And, you know, when you get a DA on national TV talking about her rate, her conviction rate,
yeah,
that don't seem like that's, you know, that justice is being done.
Yeah, you just looking at your stat sheet at that
point.
point.
You're looking at your stat sheets. But again, I'll ask the question, like the statement, you got a 95%, you not playing nobody.
Yeah, you can't be.
You ain't going up against nobody. And we got to remember, over 90, I think it's 98% of criminal cases have public defenders. Yeah. So most of that is you playing the public defender's office, and we already know they overworked and underpaid.
And plea bargain.
Yeah, you plea bargaining.
Yeah. And see, that's what I mentioned earlier about somebody like Brian Steele or Keith Adams or Steve Sadow and Ashley Merchant in another trial.
Right.
If you all think that Steele and Keith Adams and Shard are good, you ain't seen nothing yet until you see Steve Sadow and Ashley Merchant in action.
All right, somebody said she giving plea deals and counted as conviction. Yeah. A plea deal lawyer. The things in question that are debatable is not even how effective they are, but how, not even how effective, but how ethical.
Exactly, yeah, that's true. The Honorable Yvette Daniel, I like that.
Right, she said they all decline plea deals, which is bad.
Yeah.
The other hearing for the people that severed, they all said we don't want it, a plea deal, especially now.
Yeah.
Y'all been exposed.
Yes, you don't have nothing.
You don't have nothing. You just showed your hand.
Well, let me ask you this right here then. Let's just say for some miracle, this would have had all of these clients, defendants in the same trial. You got 6. So if you had, let's double that back to 12 of the original 28. What kind of chaos would that have caused what we're seeing now? Trying to, put all the evidence against all of these defendants simultaneously. Would that have worked based on what we've seen so far?
Can you repeat it for me one more time? Sorry about that.
Let's say, for instance, a lot of people got severed off this trial.
Okay.
So it's 6 people still on it. What if there would have been 12? Based on what we've seen from the prosecutor now, could they have handled a 12-person prosecution?
Oh, yeah. I don't think so. I mean, because they are getting manhandled by the 6-person team. And to imagine 6 more lawyers objecting and making it more convoluted, ain't no way.
Yeah, that's what I'm thinking too.
Yeah, I was trying to see the if anybody had the transcripts, but I'm not getting any emails back. And Dear Woke Christian, he wrote me back on email, but I think they're going to go through something else. Maybe. He said, you're more than welcome to come talk about the case. But yeah. So, she said they can barely handle 6 defendants. He said, hell no.
That's why I'm asking. That's why I want to ask you. Right. Like you. I don't know. I'm wondering, like, what would happen? It was 28 people charged originally? Something like that? 26?
I think so.
Just imagine how much chaos it would have been with that many people simultaneously.
Yeah, ain't no way. I can't see it. No. And then they got this Trump case going on, so it's gonna be the same situation. Everybody got their own lawyers. I think it's like 20 of them, almost 20.
Yeah,
that's gonna be
and these are not public defenders that Trump people have.
They're not.
They're not public defenders in that case, none whatsoever.
And then they have a fair judge, or what appear to be fair.
Yeah.
Ain't no way.
Who's going to handle all these different rulings before trial starts, more than likely?
Yeah.
He's not going to wait the trial and then have a week to cross-examine so-and-so and then go another week in order to go through what they said in a recent interview. They're not going to do that with another judge.
Right.
He's giving the state too much leeway, way too much.
Right. I believe so. Way too much. And at this point, the damage is done and there's no going back. Yeah. She said, Brown sitting there drinking Wendy's coffee, nodding his head, making faces and things. I'm so glad he gone. Brown, is that the DA Brown? Is that the one that sit on that back row? I think I know, yeah. Yeah, DA Brown.
Yeah, who was that? Maria 23. Rico ain't nowhere to be found yet. I agree.
Where that's at? You don't miss it. It's somebody popping up. Maria 23 on. Let's see. Oh, there we go. Yeah, Rico gone.
Rico gone.
Rico left Georgia.
He done caught the midnight train out of Georgia.
Not the midnight train.
Not the midnight train out of Georgia. Or she done caught the midnight train out of Georgia.
Yeah, that's crazy. Rico done caught the midnight train with who was that? Is that Gladys?
Is that Gladys?
Knight?
Yeah, I believe so. Yeah.
Leaving on the midnight train.
Night train.
Georgia, come on. Wow, Rico gone.
Rico gone.
Well, y'all, I thought we were going to get the transcripts, but it don't appear that we're going to get that today. And I really wish we could get the this document. Let me see something. Let's see. But I don't think this document of any substance when it comes to the.
They trying to do damage control, in my opinion. I think, and I would be doing the same thing. How can I put this out to the public that's going to be palatable? at this point.
See, what he filed today, he's talking about some old stuff, something that happened in May. Steele is complaining about a call that Hilton played. He played a Mr. Jimmy Winfrey.
Yeah, still trying to get everything on the record now. He want to make sure everything off. So this is another thing that the Supreme Court can look at just in case they have to argue in front of the judge or the Supreme Court. So he's trying to get everything on the record.
Right.
Which is the right thing to do at this point.
Yvette said, hey, did you see today Megan said she would be interested in speaking to some of the lawyers following this case? Yeah, I wouldn't have no problem talking with her. It seems like we're going to have some time, so maybe we can spread that out. Since the court's not going to be in session until we get another judge. We don't have the transcript yet, Quad Global. We're waiting on that. We're waiting on everything.
Yeah, I mean, think about this. I mean, we got a holiday coming up, so who's going to work Wednesday, Thursday, or Friday? The jury's not coming back before that or Monday, so this trial could go on. I mean, the jury could be out another week minimum, at least another week.
That's wild, because I haven't heard of a situation where a jury is out, just sitting without any interaction with the court, the trial, the lawyers, just nothing.
They at home. They probably, we might have a few jurors on here right now. I mean, they probably
they might be. They might be.
Don't know. I mean, they just looking right now and like, okay.
I wouldn't be surprised.
You can't be. You couldn't be. I mean, at this point, what else you expect them to do? Right. They want to find out why we're being delayed. I know the judge ain't telling them, hey, I messed up and had this ex parte meeting. So therefore we can't have trials. So he's not going to admit that to the jury.
Right.
So they got to go on their own fact-finding mission.
That's what I'm thinking, and I'm sure they are. I remember when Kayla first came, we were just talking, and somebody said Kayla in the chat, and then she came up.
Yeah.
And Thugger Daily post. Oh, somebody said Thugger Daily posted a transcript. Let's see. Yeah. So I wouldn't be surprised if a jury member might be in the chat. You never know now. Nothing surprised me. Let me see. I'm gonna go to Thugger Daily. Thugger.
All right. While you pulling that up, I'm gonna take me a 3-minute comfort break.
Oh yeah. Go ahead. Yeah. Yeah. Let me see. I don't know if that's the transcripts. I think that's just a motion that, unless I'm missing it. That's just a motion that Brian Steele just putting on a record about something that happened in May. Oh man, yeah. That looks like that's just a proffer. Thank you, JC, because I'm not seeing anything that's new. And that proffer is basically saying that the prosecutor said in front of the jury that Winfrey could possibly get a $250,000 car when he get out of jail. And the prosecutor said that in front of the jury because they're saying that $250,000 car is to buy Jimmy Winfrey's silence. And, and still basically said that that was improper to put in front of the jury that, he was promised a car. And so he basically putting everything in right. It ain't nothing new. This happened in May. And he's basically saying the judge should never have allowed that in because it was riddled with hearsay and all other type of error. So that's the document. See, Steve, you can't be posting stuff when the block is hot. We trying to get a transcript and he talking about No, I might pop over on Dear Woke Christian. He had emailed me earlier. If we have time. And I think Dear Woke Christian is going to be over there with Kenneth Williams. The judge is going to say the Odyssey system. No, he didn't knock it down. He didn't knock it. He went over there and found some wires and he pulled them all out. He probably said, the fuck you thought this was? Okay, she said, I ran over to Sylvia page to check and I saw, well, something, it was water. Hell, I don't know, but it wasn't that. You two be tripping. Oh, okay. Spilled coffee on him. Spilled the whole pot, didn't he? And for those that don't mind liking the video to circulate it, that'll be appreciated. Oh, man. And for those popping in, we were waiting on the transcripts. Somebody said we had an unofficial visit from one of Glanville's nephews hiding in the chat, allegedly. She said, I found it. Okay, she said between 6:30 and 7:30. Oh, okay. Well, I ain't gonna hold y'all too much longer. If we don't get the transcript, then we just jump back on. Talk to like AB has Weinstein on 2 at 6:30. Just check. Okay. Now, I don't remember seeing Adams, but he, I won't be surprised if he had other business to tend to. 20 likes to 300 if you don't mind. Yeah, if y'all don't mind giving us a 300 likes. Somebody said, that's why ain't nobody but you over there and 200 people because you ain't saying facts. And then we say, well, what's the facts?
Yeah.
What's the facts?
Bring the receipts.
Right.
Bring them.
What's the facts?
Yeah.
And then it disappeared. Hey, we ain't got no reason to lie on that man. The whole world watched him.
Yeah, this is not anything we've made up.
Right. What incentive we got to just make up something on this man Wade in Georgia that he didn't do for himself? Like Mr. Michael said, self-inflicted.
Self-inflicted. Both cases, self-inflicted.
Self-inflicted. They shot their own self in the foot.
Yeah.
They ain't need no help. You can't even. The defense can't even take credit because they did it to themselves.
Exactly. Yeah. I mean, you think about what Shard said a couple of hearings ago is that the state didn't prep any of these witnesses before they got on the stand or show them what they said before. And what they're doing is getting them on the stand and then trying to impeach their own witnesses. Where they do that at?
Right. Yeah.
Why you want to impeach your own
witness? Unless you went in there with the intention on them not remembering. So you can, because a lot of times lawyers will say, okay, my client or the witness don't remember. So now I get to bring in all this treasure trove of evidence to refresh their memory. And they were like, hold on. You can't bring in all of that just because they don't remember one thing.
Yeah, and this is not like it happened yesterday. It's happened 2015, 13, 14.
Right.
Yeah, these are not recent events.
I had a trial before where the DA only wanted to play the first few minutes of a body cam. And the body cam was there near 2 hours long. And I said, well, this is a new one. I told the jury, I never seen a prosecutor only want to show you certain portions.
Yeah.
If they want the truth to come out, show the whole thing.
Simple.
Especially when my clients facing life in prison, show the whole thing.
Oh no, yeah, you won't show it twice.
Right. Oh, you better know. I played it so much. I wore the judge out.
Yeah.
The judge said, "Haven't we seen this before?"
No.
No, this a different angle. That was such and such body cam. Now we on somebody else's body cam.
Yeah, we want to make sure that they don't miss nothing. Every vantage
Man.
point that's possible.
That jury came back with a not guilty so quick, and then the state looking crazy in the face. That's what you get trying to hide stuff.
No, we want to
Play
see the full treasure trove.
Right, right, the whole thing. Play the tape. Yeah.
But help me out, then. Help all of us out. Why would you want to play what Woody said in bits and pieces, knowing that he's not a good witness, or that he may have been trying to just tell them, even on the previous interviews, that he was just trying to do what he could to get out of jail? Obviously, it never worked, because I don't think they took any of his information seriously to ever go put anybody in jail.
Right, and from my understanding, I'm trying to figure out where let me see, she said drop one be at 7. Oh, okay. We need your ETA. Oh, yeah. Yeah, I think I might go to Dear Woke Christian. I believe he's gonna be there, as well as Kenneth Williams, and they're going to discuss more of the case. So I might pop in there briefly to show my face, speak. We've been trying to link up for the longest, but I think this would be a good time, since we have nothing else to do. The trial is stalled, and we've been trying to make it happen forever. Oh, sorry. Can you repeat it one more time? I got sidetracked reading. Did you ask me something specifically?
No, I was actually about witness as a Woody. I mean, witness as a Woody as a witness.
Long day.
Woody as a witness of Mr. Kenneth Copeland. I mean, if you didn't believe him in 2015, why are you believing him now?
Right, and I think they're trying to do what most prosecutors or most any attorney would do. They're trying to pick the good parts that help their case and leave out the bad.
Okay.
And that's what they're trying to do. Go through and cherry pick. Is this the link to the transcript? Let me see if I can. I don't think I can copy that.
That's the Trump hush money trial.
Oh, okay. Trump. Okay. Yeah.
Yeah, Trish, a Trump fan.
Oh yeah.
Trump.
Trump transcript.
Yeah, that one's gonna get appealed as well. I mean, you may, however you feel about Trump, I mean, that trial is a long way from being over.
Right, and the thing, it might get appealed on because they brought in so much stuff in that trial about, so much stuff that's irrelevant.
Exactly.
About what he was doing in the room and what was he in his underwear, like all that stuff just to inflame the jury.
Yeah. See, and there has to be a limitation to certain things.
Right, and that's why Harvey Weinstein's case was threw out, because they said y'all brought in way too much. Judge, you let the floodgates stay open, and now it affected the trial. So that could be an issue as well in Trump's case, that they may have to start all over again.
Well, in your state,
Texas, yes, sir.
Of Texas, yeah. The Enron trial, one of those guys, the second in command, they took time off his sentence because they felt like the prosecutor left out some information and misled the court and the jury. So he got, 10, 12 years knocked off his sentence.
Right.
He didn't do as much time as they thought he would.
And sometimes prosecutors go overboard. Like, my thing is, why lie when the truth would do?
Exactly.
Them people at Enron stole sugar out of cake. They robbed them people blind.
Yeah, you didn't need to bring out.
Right, you didn't need to lie. You need to make up nothing.
Yeah.
The story enough was good as it is, as it was. That's how some people do. They'll call and tell you a story. They add more facts. You ain't got to add more facts.
Yeah.
The breaking news by itself is good enough.
And you will notice a lot of those high-profile trials like that, as long as no violence is involved, most of the time they get overturned.
Oh yeah, for sure. Yeah. I mean, and they got the top dollar lawyers that
Exactly.
can
Yeah.
these top dollar appeals attorneys, and you don't know who these attorneys know. And we got to remember, our judges in most states are elected.
Mm-hmm.
You want to keep your job. You know, you want to make sure that you're not going against the grain.
Yeah, you're not the donors.
Right, the donors. Because
Yeah.
the donors send such and such lawyers, and we're not saying that all judges are like this. Some judges gonna stand on principle whether they are reelected or not.
Mm-hmm.
And I believe that's why when federal judges came about, when they were creating the system, they said federal judges needed appointment for life, not because they so good, but so they don't have to have their opinion swayed based on pressure or which way they vote.
Yeah.
Federal. I'm here for life, so you can't fire me, so I can do the right thing. So I think that's why the appointments for life was originally a thing, as well as the Supreme Court, because they federal judges too.
Well, that notion has been thrown out the window now.
Now they said, hold on, life is longer than we thought it was.
Yeah.
And we got to remember, life now may be longer than it was when, way back when. People weren't living as long.
Yeah.
Now they literally are dying in office.
Yeah.
They get these good jobs and they would literally die at the desk. You got to drag them out and they don't want to let go. So,
and we're seeing where politics is definitely playing a role right today, because you can see with some of the rulings they're making, it's all political. It's down party lines. Whoever appointed me, that's the side I vote for.
Right. And pretty much. And then if you kind of look at it, most of the presidents, they pick people whose ideas are in line with their own. So it's not uncommon for a Republican president to pick a Republican judge. And then when that judge get into office, they have Republican views.
Exactly.
I mean, that's the reason they were picked in the first place. So, I mean, that's not really uncommon. I mean, they get somebody that think like them.
And see, we wish Thurgood Marshall would have retired maybe 2 to 3 years later than he did, because when he retired, that's when we got the Clarence Thomas of the world.
Right. And that goes to, show that we don't know when our time is up.
Yeah, Ruth, she said Ginsburg. She held on too long. Yeah.
Right. When Obama
if she would have retired under Obama, we probably wouldn't have got one of these other Trump judges right now.
And they were saying that for the longest. I believe Obama had, offered. I don't know how you offer somebody to retire, but basically they were saying, "Hey, get out." But in her mind, she probably thought Hillary Clinton was going to win it. She had a few more years, and I think she right before the election. Yeah. So now that seat could be lost for generations.
Yeah, 30 years or more, if not longer.
It may be longer because that person, if it's not an accident, the next person might live 50 years.
McKinney?
Oh, what'd she say? Miss Sylvia stated the transcripts have not been released because Miss Love, of course, Miss Love filed a motion earlier, which is causing a holdup of the transcript being released. I should have known.
I told you that earlier. I told you that. I said Love is
Love.
I told you
that Love in the back room working.
Yep, I told you that earlier.
See, so my thing is, what's in that transcript, Love, you don't want us to see?
Well, ain't no love in that transcript.
It ain't no love. Come on.
I told you that earlier. I say ain't no way Love going out without a fight.
Love is holding that transcript.
Yeah, Miss Melody, we are on it.
See, my thing is with the judge. The judge saying that if you file a motion, the motion got to go through the court's office and it got to get to his desk. By the time Love had a chance to do all that, I would have already had it released.
Yeah.
It would have been too late.
Yeah.
But she didn't win and called up there or ran. Like I said, she almost broke an ankle trying to run to that Judge Chambers to tell him, don't you release that transcript. Don't you do it.
Worse than I have been.
Don't you do it. She probably, and the judge probably shook. She probably said, you released that, we all going down. The hell wrong with you releasing the transcript without talking to me first? So now we're not gonna get the transcript. Golly.
I figured that.
My thing is, why we can't get it directly from Ms. Weaver? She was handing out other portions of the transcript to Ms. Hilton. Because I know the DA Hilton was reading back some of the transcript directly from the court reporter.
Yeah, exactly. Yeah.
Edo said they all in cahoots, being in cahoots.
Gonna stay in cahoots as
They
long
gonna
as
stay in cahoots,
they
right?
have no choice at this point. They have no other option but to be in cahoots with each other.
Now the thing is, are they gonna talk, or are they gonna all stay strong? So they ain't gonna get no RICO put on there. They gonna all stay strong.
Yeah, they're gonna be quiet.
Somebody said, Ron Barnes, I knew it. She had to be involved.
I knew that early on. I said that early on in the cast. I was like, loved and tried something at this point. She want to make sure that this doesn't get out. That sounds about right.
I should have known why I'm going to switch up this saying. It actually goes a different way. But I'm going to say it like this. While the defense attorneys are sleeping, the prosecution is creeping.
Yeah.
And they in there. In that back room, see, we all wonder where Love was. She in the back room working behind the scenes.
Yeah.
She working hard now. Thank you, Lav.
And see, we all got too comfortable thinking that they was coming. So
it was coming.
Everybody let their guard down.
Yeah.
Like Steele was like, okay, they're gonna release it at some point.
Right. I mean, all she doing is delaying the inevitable. It's gonna come out.
Yeah.
It's gonna come out. They say if it don't come out in the wash, it's gonna come out in the rinse. I jumped out the window earlier, said it. Come on. Yeah, I mean, she stalling. I don't know what she's stalling for.
Yeah, like you say, she delaying the inevitable.
She delaying it. It's gonna come out.
They say pride goes before the fall.
Oh,
yeah. I hope it goes.
It's gonna be a hard fall. She's not in the chair. If it's what Glanville stated, nothing, then why? I'm just saying he stated case law to support his thought process. You're right. If it's nothing in the transcript, and we had a guy that came over here, maybe one of Glanville's nephews allegedly. If there's nothing in them, the nephew said they got 3 cases.
From a different millennium.
Right. Y'all got 3 cases, and we ain't got 3 lines of what's in the transcript. 3 sentences. Somebody said when a mistrial, Mr. Don from California, when a mistrial is declared, it will forever be sealed. Oh no, we getting that. We gonna get that, and we gotta charge. If we gotta charge into Odyssey, which is the e-file portal. We gonna get that. Somebody gonna get it.
But is there a path forward, from your opinion right now? Is there a path forward for this case to go on?
And it's present
legally, from a legal standpoint, strictly from a legal standpoint.
I don't think so, but I hope it's. I just hope that it can. If it's dismissed outright, where she won't be able to get a chance to do it again. Okay. I mean, she shouldn't get a chance. I mean, when you drop the ball, you fumble the bag this hard, Fonnie Willis and her team shouldn't be able to bring this case again and have these men in jail another 2 years, another 4 years. I mean, that's insane. And then they're not even on bond. So I think we can at least start by giving them bond first.
But this trial with Glanville can't go on, though.
I don't see it. Because in my mind, I'm kind of torn. I kind of want him to stay because if he stays, we get a not guilty from the jury. It's done forever.
Okay.
But if he's kicked off the case and they have to start over, then we might be starting from scratch, and it'd be a whole new trial all over again.
So another judge can't just come on at this point and take over the trial.
I don't think they could because it's so much that had happened in this past year or two that the judge won't be caught up to speed.
Yeah, it's a lot.
I mean, they can try it if they want. Just bring another referee in and let's see what happens. It reminds me like a boxing match. When another referee come in, he's not gonna know that you done gave 10 warnings because his boxer was doing something against the rules. Yeah. He already had his 10 warnings. Don't come in and give another 10. and he been doing it the whole fight. I mean, it won't be right. I think we're gonna need a new judge. Thank you so much, Edo Flores, $12. He said the best channel for analysis. Salute. Thank you so much for that,
Mr. Flores. Thank you.
Yes,
This guy's brilliant.
She said I found. Thank you so much for that, and I'm glad you came. You really have helped out. You carried this day. I was hoping that you stuck around and you did. Thank you, Mr. Michael Daniels, for doing that so much. How do you do it? Oh, there we go. Look at COE. Capitalize on everything. How do you donate? You can just donate through the channel.
COE capitalize. Okay, COE.
COE.
Come live with us.
You can donate through the channel. Some people donate. Let me see if I got the banner. Some people donated through Cash App. Mr. I don't want to leave nobody out. I know Minister Fears gave $100 on the Cash App. That was so kind. And this is not required, not mandatory. Just for the people that ask. Because some of y'all email and y'all send comments. How can y'all do this or do that? And it's not mandatory. If you want to, you can.
Yeah. Miss Melody right here saying she was rooting for Glanville. Integrity. He thought he was a black seasoned judge.
Let me see where she at.
Right above Mr. COE.
Oh, COE. Okay, let me see. I was rooting for Glanville honestly and integrity as a black male seasoned judge. All right.
I don't know how to respond to that.
No, you don't have to give no $100. I'm just saying that's Minister Fears did. Yeah. That was just a shout out to him, and I'm shout out to Don Cato, Amy twice. Shout out to Amy, Miss Carol. Yeah, all y'all have been supporting it. It's not mandatory. If y'all could just like and subscribe, that'd be good enough. They're saying it's good enough for me. But yeah, that's where we're at. Let me see. Yeah, but sometimes they used to say back in the day, all skin folk ain't kin folk.
Yeah.
Just
we're not a monolith. I think people don't realize that.
Just because somebody look like you, that don't mean they have your same thoughts and morals and the way they vote. I mean, you have a lot of people now that's mad at Clarence Thomas. They saying that he's the opposite judge of Thurgood Marshall.
Oh yeah, he is.
Yeah. I did a lot of the ideas.
Nobody realized he was going to be this bad, though. Nobody thought Clarence Thomas was going to be this bad. I mean,
they ways, like I said, you put them in a room, you might say, okay, they live together, got the same skin, but their thought patterns, the way they were brought up, their ideas, everything.
Yeah, and Clarence Thomas is right here in Georgia. Everything. Clarence Thomas is from Georgia, right outside of Savannah.
Oh, I didn't know that.
Yeah. From Georgia.
And they say Clarence Thomas, he all on a yacht with a billionaire. Boy, what you doing on a yacht?
Yeah.
I don't care what political side you on. What you doing in the boat?
Yeah.
I mean,
Harlan somebody. I can't remember his last name.
Because my question would be, would you have been in that boat but for your position in the court?
Exactly, yeah.
And if that answer is no, then you don't need to be around that boat, because it can appear that the only reason they have you around is to influence you one way or the other.
Exactly, yeah. And it's just like it was on a Law and Order show years ago, and the prosecutors told Jack McCoy, the head prosecutor, the female that was there, she was like, the judges are politicians and rogues.
Oh yeah, they politicians, big time.
Yeah.
Judges, even here, they want to set bail on certain cases because they don't want the news to blast them. Let's say they set a bail on a repeat offender, and that repeat offender goes out and commits another crime. Mm-hmm. Then they're going to be all on the news down here. Such and such judge, they have a picture of the judge. Let this person out again while they were already on bond and they committed a new crime, and now somebody's hurt because of this judge.
Yeah.
So judges really consider that when lawyers like me are making arguments as to why our clients, should get a bond or should not, or some other issue before the court.
Yeah, it's just like nowadays, like every judge in Fulton County is a Fannie Willis judge. That's what everybody call them, a Fannie Willis. Yeah, so that's just something that, you know, people are going to do at this point. They're not going to care. They're going to associate them together. They work in the same courthouse. They hang out with the same people.
And I don't think.
Oh, she's saying Fucker Daily got the transcripts?
I think that's something different.
Okay.
Let me see. I think that's a proffer from Brian Steele. Let me see. Yeah, I think that's the proffer that he's filed. I don't think that's the actual transcript itself.
Yeah, Ron Barnes, you make a good point, brother.
Oh, thank you so much to COE. I definitely appreciate that. I was hoping that we could get you up, but you said, no, I'm gonna watch from the back. But hey, I definitely appreciate that. Y'all coming through with the support today. Yeah.
You see Ron Barnes?
Oh, Ron Barnes. Let's see. Granville couldn't get along with defense because they are not afraid to challenge him. Right.
Yeah.
And he got to remember, attorneys are powerful people as far as if they have something to say, especially when it comes to the rights of their clients, when their clients' lives are on the line, we gonna say it. We don't care if it hurts your feelings or it's taking up too much time, or you'd rather be, playing with your dog outside. These men's life are on the line, our lives. All of them are trying not to go to prison for the next 20 or so years.
Yeah, and with the murder cases in there, it could be life plus.
Right. So absolutely not. That
you need a pit bull.
Right.
Get in there, yeah.
So I think they should. All attorneys should challenge. And you don't got to be. When I say challenge doesn't mean disrespect.
Mm-hmm.
You don't got to be disrespectful to make your argument and get your point across on the record. And we said that earlier with Judge McAfee, the Trump trial judge in Georgia. He hasn't been rude, disrespectful, raising his voice.
Not one time.
But he's running his trial with some order.
Yeah.
I mean, he tell you, hey, you do that, you keep doing that, and I'm gonna do this.
Yeah. And he's another example to where if you wanted to say that politics were not involved in that, because he was appointed by a Republican governor to take someone's place who retired. So he wasn't elected until this year.
Which one?
McAfee, Judge McAfee.
Oh, okay. Right.
Yeah, someone retired and the governor of Georgia, Brian Kemp, appointed him.
Right. Okay.
And so if he really wanted to be political, he could have just said, I'm going to throw Miss Willis and the rest of her office off the case if he wanted to be political.
Right. And some people were saying that because he ran on the same election cycle as Fani, which is crazy. And, some people make the argument, well, maybe he didn't want to kick her off because, that might hurt his chance of a re-election. So he passed the buck down to the appellate court. He said, hey, it's an order of mendacity. I'm not going to kick her off. I can let the appeals court do it.
Yeah, and that was a smart move.
Right, real smart. Because at least he signed a certificate of review. He gave the lawyers permission to go to the appeals court. He said, hey, if I'm wrong, I can still keep my job, number one.
Yeah.
Because, he still got to feed his family. And then number two, I'm still leaving the avenue where the appeals court can kick her off.
Yeah.
And that way he can kill two birds with one stone. With one stone.
Yeah, he took the script.
And he definitely did that. Right now, he still got a job. He won his election.
Yep.
I mean, he won his primary, but I don't think he's challenging in the general election in November. And the door's still wide open for her to be removed from the appeals court.
Yeah, because at that point, you don't have any visceral toward him one way or another.
Right. He said, it wasn't me.
Yeah.
I let her stay.
Yeah.
They kicked her off.
Yeah.
And I mean, like you said, even if she does get kicked off, there's really nobody's fault.
But her.
But her, I mean, it's kind of like the biggest case of your career ever.
Yeah. Well, actually, she done gave Georgia these two big cases.
Right.
The Jeffery Williams trial
And the Trump
trial. And remember, she was a prosecutor on the cheating scandal, 10 years ago as well.
Right.
Yeah, the big Atlanta public school cheating scandal. She was the prosecutor on that.
See, it seems like she liked high-profile cases. Somebody says she's prosecuting somebody, Shirley Strawberry's husband. Like, I think that's like a reality TV person.
Yeah, that's the talk show host.
Right. So anything that's big name, she want a piece of. And like you said, she gave these cases to Georgia, and Georgia trying to give them right back.
Yeah.
The senators in Georgia like,
But see, the only difference on that trial is going to be, does that person have access to these same type of lawyers that Young Thug has and that Donald Trump and his guys have? That's the only difference between that other. That's the big difference.
Right. And in the Trump case, the caliber of lawyer in that courtroom is going to be completely different. And supposedly one of the best prosecutors they had, he got upset because Fonnie put DA Love in front of him.
Yeah.
So they said he left and took the file with him.
Yeah, I can't remember his name. I know exactly what you're talking about. I can't remember his name, though.
What was it? Yeah, was it? I don't want to say Doug. Was it Mathis? Yeah, what was that prosecutor that was coming to court all the time trying to keep the YSL member from getting a bond?
Yeah, Mr. COE, I want to challenge you on this last comment you made. The second crime lowest in the U.S. I don't think that's true. Matter of fact, I'm going to say I know that's not true. But you entitled to that opinion, but that's not a factual statement, brother.
Well, which one?
Where he's saying that Atlanta had this, that one right there, yeah.
Come on. Come on now.
Stop it. Yeah, come on, man.
I appreciate that. But come on now. I can't give you too far of a stretch.
Yeah.
Where is that? I can't give you too far of a stretch.
Yeah, don't go too far down.
The second lowest in the what?
Yeah, come on. And prosecutors don't bring crime down, just so people know that. It's policing that brings crime down or deter it. It's not prosecutors.
He said, Google it. Okay, I'm Googling it. And what are we comparing? I mean, because obviously, Fonnie doesn't control the whole state of Georgia. So are we comparing her county, Fulton County, to what?
Or the city of Atlanta. I mean,
the city of Atlanta to what?
Yeah, exactly. Yeah, I can't. Yeah, that's not true.
Right. She said COE, a different kind of troll, right? They'll give you a little change and still talk about you at the same time. Come on here. Let's see that. Google it.
Yeah, I don't even have to Google that. I know that's not true.
Somebody said, obviously, this is a Fonnie burner account. I was like, that's a stretch. I don't think they did this much stretching on the what they just had. Was it the USA Olympics? Is that what I've been seeing on TV? Or what's it called? They getting ready for the Olympics?
The Olympic trials.
The Olympic trial. There you go. Olympic trial. I don't think it was that much stretching in the whole Olympic trial. I ain't seen what's her name? Simone Biles do this much stretching.
No.
To say the second lowest in the whole U.S.
No.
In Atlanta.
No.
The Olympic trial. Thank you. It ain't that much stretching, I know.
Yeah, he's stretching. Yeah, that's a Trump stretch right there. That's one of them alternative facts.
He's at the second lowest in the U.S.
Can we say any city in Maine? Yeah, you're right. Yeah, see that. in the country. Yeah. We love you, Mr. Capitalize on everything. He capitalizing on the moment. We love him.
Oh yeah.
Yeah.
Well, I know. Yeah, that just sounds wild.
Yeah, we love him.
Yeah, that's something you ain't even got to look up. Like you said, hey, I lived in Georgia. I don't know, is it Kenny? How you say it? Kennesaw?
Yeah, Kennesaw, Georgia.
Kennesaw, Georgia, where all are entitled and mandated to have a gun. You can opt out, and they definitely have less crime than Fulton County. He meant U.S. and they not like us. Hold up. Let me go.
Yeah.
This is wild.
Yeah, I live in Georgia. I used to live in Atlanta. I moved down to Henry County, McDonough.
Yeah, shout out to Shakari and Noah. Yeah, I was saying ain't that much. There's local here. Russia is much bigger than Georgia. All right.
Oh,
But
yeah.
I mean, but certain stuff you just know.
Yeah, you just know.
You just know.
Yeah.
Yeah. if somebody just say, hey, the sky right now, is bright red, it turn red all across. You can kind of like, nah, it's been blue for how many years?
Yeah.
It was bright pink. Nah.
He said he's going to send the link. I mean, I guess he's going to correct us.
Okay, let's go. Okay, I'm going to send the link. Well, somebody saw the grass, it ain't green no more, y'all.
Yeah.
It's purple.
He said he has the link. I want to see this right here.
All right, let's go.
COE said he got the link for it. Wow.
Okay, I dropped the link. Now let Fonnie come up. Go away, Fonnie.
We have nothing against Miss Willis.
Right. And people say, "Oh yeah, you coming after, you attacking it." We only doing what what she put out.
Yeah.
It's self-inflicted. If you don't give it to us, we can't use it.
Letitia James, Attorney General of New York State, didn't hear anything about her during the whole Trump trial that she had.
Oh yeah.
Not a mumbling word. Nothing about Alvin Bragg. Nothing about Jack Smith. Hell, Jack Smith barely got photos out.
Hey, send it to my. Or you're trying to. I thought you were trying to come up. If you have a link to send me, it's not gonna let you put it in the chat. If you could send it to my email, and I can put it up on the screen, because I want to see where these numbers came from.
Yeah, I do too. Yeah, I'm curious.
And I'm gonna tell you, like the professors tell us, and you can't cite Wikipedia as a source because anybody can edit it. We need a reputable source.
Yeah, and your professor. When I had a professor who always said, "Who are they?" Don't say they said it. Tell us who they are.
Who they are, right? That's really important because you can get lost in all the days out there.
Them and they. Yeah, don't do that.
I sent the link. Okay.
Well, we're glad you stuck around, Mr. C.
Right. I thought he was gone for sure. Oh, you from the show me state? Come on, shout out to Missouri. I'm from Missouri. You have to show me.
Yeah, he
Come on here, Ron.
Yes.
Yeah.
You say AV7 is interviewing Doug Weinstein. Who is AV7?
She was she always she's the co-host for Lead Attorney.
Okay.
And Doug, Weinstein, he's one of the attorneys. So I'm guessing he's gonna probably talk about what the next steps would be.
But she's saying they interviewing him now. Are you able to pull that one up?
Let me see. Let me go to my phone and check. Let me see. Because I don't want them to. Yeah, I'll pull up a little bit of it. Hey, and for let me make this disclaimer for those who want to watch it. AD to the 7th. She got her own channel. Y'all can click off of here and y'all can go watch it over there. I'm gonna show a little bit of it over here, but I'm not trying to take away support from her over there. Y'all got that? Okay, because they quick to lie.
Oh, he stole it.
He stole it. He ain't giving her proper. Come on now. And they know I wouldn't do nothing like that anyway. It,
again and
No, Max,
rule on each one.
I'll tell you, like, there's so much work to be done. Max Shart has carried a lot of the weight of going through the transcripts and identifying that stuff, along with Brian Steele's team. So kudos to them for all that they have been doing. There's no way any of us, I think, could get through this trial without the other defense attorneys and all of us all working together. And we are, having been involved for 25 years or more in a lot of cases with multiple parties, multiple defendants, having attorneys that actually can work together, set egos aside, cooperate. It's a miracle to find a group that can do that. And I'm just blessed. We are all blessed to be working with each other and have a team that gets along so well together.
That's awesome. Yeah. And, we've also talked a lot over here about how uncommon it is with RICO cases. Like, we see them, but not as often. I know that is it's a challenge because you have so many defendants. There are other cases in the state of Georgia that have RICO attached to them. And we know that it can be a big resource. It can deplete resources from the government in a sense, right? Like, these are taxpayer dollars, things of the like, and it's got a lot of eyeballs on the case itself. And, I try to mention to them that usually it's one table against another table, but you guys are like a sea on one side. And we often mention how, even if it is an opportunity to approach the judge, and, sometimes we would have to look at things if the state is bringing something up for you guys to all talk to the judge. And there would be so many of you coming from the defense side. It's like a little army, but it's we mention how that is uncommon in the everyday courtroom.
Right. We try to, we have 6 defendants. We try not to send 6 attorneys up to the judge's bench when he needs us, just a couple of us. When that happens, though, I hope your viewers understand, your audience understands that we're all listening in when that's happening, including our client. So anything happening at the bench, we're all hearing. So we all have the opportunity to weigh in on everything. But unlike the state, I think we try to be efficient and move things along.
Yes. Yeah. Oh my goodness. Like, even these guys were sitting here with me for hours watching it. And I try to balance out my study schedule for the bar. And I'm like, okay, we can only do a few hours today because I really need that time to focus on other things. But it's really interesting because sometimes they are watching and they're just like, why is it taking so long? Why is this happening? Why weren't some of these things done during the discovery process or pre-trial? But it seems like some things are reactionary. Would you agree with that?
I'll give you an example. This issue of having to go through all the transcripts for Mr. Copeland and identify what should come in, what should not come in. Normally, that would be something that you would do before you have the jury seated. Yeah. But I guess the prosecution would say that they didn't expect. I mean, I don't know what they would say, but I guess they would say that they didn't expect Mr. Copeland to testify inconsistent with his.
That's a point.
By the way, I don't believe he testified inconsistent, but they maintain he testified inconsistent with his prior testimony, prior interviews. I don't believe he did, but they say he did.
So what they said essentially is they thought Woody was going to play ball to prosecutors. That's why they didn't go over all of these videos before trial, because they thought they didn't need them because Woody was going to play ball. But now Woody backtracking. Yep. So I guess that could be a reason why they didn't do the videos and edit them pre-trial.
Yeah, we talked about that a little bit earlier.
Yeah, we talked about it earlier.
Yeah, why?
Right, and then on top of that, the prosecutor, they don't want to show their hand. They don't want the other side. Ms. Love don't want to show nobody what evidence she might use. So that's another reason she might be, holding it close, holding her cards close.
But that wouldn't have came over in discovery?
Well, it would have came over in discovery, but if they said that, hey, we don't think we're gonna need to play it, then it wouldn't matter.
Okay.
But what she's saying now, since Woody's not cooperating, now we need to play it.
I got you.
And COE, you can't send any links through the chat. They won't pop up. It may pop up on your end, COE, but it's not popping up for us. You have to email them to me.
And so they're going to say, well, we didn't anticipate needing to bring in these interviews. I don't think they should come in right now.
Yeah, because it's essentially been, because it's essentially been the last 2 or 3 weeks we've been focused on this. Like, that's where we've been.
Yeah, because we've got, I don't know, a dozen hours of these interviews to go through, and it takes a long time.
Yeah, and we haven't touched the jail phone calls yet. It seems like that's coming.
Those aren't going to take as long. I think we can get through that pretty quickly.
Okay, got it. Because I think one of his interviews and the audio, does it sound different in the courtroom? Because from home, the audio of those interviews, okay. It's just like, what is happening? Like the audio is not the best. So we all suffer listening from home. I'm like, all right, guys, there's a headphones warning. Take them out for a second. So we often go through that. Shifting along to the implications of the trial, right? How do you see the decision that was made today impacting the dynamics of the trial? And do you anticipate any like broader implications in the next few weeks for any other defendants?
Well, I think the implications, and for what's going on right now with the recusal, all of that affects all the defendants the same. I think we're all impacted no matter what happens. So if the judge is recused, we'll all get a new judge. And then a decision will have to be made of what happens with the trial when we get that new judge. Does the new judge slide in and we try to rewind everything back to June the 12th? Because that's what the law requires. How do you rewind what the jury has heard? Can you rewind what the jury has heard? I would argue you probably can't do that. So do you have a mistrial? Well, we'll see how things go.
Wonderful. And then just to close, because I know we're kind of short on time here, but I want to be respectful of your time as well. Yeah, absolutely. What are the next steps specifically for your client, for Yak Gotti, for his legal journey, Diamante? How do you plan on building on this momentum and securing a favorable outcome for your client?
Okay, so what's going to happen next is some judge eventually is going to hear this recusal motion. I hope that they're going to be hearing it next week, ideally. I don't believe any judge in Fulton County can hear it. Wow. So I think it's going to eventually be moved to a judge outside of Fulton County, which could potentially delay things a little bit. But I'd still hope it would be heard next week. The judge does not have to, under the rules, does not have to have a hearing. The judge could just rule on the paperwork. But given the profile of this and the charges, I would imagine that any judge would want a hearing. So we'll have that hearing. We'll await the ruling of that judge. I wouldn't have filed a motion for recusal unless I thought one was merited. So we should, hopefully the judge will be recused, and then a new judge will be assigned to the case, and we'll see where things go.
Wonderful.
And I don't want to betray too much of future strategy because, again, there's a lot of this thing can fork.
Because DA Love is watching, trust me.
Yes.
So don't tell it all, Doug.
And we'll just have to see where things go. But I will tell people, we have a plan for every option that could happen. So we're ready to go no matter what happens.
That's good to hear.
He said they ready for whatever.
Yeah. Wow.
And we had Kayla on today to get her reaction after what had taken place today with the judge, because she had an active motion to quash. She was supposed to appear on July 3rd. So we had an opportunity to get her live reaction, and also hearing that the full transcript is going to be made available. That was news to a lot of folks. And then before I let you, yeah, exactly. So before I let you go, just because those are recent developments that came out today, what was your reaction when you heard that the full transcript would be available? Because Judge Glanville just really held on to it. And we even asked Kayla, when she wanted to be recused, he kept going back to the 10-day rule and speaking to Mr. Copeland about that while he was under the stand. So it seemed like everyone wanted Kayla to be excused except for Judge Glanville for some reason. So I'm just wondering, with that whole ordeal and the secret meeting that folks are calling it, but this ex parte meeting, and to finally be able to get a full transcript, not a redacted transcript. And, it just seemed like we were throwing the football around or kicking it around, kicking the can down the road, so to speak. What was your reaction when you heard that it would be full and unredacted?
Well, first of all, my reaction is that's exactly what we should get, because while the judge was saying there was alluding to privileged information in the transcript, I was racking my brain and wondering what I missed in law school that could possibly be privileged within that meeting. And I think some of the things that I said in my motions, there really couldn't be anything privileged in there. And I guess the judge came around to that today. So I'm thrilled to get it for a number of reasons. One, we should get it. Second, let's have some sunshine. If nothing wrong happened in there, if the judge is confident that there's nothing wrong, there shouldn't be any issue with releasing that transcript. If what I said in my affidavit is inaccurate, because it's just on information and belief, it's just based on what I was told. Let's see it. If I'm wrong, I'll say I'm wrong. But all I can go off of is what I've been told by my source. So I'm hoping the transcript is an accurate reflection of what happened in there. And if it is, we'll find out if I'm right, if I'm wrong. If I'm right, I think the judge should be recused. And let's let the transcript show what it shows.
Awesome. And Mr. Weinstein, before you go, I just have one quick question. This question comes from a viewer, and she's super important to me. So I just want to bring it up, and we can answer it together. Shout out to Anna P. She sends a $20 super. And Anna asks a question for when it's appropriate. What sort of appeals process, complaint, or action can attorneys take when the judge doesn't allow the attorney to get something on the record? I noticed Judge Glanville has done this a lot.
Like a proffer.
In most cases, the best that we can do is to make sure that there's a record created in the transcript of what we tried to get on the record as best we can, to do what we call proffering the information, which is putting it forth as an officer of the court of what we think this will be. That will get that into the record. And then, unfortunately, most of the time, we just have to wait for the appeals process to say that the judge made an error and not allowing us to get that onto the record. And if it goes back for another trial, that judge should let it in at that point. But most of the time, that's what we're limited to. Sometimes we can ask for a certificate of immediate review, but that's rarely granted, and there's few occasions where we can ask for that. So a lot of times we're just stuck with it and we make a record. And you'll hear Brian Steele say that a lot. I'll just need to make a record, Your Honor. Max will say, if I can just finish so I can make a record, Your Honor. And the prosecution will do the same thing. Got it.
Well, Mr. Weinstein, I appreciate your time today. Thank you so much for joining us. We love you over here. We're always rooting you on and cheering you on while you guys are in the courtroom. And we're like team defense at this point. So we love to see the right thing happen, and definitely advocates for
and Diamante is a great guy. He's innocent of these charges. I want to get him back out there so he can start making some more music and doing some more concerts and doing some more shows and doing what he loves and is great at, I think. So thank you all.
Thank you so much. Thanks again, and we'll see you soon.
Thank you.
All right, guys. Bye now.
All right, shout out to AV. And AV, she always supports this channel. I go over there, I support her channel. I also, and I'm not saying this to brag, but I did donate to Lead, AV, and Kayla this morning. So I don't want y'all to think I'm just using them. That's not the case. Never been the case. But since this happened live and we're on live, we might as well all watch it live. And we're entitled to do that under fair use. And if anybody ever has a problem with me showing their videos, you know, I'm not saying they would, but anybody, just let me know. I'll crop it out. We just watching it live because it's happening in real time. So I just want to put that on the record for anybody that they may want to go and run and tell something. Then you can run and tell that. So it could be fair to both sides. So you had something that you want to add, Mr. Michael?
No, sir.
Oh, okay. What you thought about it? What he said?
Well, I do have a question for you. That's what I was waiting on him to finish up.
Yeah, go ahead.
Yeah.
Yes, sir.
He mentioned that they have a alternative for each scenario that may come up. But who decides which county and which judge it would go to at that point?
Right. That's what's going to be tricky, because I'm assuming if he gives it to one judge in Fulton County and they recuse themselves, then all of the judges have to recuse themselves, or would they do it all in one group? They all get together and say, "I'm not going to do it. You know, it's too sticky. We all recuse," and then maybe on their own can send it to a neighboring county. In some counties, just by operation of law, sometimes you have counties that work more closely with others.
Yeah.
So if you're always doing business with a certain county, or y'all always switch cases, if you know they needed something recused, they send it to you. Then I don't see a big deal, and I really don't think. Amy, she did a really good job, you know, getting the questions, and it seems like Mr. Weinstein, you know, on the schedule, he probably got to make his rounds.
Yeah, he does.
He got to make his rounds. Somebody said that he may be over with Miss Sylvia. So yeah, he got a lot going on. Oh, or is that somebody else? Oh, Harvey, that's a different attorney. Which one is Harvey? Now, see, I had said Harvey earlier, and I had it all mixed up.
Yeah, you said Harvey Weinstein. Yeah.
But I thought it was a Harvey in the trial. Let me see, Harvey.
YSL Harvey.
Somebody said what?
Yeah, that's the guy. Coco said that's the guy I was referring to, the older guy that sits in the back.
Bruce Harvey. You right.
You
right.
Yeah.
So I crossed Harvey's name with the other lawyer's name, Weinstein, put them together, Harvey Weinstein. That's dangerous.
Yep.
Right now, they say, hey, oh yeah, I know Harvey. He always want to jump up and he say he want his case severed, but I don't think that's a good idea at this point.
You're not at this point, no.
Right.
We gotta stick together now.
You're right, don't sever nothing.
Yeah. But he's in the same boat. That kid that he's representing, he hasn't been involved in any of the proceedings so far. They haven't his name on anything that has come up. Not one single time has his name been mentioned.
You're right. I mean, like Martin Luther King once said, he said, we might have all came on different ships, but we in the same boat now.
We in the same boat now.
So, hey, y'all in the same boat. Do not, y'all stick together, shoulder to shoulder.
Yeah. Or as Malcolm would say, you know, just because if you're going down the wrong path, there's no reason to believe you're gonna make it to the right destination.
Right.
Yeah.
You sure right.
Yeah.
Let me see. He says, "Sent. I apologize. It is crime. Drop." Okay. I
still don't know if that's true or not either. That's a stretch.
She said, "You have like, girl, mix it all together. Mixing it all up. Mixing it all up." Told that man name like that, messed his name up. Brian, okay, is getting ready to read. Okay, breaking. AB is getting ready to read it. Oh yeah. That's just a proffer of something that happened in May. That's not of the transcript that we trying to get for today's purposes. But y'all could. See, they making gumbo. They mix it all together. And that's what they're doing with the trial. Yeah. They mixing everything together and they're trying to see what sticks.
I don't think they have nothing in the pot anymore.
He said ain't nothing in the pot.
The pot is empty.
He said the pot is empty, Coco.
Coco, we love you, but the pot is empty.
The honorable is empty.
What was that show? Had all the crooked cops on there. I can't think of the name of it now.
Somebody say pick one. Y'all seen that cop and went in there and stole that man money.
Oh, I saw that. Yeah.
Stole that man and tried to play like he did.
That was in Charlotte or North Carolina or somewhere.
Yeah, North Carolina.
Yeah.
Boy, no good. That man was on him too.
Forgot about the body cam?
Right. He said, I heard the pop. But I guess they get to doing so much wrongdoing. They forget they have cameras on. They don't know.
Yeah. So where does YSL? So if the YSL defense, he said that there's a possibility if there was a new judge, and he mentioned the fact that it get rewind to June 12th. What does he mean by that?
No, I think he's saying can we rewind back the evidence to June 12th? That's the last day the jurors was there.
Oh, really? Okay.
Since it's such a big gap.
Yes, huge.
Can we go back and piece it together? Or is it like, what's up, D? Is it like, it's too big of a gap, so that in of itself might be a mistrial.
Yeah. Wow.
So
now, does that come up under that fruit of the poisonous tree, or that's something completely different? That does apply to trials.
Right. That applies more so when if a police lie, or let's say they search your car without a warrant, they didn't have a reason to get into your car, lie on the affidavit to get that warrant, then anything they find in that car can be considered fruit of the poisonous tree and excluded from evidence.
Okay.
So that's more so of an evidence-based term, not in a situation we're dealing with right now.
Yeah, so everything that has happened between the time they initially asked for the recusal and mistrial, all of that stuff still comes in, or does it stop now? Or did it stop then? Like nothing that has happened after Steele asked for the recusal initially when he got held in contempt. What about all the testimony from that point up until now?
Well, I don't think that the testimony will be affected by him asking for the recusal.
Oh, it was? Okay.
Yeah, because the judge denied it. I mean, it's not the first time they asked for a recusal. So, yeah, everything is still going as normal. Sometimes we may ask for mistrials in the middle of trial, but it doesn't stop anything. It's just so unusual with this situation because they're actually accusing the judge of, doing something wrong. And I think they got a real good leg to stand on.
So this is going to be new case law regardless. At some point, end of this trial, it's going to be a lot of new case law.
Oh, yeah, big time. And I think that's why the appeals court and the Supreme Court is really trying to get some structure to make sure that other attorneys that may have this issue go through the proper channels first. And then come to us as a worst case scenario or the court of last resort when you have no other options. Yeah. Then you come to us.
Don't you think it was a good idea for them to file with the Supreme Court in order to get instruction on what to do going forward?
I mean, that could have. Some people say it was strategy. It wasn't a mistake by YC. It was just strategy. Mm-hmm. The only thing is, if the Supreme Court sat on this and more time went by before they replied, then it could have really turned into a disaster, which it might be now, because now the judge is sent it to another county. And first they send it to another judge inside the building. Mm-hmm. And if all those judges have a problem, then it goes to another county.
Wow. And
then if the other county doesn't, play ball or kick them off, then they got to go back to the Supreme Court. So this can be a wow. And that's why my only thing was, if there was a better way, cross everything out first. I was just basically saying, scratch everything off your checklist. Somebody said Jack told the judge he had enough. You know who Jack is, huh?
Who is Jack?
Jack is his service dog.
Oh, really?
Yeah, his name is Jack.
Okay.
Yeah, Jack ain't retired.
Yeah, Jack ain't nimble no more, is he?
Right.
Jack want to quit. Jack done quit.
Right. Jack can quit. Jack gonna jump over all this.
Wow.
I ain't gonna say the word.
But this trial has explored so many. It has realized so many people fears when it comes to the criminal justice system.
Right.
Yeah, it shows you so much.
And we on YouTube, we watching this, from the comfort of wherever we at, but we still got to remember it's real lives at stake.
Yeah.
And when lives are at stake, you don't cut any corners, and that's the issue with Glanville. See, we love you and cheering you on. She on there. See, we love you and cheering you on. She and their channel are clearly biased.
About Coco?
He probably talking about, I don't know. He's talking about AV. I don't know.
Oh, he talking about AV when she told Weinstein she was pro defense. Yeah, I think we all are at this point until we see otherwise.
Right, we all trying to
fairness standpoint.
Right, all right. I think so. Everybody trying to get to the bottom of it, and so far we haven't seen anything that the defense has done wrong that's so egregious to rise to the level of what the judge has done wrong.
Oh my God.
Somebody said somebody said the service dog need a service dog at this point. The service dog.
I'm not trying to be funny or anything, but so where does the judge walk the dog at? Like the dog has to go to the restroom at some point during the day.
I think when he take his comfort break, too, most of the time they say the dog sits under the bench.
Yeah. So where does he take him? Around the courthouse to use the restroom or something? That's what I'm wondering.
Oh yeah, I don't know if they got a back door or he got some doggy pads in that office in that chambers. I don't know.
Yeah, that must be what it is. Then, yeah.
All right, it just seems like it'd be crazy for him to just be walking in and outside.
Yes, yeah.
Yeah. But I definitely appreciate you coming in and working this thing out with me today.
Oh yeah.
And hopefully we can get you back in the future.
Oh yeah, I'm game.
Yeah, I definitely appreciate you hanging in there.
Oh yeah, I'm game.
And I don't know, when we're gonna go live again. I guess when we get some news, unless y'all just want to go live in the chat and just dry sit here with nothing to talk about.
No, I got some stuff on my email you. I want you to look over and you see if we want to do a couple of shows on it.
Okay, yeah, let's do that. Yeah.
I think if we can. It's enough material to do a whole week or two.
Okay, that'll work then. Yeah, if you want to talkthatlaw@gmail.com, that'll be good, and I'll take a look at it for sure.
Yeah.
And I might jump on Dear Woke Christian's channel. He asked me to stop by there. I think he's over there with Kenneth Williams. So so I might do that. I might go give me something to eat right quick though first. Before I file out this chair.
Well, find Kayla. We need to find Kayla.
Oh yeah, we're gonna find Kayla. We were trying to get her. We had reached out to her earlier, and she said she was still in court. And by the time she probably left court, she wore out and she's tired because she's been doing a lot today. Let me see. Oh, somebody said thank Coco said thank you, Michael. Yeah.
Thank you, Coco. You've been great today. I think she's talking about me. Is she?
Yeah, she's talking to you. Yeah.
I'm just messing with you.
Oh, okay. Yeah. Somebody said they finna go over to the Dalton meeting. Oh man. So the city council and Dalton having a meeting. That's the one they said the super mayor. They say she didn't ran off with the bag. She ran off with the city money.
Oh, did you say? Well, you need to check in Chattanooga, Tennessee police chief. Oh my God, crazy.
What they do?
Yeah, she lived in Fulton County, but she worked in Chattanooga, Tennessee, but was still voting and doing stuff in Fulton. It didn't make any sense.
So what happened? So it's been discovered.
They indicted her on like 17 counts, I believe.
Golly.
Yeah, crazy. I'm like, just change your address.
Yeah. That would have been easy, especially, some people say that we got to go through a little bit more. We got to keep our ducks in a row.
Stay clean, especially on something as simple as that.
Right. Because they looking for something now.
Yeah, they found it too. They indicted her. She resigned one day and they indicted her the next.
Wow.
Chattanooga, Tennessee.
I'm sorry, yeah. But I'll be looking forward to your emails.
Okay, yeah, I'll send it
and
over.
I'll take a look at it. Definitely appreciate it, and then I'll let you know. Oh, he said, look at the email right quick. Let me see.
Oh, well, one other question. How much lead-in time, if the transcripts drop, how much lead-in time you're going to need before you go live once you get them?
What do you mean?
When the transcripts from the Woody
meeting. Man, as soon as I get them, I'm gonna be ready. I'm gonna be running so fast to get back to this computer right here. They ain't gonna be able to stop me.
Okay.
I'm gonna be slipping and sliding trying to get it in here to this computer. Yeah, I'm gonna be ready.
Yeah, Coco, I want you to come back. You and Miss Simone and Miss LaShawn, all of you all.
Oh yeah, come on back. Let me see if I can find
Honorable Miss Yvette, come into the video chat with us.
Let me see. Where is it at? He said check his email. I guess he wants to see before he get
He said, I bet nothing anyone here that will happen to the judge. I almost agree with you, Mr. COE. It's hard to imagine the judge getting kicked this late in the game.
Let me see if I can share this real quick. This is what he sent over, COE. And I'll go through it real quick. If I can find what link. Oh, there you go. Verify our claims in the Fannie Willis campaign true. An ad by Willis said that homicides are down 21% and violent crime is down 25%. Okay. So she's facing a Republican challenger. She said crime is down. She said we have the third largest crime drop in America. That's what she said.
That's what she said.
People deserve to live free of crime. Yeah, that's what she said. Question one, are homicides down 21%? True, yes, there was a 21% drop in homicides in Atlanta. The police chief said homicides are down 21%, shootings are down 15%, and the number of people that were shot are down 23%. Okay, and then they got some data here. So we can verify that, yes, there was a 21% drop in homicide, which is good.
Yeah, that's great.
I mean, that's great that, less people are getting, killed in Georgia.
You want to be 100%. Yeah.
Right. You want right. And, if you got 1,000 and that was, is 950, I mean, you don't want to be doing a parade around the building.
No.
You want to keep, any drop is better, but you don't want to just be parading like it's something. Is violent crime down more than 25%? False.
Yeah.
No, violent crime is not down more than 25%. The DOJ characterizes these 4 crimes as violent crimes. According to 2022-2023, the report shows a 50% drop and a 15% in SAs, I say it like that, 50% decrease in both robberies. Compared to the totals from the year before, that would amount to a 16.8% drop. So we can verify that it's not down 25%. Question 3, have we seen the third largest crime drop in America? False.
False.
This is what you sent me, COE. No, Atlanta did not see the third largest drop. This is what you sent me. I'm only reading what you sent me.
But I'm glad he was man enough to send over that
right.
to correct himself.
Right.
Yeah, he corrected his own self because I knew that went through.
I had the A's. Okay. Yeah. All right. Let me see. I think he real quick. Let me see. He had one more. Oh, where'd it go? This is another article he shared, but it doesn't. This is just Fonnie saying her own stuff. I mean, that's just something she said. Fulton County said it's down 50, and this was in 2023. And politicians, they are allowed to To lie, right?
That's simple, yeah. Just put it plainly.
Yeah, right. Old fashioned, good old fashioned lie.
Yes, we saw that on the debate.
Right. I mean, they, a little puffery. Just
That's a whole hot air balloon, man.
right. And this is another one he sent. His last one he sent. Atlanta officials say violent crime. 17%.
Yeah, that's feasible. 17%. That's feasible.
Right. Right. Yeah, 17%. And my thing is, and it might, and I think that 17% is comparing Atlanta to Atlanta.
Exactly. Yeah.
I don't think it's comparing it to the the country.
Yeah.
It's saying it's down 17% from the previous year. So yeah.
Yeah, like you said, if you got 100 robberies and it go down to 83, that's still bad.
That's still bad.
Still bad.
Right. So when your number's so high and they go down,
it don't really make a difference.
Right. Yeah. It don't make. It's not like you doing so good. It's just people doing the right thing now. No, not that. No, that was done. Wait, what was done? What part was done? I showed all three of them.
You got another one? I mean, but either way,
Know that EA. What's talking about? Oh, maybe he's talking about something in the chat. Maybe they ain't had nothing to do with me. Because I know he sent me 3 links in the email, and I clicked on each one of them.
Yeah, and Coco has a point too, and there's a backlog because they just going strictly off convictions. So there's still a backlog of people still in jail waiting to be sentenced or released at this point. So yeah, them numbers going to be skewed because of the pandemic. Right. So yeah, so those numbers are accurate. But the link he did send us, it did show that 2 out of the 3 things were false. Yeah. COE, we love you, brother. He said, and the entire time Thug will be in jail. Yeah, he will be. Well, let's another judge take over. Well, let me ask you this right here before we go then. So would it be better to keep Glanville with this clown show and just try to go ahead and go for the not guilty? Not guilty. I think so. I mean, keep him. Because there's so much in the record that he's done wrong, you still can appeal it after the trial is over. So you essentially get 2 bites at the apple. Keep him, try to get for the not guilty, and if that don't work after the trial is over, appeal it. There's so many issues you can appeal on. I mean, the secret meeting is a big one. Then win that, then you can have another bite at the apple with a different judge. Yeah. But right. But the only thing I don't want is for them to start all the way over. Yeah. Even though they may make for some good content for YouTube, it's just gonna be they're gonna another 10-month jury selection. Right, that's a lot. That's a long time, man. They damn near interviewed everybody in the country. Right. I mean the county. I'm sorry, the county. Thank you, Ms. Deborah, for hanging in there with us all day. Yeah. Well, okay. Well, it's been nice going through all the breakdown with you. Yes, sir. And hopefully we can come back, and I'll be looking out for your emails. And if you get the transcripts, let me know. Yeah, I'm gonna be on the lookout for them. Okay, yeah, thank you. And I'm gonna jump on as soon as possible. Adrian Love, man, she's gonna play transcript blocker. She's not. She gonna play transcript blocker. Right? We need somebody that's gonna. We need a workaround. Somebody that can get them for us. Any proceeding must be filed. Okay, she said, I am not sure, to be honest, but in any proceeding, motion can be filed to stay due to almost anything. Yeah, you can ask the court. Yeah, it's a whole different. Okay, well, answer this for us then before we go. If Love has the transcripts, she's asking for some kind of injunction. Would it go back to Glanville to release them, or would it be to somebody else? What you mean, injunction from who? If Love filed an injunction not to release the transcripts, and Steele and his crew decide, okay, we want the transcripts released, what judge hears that? Well, right now, I'll say it's still in Glanville's court. Okay. Until it's not. So right now, it still hasn't been officially assigned to anyone. Maybe it's still spinning in the wheel. Okay. But until he don't have the case, he has it. So I think he still have a jurisdiction over this case.
until the new judge say otherwise. Hopefully you read the email I sent. I read them. Oh, you said read it. I read the links. Yeah, I went through all. Yeah. Oh yeah, I go back and read each one. Yeah, for the sake of time, I just went through the ones where it said it was verified or unverified. Yeah. Okay. All right. You had any final thoughts you want to add?
No, sir. I just want
Okay.
to thank you, Ms. Melody, and thank everybody for tuning in to you today, man. You did a hell of a job.
Oh yeah, thank you so much. And I plan on coming back soon as we can get something, that's worthy. Stream worthy.
And hopefully you'll let me back on to review them with you.
Oh yeah, I wouldn't mind. I wouldn't mind at all. You've been such a great help today, pushing us through. So yeah, I wouldn't mind doing that at all. Email me for sure. So
I got something for you if you want it. It's landmine, but it depends on if you want it to explode or not.
I will send you also. I don't know if your email goes straight to your phone, but soon as the transcript, I email you right away. Like, hey, you ready?
Oh yeah, I got you.
We can just jump on.
All right.
Okay. All right. Sounds good. Thanks a lot. I'll catch you on the next one.
All right.
All right, y'all. Hold on right quick. Let me see. I'm starting to sway. Hold on right quick, y'all. Let me see if I can pull up this last link. Oh, let me see. So I was trying to go to Thugger Daily one more time to check. Thugger. No, I don't see any. If y'all get the the transcript, let me know and I'll jump back on. Coco, I emailed them links. What are you talking about? Are you YSL? Coco, you said, are you YSL? But yeah, but thank y'all again for tuning in, and those who want to, y'all don't mind liking the video on your way out and subscribing if y'all want to come back. Thank you again to Edo Floors, Miss Carol, Amy twice. Shout out to Amy. Amy supporting Mr. Don as well, always supporting. All the way from Cali, California. And then also let me not and also Minister Fears. Thank you again. That was kind of you. $100 on a cash out. And then also COE. Shout out to COE and all the other people that subscribe, like all that good stuff. And hopefully I can come back as soon as we get the transcript. I'll be back. And if that's tonight, guess what? I'm coming back tonight. I might hop over on Dear Christian's channel if I can give me something to eat. I gotta get some to eat right quick. Somebody say go get some hot dogs. She said go get some hot dogs. Is that the Honorable? Somebody said a hot link. I can't even find it. Where'd it go? Oh yeah, I will send you a video to stream. Get your hot dogs. Y'all are funny. He sent you $10 to get you the campaign false info. All right, y'all. I'll see y'all on the next one. Just check. It's not different. Yeah, it's not different, Mr. Bourne. It was same old. I thought it was something different. But before I go, let me get my disclaimer. She's just playing. No legal advice intended. I'm a lawyer. but I'm not your lawyer. I'm just here to talk that law. All right, y'all. I'll see y'all on the next one. Thank y'all so much for stopping by and supporting the channel. Let's go.